of Legal Studies, who has clubbed all of us to the one-day workshop on right to privacy, its dimension and limits. I deem it a moment of great privilege and honor to extend a hearty welcome to our honorable dignitaries, distinguished guests, respected principal sir, coordinators, faculty and students of various institutions, fellow faculties and my dear students, on behalf of Karnataka Institute for Law and Parliamentary Reforms and RVLS. As it is a mark of an undying tradition to invoke the Almighty at the beginning of an event, I call upon Ms. Vaishnavi and Ms. Manushri, first year students of RVLS, to grace the occasion with the invocation song.
Gajavadana beduve, Gajavadana beduve, Gauri tanaya Trijagavanditane, Srujanara porevane, Gajavadana beduve. Pashankushadhara parama pavitra, Mushika vahana munijana prema. Pashankushadhara parama pavitra, Mushika vahana munijana prema. Gajavadana beduve, Gauri tanaya Trijagavanditane, Srujanara porevane, Gajavadana beduve. Modadi ninnaya padava toro, Sadhu vanditane ಆದರದಿಂದಲಿ. ಮೋದದಿ ನಿನ್ನಯ ಪಾದವ ತೋರೋ, ಸಾಧು ವಂದಿತನೆ ಆದರದಿಂದಲಿ. ಸರಸಿ ಜನಾಭಶ್ರೀ, ಸರಸಿ ಜನಾಭಶ್ರೀ ಪುರಂದರ ವಿಠಲನ ನಿರತ ನೆನೆಯುವಂತೆ ದಯ ಮಾಡೋ. ಸರಸಿ ಜನಾಭಶ್ರೀ ಪುರಂದರ ವಿಠಲನ ನಿರತ ನೆನೆಯುವಂತೆ ದಯ ಮಾಡೋ. ಗಜವದನ ಬೇಡುವೆ, ಗೌರಿ ತನಯ ತ್ರಿಜಗವಂದಿತನೆ, ಸೃಜನರ ಪೊರೆವನೆ. ಗಜವದನ 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 ಬೇಡುವೆ.
Thank you, Vaishnavi and Manushri, for such a soulful rendering. Privacy is an essential human need. Although the concept of privacy has a certain abstract quality to it that makes it difficult to define. Instinctively, humans need to know that they can keep some things secret from others. The right to have secrets is so embedded in human nature that it would be very difficult to imagine satisfying human interactions without the ability to keep certain things secret from each other, to lead lives unmonitored by others. The notion of individual privacy also plays an important role in individuals' relationship with government. When one thinks about the absence of individual privacy, the world described by George Orwell in his famous novel 1984 comes into the mind. In that scary world, citizens are continuously monitored by a totalitarian government which surrounds them with video image screens filled with propaganda and posters bearing the warning, Big Brother is watching you. The thought of living in a world like that makes people shiver. Absent extraordinary circumstances, the need for humans to have a certain degree of privacy is natural. Perhaps as a result of that intrinsic need, privacy as a concept has been recognized in a social as well as a legal sense in most cultures from time immemorial. Eventually, the legal recognition of the right to privacy as an independent right has come to be grounded in individual freedom and personal autonomy. Today, whether the right to privacy is a human right with universal qualities that deserves universal recognition and protection is a question that more individuals, if asked, would instinctively answer in the affirmative. The debate begins in trying to define the scope of privacy that ought to be protected and the legal protection that governments must afford in order to protect privacy. Keeping this in view, Kilpar and RVLS has organized this workshop on right to privacy, its dimension and limitations, to provide a forum to discuss on various dimensions relating to right to privacy, which is the need of the hour. I am optimistic that all participants will acquire good understandings about the concept of privacy. To welcome is to show honor. To welcome is to establish integrity. I invite our respected principal, Professor Dr. Anjaney Reddy KR, to deliver the welcome address. Over to you, sir.
Thank you. Good morning, one and all who are present here. It's my privilege and honor to welcome you for this one-day workshop on right to privacy, its dimension and limits, organized by RV Institute of Legal Studies in association with Karnataka Institute for Law and Parliamentary Reform. It's called as Kilpar, Bangalore. First and foremost, I would like to welcome today's chief guest, Honorable Mr. Justice Ram Mohan Reddy, former Judge, High Court of Karnataka, Bangalore. Above all, Mr. Justice is a fine jurist known for his sound juristic thinking. Sir, as your contribution to legal fraternity has been tremendous. We are privileged to have you with us. When we approached and invited him, inauguration of the workshop, sir, in spite of his busy schedule, he has accepted our invitation. I would like to welcome him on behalf of Kilpar, RVLS and RSST. I request today's president of the program, Sri M.K. Dattaraj sir, to welcome by giving him a bouquet. I would like to welcome today's keynote speaker, Sri K. Dwaraknath Babu, Director Kilpa, and he is also an instrumental person for organizing this one-day workshop. I would like to welcome him on behalf of RSST and RVILS, and I request faculty member Mr. Arun S. to hand over a bouquet to him. I would like to welcome today's guest of honor and resource person, Dr. C.S. Patil, Professor of Law, Head Research Center for Democracy and Constitutional Government, Karnataka State Law University, Hubballi, and also our Institute Governing Council member, over and all, a great professor and my mentor. Sir, I express my sincere gratitude for accepting our invitation and here, in spite of your busy schedule, I welcome you once again, sir, on behalf of Kilpar, RVLS and RSST. I request faculty member Ms. Maitra Badigi to hand over a bouquet to him. I would like to welcome today's guest of honor, resource person, Dr. G.R. Jagadish sir, Professor of Law and Principal, National College of Law, Shivamogga, and a great professor and a very good administrator. Sir, I express my sincere gratitude for accepting our invitation and be with us. I welcome you once again, sir, on behalf of Kilpar, RVLS and RSST. I request our administrative officer, Mr. Rao, to hand over a bouquet to him. I would like to welcome Dr. Revaya Vadia, Research Head, Kilpar. He is one who has extended all his support on behalf of Kilpar to organize the second workshop in our institution. I welcome you, sir, for this workshop. I would request you, our faculty member, Mr. Bharat, to hand over a bouquet. I would like to welcome our today's president of the program, Sri M.K. Dattaraj, trustee, RSST, member, governing council, RVLS. Is a continuous support to organize this workshop and other activities in the institute. Now I call upon our faculty member, Mr. Arpita, to hand over a bouquet to him. I would like to welcome faculty members, students, research scholars, paper presenters of various law colleges, and the special thanks to our coordinators of today's program, Mr. Arun and Bhavna C. I also welcome all the faculty members, administrative staff, and my dear students. Thank you one and all.
Thank you, sir. Sir is a driving force of knowledge power of RVLS. I heartily welcome you also to the session, sir. I request Ms. Sudha Chellappa, Assistant Professor of Management of RVLS, to present the bouquet as a token of respect. Light fade away darkness. Light symbolize knowledge and wisdom free will. With the hope that the brightness of education overcomes the darkness of divisions, injustice and aggression in the society and lead us to the growth, equality and liberty, to solemnize this special invitation, I would like to entreat a honorable chief guest, Mr. Justice Ram Mohan Reddy, along with other dignitaries to illuminate the lamp lighting. I now call upon Revaya Sir, Research Head Kelpa, to deliver Prastavika Nudi to the gathering. Over to you, sir.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ ಹಾಗೂ RV ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಲೀಗಲ್ ಸ್ಟಡೀಸ್ ಬೆಂಗಳೂರು, ಈ ಎರಡು ಸಂಸ್ಥೆಗಳ ಸಹಯೋಗದಲ್ಲಿ ಖಾಸಗಿತನದ ಹಕ್ಕುಗಳು, ಇದರ ಆಯಾಮಗಳು ಮತ್ತು ಇತಿಮಿತಿಗಳು ಈ ಕಾರ್ಯಾಗಾರವನ್ನು ಜ್ಯೋತಿ ಬೆಳಗಿಸುವುದರ ಮೂಲಕ ಉದ್ಘಾಟನೆ ಮಾಡಿರುವ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ವಿಶ್ರಾಂತ ನ್ಯಾಯಮೂರ್ತಿಗಳಾಗಿರ್ತಕ್ಕಂಥ ಸನ್ಮಾನ್ಯ ಶ್ರೀ ರಾಮಮೋಹನ್ ರೆಡ್ಡಿ ಸರ್ ಅವರೇ, ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಕೀನೋಟ್ ಅಡ್ರೆಸ್ ಮಾಡಲಿರುವ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಸಂಸದೀಯ ವ್ಯವಹಾರಗಳ ಇಲಾಖೆಯ ಕಾರ್ಯದರ್ಶಿಗಳು ಆಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿ ಈಗ ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆಯ ನಿರ್ದೇಶಕರಾಗಿರುವ ಶ್ರೀ ಕೆ ದೊರಕಾಂತ್ ಬಾಬು ಸರ್ ಅವರೇ, ಇಂದಿನ ಈ ಕಾರ್ಯಕ್ರಮದ ಘನ ಅಧ್ಯಕ್ಷತೆ ವಹಿಸಿಕೊಂಡಿರ್ತಕ್ಕಂಥ ದತ್ತರಾಜ್ ಸರ್ ಅವರೇ, ನಮಗೆ ಮತ್ತು ತಮಗೆಲ್ಲರಿಗೂ ಖಾಸಗಿತನದ ಹಕ್ಕುಗಳು, ಅದರ ಇತಿಮಿತಿಗಳ ಕುರಿತಾಗಿ ವಿವಿಧ ಆಯಾಮಗಳಲ್ಲಿ ಮಾತನಾಡಲಿರುವ ಪ್ರೊಫೆಸರ್ CS ಪಾಟೀಲ್ ಸರ್ ಅವರೇ ಹಾಗೂ GR ಜಗದೀಶ್ ಸರ್ ಅವರೇ, ಮತ್ತು ನಿಮ್ಮನ್ನೆಲ್ಲರನ್ನು ಇಲ್ಲಿ ಸೇರಿಸಿ ಈ ವಿಚಾರ ಸಂಕಿರಣವನ್ನು, ಈ ಕಾರ್ಯಾಗಾರವನ್ನು ಆಗು ಮಾಡಲಿಕ್ಕೆ ಕಾಣಿರತಕ್ಕಂಥ ಅಂಜನಾ ರೆಡ್ಡಿ ಸರ್ ಅವರೇ, ಅವರ ಎಲ್ಲ ಸಿಬ್ಬಂದಿ ವರ್ಗದವರೇ, ಮಾಧ್ಯಮದವರೇ, ವಿದ್ಯಾರ್ಥಿನಿಯರೇ ಮತ್ತು ವಿವಿಧ ಕಾಲೇಜುಗಳಿಂದ ಆಗಮಿಸಿರುವ ಪ್ರಬಂಧ ಮಂಡನಕಾರರೇ, ತಮಗೆಲ್ಲರಿಗೂ ಶರಣಾರ್ಥಿಗಳು. ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ 2005ರಿಂದ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ವಿಷಯಗಳಲ್ಲಿ ಸುಧಾರಣೆ ತರಬೇಕು ಎನ್ನುವ ನಿಟ್ಟಿನಲ್ಲಿ ಆರಂಭವಾಗಿರ್ತಕ್ಕಂತಹ ಒಂದು ಸಂಸ್ಥೆ. ಈ ಸಂಸ್ಥೆ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ, ಕಾನೂನು ಸಚಿವರ ಉಪಾಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಮತ್ತು ಸರ್ಕಾರದ ವಿವಿಧ ಕಾರ್ಯದರ್ಶಿಗಳ ಸದಸ್ಯತ್ವದಲ್ಲಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ವಿಧಾನಸಭೆಯ ಸಭಾಧ್ಯಕ್ಷರು ಹಾಗೂ ಕರ್ನಾಟಕ ವಿಧಾನ ಪರಿಷತ್ತಿನ ಸಭಾಪತಿಗಳ ಪ್ರವರ್ತಕ ಮಂಡಳಿಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸ್ತಾ ಇದೆ. ಪ್ರತಿ ವರ್ಷ ಕಾನೂನು ಕುರಿತಾಗಿ ವಿಚಾರ ಸಂಕಿರಣಗಳನ್ನು, ಸಂಸದೀಯ ವಿಷಯಗಳ ಕುರಿತಾಗಿ ಮಾದರಿ ವಿಧಾನಸಭೆ ಸ್ಪರ್ಧೆಗಳನ್ನು ಮತ್ತು ವಿವಿಧ ವಿಷಯಗಳಲ್ಲಿ ಹೊಸ ಚಿಂತನೆಗಳನ್ನು ಮೂಡಿಸಿ ಆ ಚಿಂತನೆಗಳ ಮೂಲಕ ಸರ್ಕಾರಕ್ಕೆ ವರದಿಯನ್ನು ನೀಡುವ ಕೆಲಸವನ್ನು ಮಾಡ್ತಾ ಬಂದಿದೆ. ಇದರ ಜೊತೆಗೆ 75ಕ್ಕೂ ಹೆಚ್ಚು ಕನ್ನಡದಲ್ಲಿ ಪುಸ್ತಕಗಳನ್ನು ಪ್ರಕಟಿಸಿದೆ. ಇಂತಹ ಕೆಲಸವನ್ನು ಮಾಡುತ್ತಾ ಈಗ ಹೊಸ ವಿಷಯದಲ್ಲಿ ಖಾಸಗಿತನದ ಹಕ್ಕುಗಳು, ರೈಟ್ ಟು ಪ್ರೈವಸಿ, ಈ ಕುರಿತಾಗಿ ಕಾನೂನು ಬೇಕು, ಈ ಕುರಿತಾಗಿ ವಿವಿಧ ವಿಚಾರಗಳು ಬೇಕು, ಈ ಮುಖೇನ ಏನಾದರೂ ಹೊಸ ಹೊಳವುಗಳು ಬಂದಲ್ಲಿ ಅವುಗಳನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಮುಟ್ಟಿಸಿ ಒಂದು ಕಾನೂನನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಲಿಕ್ಕೆ, ಕಾನೂನನ್ನು ರಚನೆ ಮಾಡಲಿಕ್ಕೆ ಸಾಧ್ಯವೇ ಎನ್ನುವ ಒಂದು ಚಿಂತನೆಯಿಂದ ಇಂದಿನ ಈ ಕಾರ್ಯಕ್ರಮ ಇಲ್ಲಿ ನಿರ್ಮಾಣಗೊಂಡಿದೆ. ತಾವೆಲ್ಲರೂ ಈ ಕುರಿತಾಗಿ ಹೊಸ ಹೊಸ ವಿಚಾರಗಳನ್ನು ತಿಳಿಯಪಡಿಸುವುದರ ಮೂಲಕ ಮತ್ತು ತಾವು ತಿಳಿದುಕೊಳ್ಳುವುದರ ಮೂಲಕ ಖಾಸಗಿತನದಲ್ಲಿ ಹಕ್ಕುಗಳಲ್ಲಿ ಏನಾದರೂ ಬದಲಾವಣೆಗಳು ಅಥವಾ ಹೊಸ ಕಾನೂನು ಬೇಕಾಗಿದೆ ಎನ್ನುವ ವಿಚಾರ ಒಳಬಂದರೆ ಅದನ್ನು ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ ಒಂದು ವರದಿಯನ್ನು ತಯಾರು ಮಾಡಿ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಲು ಇಂದಿನ ಈ ಕಾರ್ಯಾಗಾರವನ್ನು ಆಯೋಜಿಸಲಾಗಿದೆ. ಈ ಕಾರ್ಯಾಗಾರದ ಸದುಪಯೋಗವನ್ನು ತಾವೆಲ್ಲರೂ ಪಡ್ಕೊಳ್ರಿ ಅಂತ ಹೇಳುತ್ತಾ ತಮಗೆಲ್ಲರಿಗೂ ಮತ್ತು ನಮ್ಮನ್ನೆಲ್ಲರಲ್ಲಿ ಸೇರಿಸಲಿಕ್ಕೆ ಕಾರಣಕರ್ತರಾಗಿರ್ತಕ್ಕಂಥ ಸಂಘಟಕರೆಲ್ಲರಿಗೂ ವಂದಿಸಿ ನನ್ನ ಮಾತು ಮುಗಿಸ್ತಾ ಇದ್ದೇನೆ. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ.
Thank you, sir. To begin with, now I call upon Ms. Neerada Sheen, 4th year student of RVLS, to introduce our chief guest to the gathering.
A very warm good morning to one and all present here. Myself Neerada Sheen, and I am from 7th semester BA LLB. It is indeed an honor of mine to introduce a very prominent personality, Honorable Mr. Justice Ram Mohan Reddy. He started practicing as an advocate in the year 1977. He has practiced in the High Court of Karnataka and was appointed as the additional judge of the Karnataka High Court in the year 2003 and as a permanent judge in the year 2004. He is the invitee member, E-Committee, Supreme Court of India, New Delhi, member of National Court Management Systems Committee, New Delhi, member of National Legal Services Authority, New Delhi, member of Krishna Water Disputes Tribunal, New Delhi, member of General Body National Judicial Academy, Bhopal, and also the member of General Council Hidayatullah National Law University, Raipur, Chhattisgarh. He is also the chairman of the Committee for Computerization, High Court of Karnataka, chairman for the State Court Management Systems Committee, High Court of Karnataka, also the chairman of Judicial Process Re-Engineering Committee, High Court of Karnataka. It is very evident from this long list of chairmanship as well as membership, his year-long experience as well as the achievements. It is indeed a privilege to have you here with us, sir. Thank you.
Thank you, Neerada. And now I request Honorable Chief Guest to address the gathering. Over to you, sir.
Thank you. A very good morning to all of you. Dignitaries on the dais. My dear friend, principal of the college, faculty, my dear students, friends. Today's program is a lengthy one since there's going to be deliberations on a very, very sensitive issue which is plaguing the courts as well. It's also in the Supreme Court presently. You must know about Pegasus. So this is going to take a serious turn. To start with, I will start with two anecdotes, and then we'll go to the serious part of what this right to privacy is all about. The first thing is about the press. So happened that a dignitary owned an ass, donkey, an ass. Suddenly one day, it came out in the newspapers, he said, so-and-so dignitary's ass is injured. Now, that was difficult to digest. See how the press can put it across. And it made it impossible for the gentleman, at least his emotions were so high. See, the right to privacy also includes the emotions. You can't touch upon the emotions of people. Look at the converse of it. When the Taj Hotel, there was this shooting spree by Kasab and company, there was a media person who was on the TV. He got information that there were 140 guests holed up in a room which was not known to Kasab and company. So what does this gentleman do? He goes on to the TV and says, in room number so and so, there are 140 guests, well preserved, conserved, and they are protected. What does Kasab do? He gets information on his walkie-talkie, satellite communication. 140 in so and so room. He simply goes and massacres all of them. Who is responsible? Where are these emotions? Okay, you may be charged with emotion as a media person. You want to disseminate information. But what kind of information? Don't you have a responsibility? And when he was asked, he said, I'm sorry. Is sorry going to bring back the lives of 140 people? No. What action did you take against this media man? Nothing. You let him go. He is scot-free. You know the meaning of scot-free. That's what happened in Scotland. So he is scot-free. And even now he is in the media, said to be a big man now. Doesn't matter. Point still is, we're talking of rights. What are these rights? Can you define them? Can you give a list of rights? It's not possible. We have only said in judgments, we have said, okay, if there is such and such an interference by the government, we say, okay, it involves a right which is under Article 21, right to life. This is how we proceed. But then, if you do not understand the jurisprudential aspects of right to this privacy, we will never be able to even itemize in our lives what are those rights. Therefore, I will now take you through a small, I would say, information about what is this, the jurisprudential aspect of it. The rest of it, I'm sure, the speakers are well equipped with that kind of information which will be disseminated to you for discussion. Term privacy as such is not a static term, because if it was static, then you would have found it in the statute books. It's very dynamic, depends upon circumstances, depends upon so many things, as I said, even feelings, emotions. All these things, each individual has a different kind of feeling and emotion. You can't itemize it. So therefore, it is a very dynamic word. Right to privacy is a dynamic word which can never be defined. But the best way of looking at it is private, we can call private. What is private? Private is something or an action which is kept away from public scrutiny, as the lady spoke here in the morning. She said, something which you do not want to divulge to the public. This is shrouded in secrecy. Like you want to be at home, you want to watch a particular television channel. Somebody, your friend may not like it. This is what's the point in watching that channel, but you are interested. So you are looking at something which is very private, which you don't want others to look at. How did this right to privacy evolve? When did it first start? When was the beginning of this very understanding that each human had something called as a right to privacy? You can go back to the doctrine of public-private distinction. You make a distinction between public and private. That was the starting point, the evolution of the word right to privacy. The first of the person was William Blackstone. All of you must be aware of Blackstone theories, a number of doctrines that he has laid down. This is one of those doctrines. William Blackstone said in his Commentaries in Laws of England, it's such a wonderful book. I know jurisprudence is a little drab subject. It is difficult for understanding, at least for all of you, but then there is so much in jurisprudence. There is so much that each one of you will have to devote a little more time in trying to sit, first read, don't understand it. Jurisprudence is something extraordinary. If you do not have jurisprudence in you, you will never be able to make a good lawyer or judge, because the understanding must be above all these things. So, this Commentaries in the laws of England, way back in 1765, he said his idea of this public and private was you divide the wrongs into public and private. What is public wrong? What is private wrong? Public wrongs, he said, were breach of general and public rights affecting a community. Like, in the IPC we have all those sections affecting the community. So that is a public wrong. What's a private wrong? He says private wrongs are infringement of particular rights concerning individuals. They never enumerated what the rights was. He simply said particular rights where the individual is concerned. So this was how the things changed. So I was saying about crime as a public wrong, misdemeanors as public wrong. This is the first way. This is how it started. Next came Aristotle. What did Aristotle say? He brought a distinction between public and private on the basis of restricting the governmental authorities to activities falling within public realm. This was the next stage of evolution. The government was permitted to make laws or regulations insofar as it relates to the public realm only. So that was made a public wrong. Then what was private? Private was reserved for private feelings, private reflections, relationship between familial relationships, and also self-determination. These words are so impregnated with meaning. Self-determination. What is self-determination? Could be anything. I determine today, from today onwards, I'm not going to have hookah. That's all right. It's a personal feeling. It's an emotion. People have hookah. They like it to have. But then it's a determination not to have something. Or there is a determination from today onwards, I'm going to have a peg of whiskey every day. Possible. But these are determinations. So they're self-determinations. You don't have to make that public. They are all very private. As long as you take the whiskey and don't trouble others. So that is the limitation. As long as you don't trouble others. That's it. Then came John Stuart Mills. What did he advocate? He said, he was writing an essay on liberty. That is 1859. It's a very nice essay. It's a small essay, not too big. But all of you, if you have an opportunity, please read it. It's an essay on liberty. You see how the expression started, liberty. Never heard of. Nobody knew in 1859 that there was this liberty, which was a very important thing, except that, the Liberty Statute came later in America, where the rest of it you know about, the statute. But then come to this. He said, you preserve a zone. His idea was preservation of a zone within the liberty of a citizen. This should be what? Free from authority. Nobody can have authority on this particular zone. This included the conduct of a person. How a person conducts himself. For himself, not for others. But when he concerns himself with others, then the amenity of the governmental agencies coming in and framing some kind of regulations to restrict that kind of use. So this zone was such an important thing that Stuart Mills mentioned in society. Then he also says, there is a concern for the self. There is independence that each one of us enjoy. This cannot be touched upon. It is absolute right. The self and independence are absolute rights. Nobody can touch it. The mind is an individual is an absolute right. So he says the struggle between liberty and authority. The struggle between liberty and authority was something called as right to privacy. This is what Stuart Mill said. Then, he also refers to the tyranny of the majority. You know what the tyranny of majority is? Today we have a particular dispensation in the state of Karnataka. It has some kind of a majority. Like somebody said the other day when I was in Delhi, they said the present parliament has brute majority. I was wondering, what is brute? Why do you use the word brute? It's very offensive. Yes, of course, they have 400 plus, but you can't call it brute. But then, this treadmill takes up a situation where there is tyrannical force in this majority. A whole majority of people trying to come down on the citizens. How do you control this tyranny? What do you rein in? Was the question that he posed to himself, and he answers it this way. I quote him. Recognition of civil right, such as individual right to privacy, free speech, assembly, and expressions can rein in this tyranny, is what he says. So wonderful. Look at the thoughts that came to him. Look at the mind, so active, looking at all aspects of what right to privacy could be. Then we proceed to Austin. Read Austin. Read the book called Lectures on Jurisprudence. It's in 1869. His book is 1869. We are how many years? One decade, one whole year, century and thereafter. His book refers to, again, public and private. He eulogizes what public and private is. He calls of jus publicum and jus privatum. These are the two words that he uses. He says the reason to protect privacy, see the words, reason to protect privacy is the dignity of an individual. So important. The dignity of individual is such an important aspect of very individual being, human being itself. So we are now coming closer to human being, the dignity of individual. And this, he says, individual always interact with public. The situation arises. But what is the extent of that? To what limits can the individual extend that kind of interaction with public? This is the next stage that he came to. Then came, of course, all of you know James Madison, the architect of the Constitution of the United States. Now he refers to a very nice term that he refers. A man is said to have right to property, and equally so, a property in his right. This is what he says. This is the phrase that he uses. After James Madison came Samuel Warren and Louis Brandeis. See, these two bring about a lot of change into the very idea of right to privacy. These two of them. They say that a recognition of man's spiritual name, of his feelings and intellect. Look at the words, the additions, the feelings, the intellect, the recognition of man's spiritual nature, right to enjoy life. Here the word was coined, which even Justice D.Y. Chandrachud in K.S. Puttaswamy's case refers to and says, the right to be let alone. Ultimately, if you read all the judgments, if you read all the jurisprudence, we come back to this point, right to be let alone. You want to be alone, you want to do what you want. There's a case going on in the Supreme Court in the United States over whether an individual has a right to sit in his house and watch pornography. Whether an individual can have pornographic material inside his house for his own self, not for public viewing. This case is still going on in the Supreme Court. We hope to get some kind of a judgment on that. But nevertheless, you see, the whole idea is right to be let alone. You have to keep this in mind when you are thinking of the different kinds of rights that each individual possesses and how you are going to ask the governmental agencies to bring in the limitations on all these rights. With Samuel Warren and Brandeis, we have next in our Indian context. What is our Indian context? The first judgment was the 8-judge bench decision in MP Sharma, way back in 1954. I'll come to A.K. Gopalan's case, it's 1950, but let's get to 54, Sharma's case. It was observed that fundamental right of privacy did not include power of search and seizure. This was arising under the Income Tax Act, where power of seizure and search was questioned, saying that it amounts to violation of fundamental right. But then the court said, no, nothing doing. It doesn't affect fundamental right. Then came the 6-judge bench decision in Kartar Singh. Kartar Singh, the Supreme Court held that privacy is not a fundamental right. However, the observation is important. A slight deviation from the 8-judge bench decision. Police regulations of night visits was said to be unauthorized intrusion to personal liberty. This was the light change or the observation that was made. Then, of course, all of you know Maneka Gandhi's case where passport was impounded. What happened? The broadening of the view of the Supreme Court in 1978. This is where A.K. Gopalan's case was distinguished. And they said, look, that was a very narrow view that was taken at that point of time. Now, if a passport has to be impounded, then they must follow what is called as the right of audiatorem partem. You got to give them an opportunity of hearing before even confiscating or doing anything with the passport. Passport is something individual. You can't take it away without giving him an opportunity of hearing. So there was a broader view taken, and A.K. Gopalan's case, of course, the judgment was not disturbed, but they took a broader view. Then came what was the right of privacy of a woman of easy virtue. It's such an important thing. This was in the case of state of Maharashtra versus Madhukar Narain in 1991. They said even that lady has a right of privacy. This is how the Supreme Court, again, the evolution of the various ideas and concepts of right to privacy, even in the minds of judges as it went on. The next and the most important case that I'm sure all of them will present to you is R. Rajgopal versus State of Tamil Nadu. This was an eye-opener. 1994, for the first time, the Supreme Court said right to privacy is implicit in the right to life and liberty that is granted to a citizen under Article 21 of the Constitution. This was the first time that they said it was implicit, the word is used, implicit in the fundamental rights. And again they reiterated what Dharan had said, right to let alone. You want to be let alone. The safeguards that they proposed was on privacy of individual, his marriage, procreation, motherhood, childbearing, and education, amongst others. These were the words that were used. In fact, Justice Balakrishnan, later on, in a case where a woman, he says a woman's right to privacy is to even have a child, bear a child. His Lordship's view was wonderfully taken, of course, following the verdict in Rajgopal's case. Then came the case in Mr. X versus Hospital Z. This is another wonderful judgment in 1995, where it was held that this right to privacy is not absolute and is subject to restrictions as the legislature may impose, is what they said. I will take a few more minutes and I will conclude. Then came what was the restriction? The restrictions related to crime, disorderly behavior, protection of health or morals, protections of rights and other freedoms These were the exceptions that were carved out. Then came the phone tapping case. You're all aware of the phone tapping case of 1997, where the Supreme Court said it would be serious invasion, the word used, serious invasion into the individual's right to privacy. I think Pegasus is just one of those things. I don't know. I don't know what Supreme Court judges are going to take as a view now, but if you connect it to the phone tapping case, well then, this was almost identical to it. But there is the use of technology here. Then the landmark decision of the state of Karnataka, Selvi versus state of Karnataka, a landmark decision in 2010, holding that involuntary subjection of a person to tests such as necroanalysis, polygraphy, examination, and the BEAP, they said it violates the rights of an individual, the privacy right of an individual. But then they added, when is it that the state can impose on this or infringe upon it? Only cases of public emergency and public safety. These are the only two things where the state could impose upon itself. Then came the Ram Jethmalani's case, 2011, very famous case. I think all law students will have read it over and over again. Right to privacy is an integral part of right to life, a cherished constitutional value, and it is important that human beings be allowed domains of freedom. The words are so pregnant with meaning. Domains of freedom that are free of public scrutiny unless they act in an unlawful manner. These were the words of the Supreme Court. I just quoted it. So these things must try help you in an understanding of what right to privacy is. Of course, the latest of the decision is Justice K.S. Puttaswamy's case, where the Supreme Court, in the case of Aadhaar, making it available, and it is in this judgment that both the earlier larger bench decisions of MP Sharma and Qatar Singh were set at naught. They said it is no good law. It was in this case. So, speaking of individual rights, what comes to my mind just as a commoner, forget me as a judge, and just as a commoner, what does it strike me? The first is about law of abortion. In the present context of circumstances, emotions in children are growing haywire, there's no control. So then this law of abortion is such an important thing. Then bailments. I don't know if all of you know the kind of bails that are granted in courts. Stringent conditions. You shall go every evening to the police station and you will report. Police station is 100 kilometers away. Every evening he has to travel 100 kilometers. This kind of bailments is not proper. So it came to my mind because I had to deal with that kind of bails at a point of time. Of course, the latest one is Justice Nageshwar Rao yesterday in the Supreme Court said, when one of those accused, one of those convicted in Rajiv Gandhi's murder case, he was released on bail, enlarged on bail. And there the words were used was that, you see, you can't expect this 100 kilometers traveling every week for this man from some place in Andhra Pradesh to Tamil Nadu and go and report to that. These are certain things. You see, it comes to your mind. Your reflections on this as students is very essential, because you must think of various methods, means, circumstances that occur to you. May not occur to you, but then your imagination is so wild. It can go wild on all these things. Then there is this discrimination in employment. I happened to have one such thing when I was a judge. She was from one of those LBGT, and nobody wanted to give her an employment. I was very keen that this person, I call her a person, to be given an employment. So I requested Justice Manjula Chalur, who was then the chairman of the selection committee, and Sister Judge was so compassionate. They said, we are all human beings. It's unfortunate that she is born like that. Does it mean to say we should discriminate? We were the first of the high courts in the country to give her an employment. These are things that should strike you at that given moment. It's such an important thing. So I keep all these things in mind. I say when I sit and contemplate, the contemplation gives us so much of information that we can just note it, a pencil, because our memory fades. We just forget it because the next minute we have something else which is coming up. So we forget to make a note of it. So make a note. Doesn't matter. Even if it's the most idiotic thing that has come to your mind, just make a note. We are human beings. We are bound to err. Doesn't matter. Then conflicts between private individuals, between two private individuals, conflict. This is another thing where, the zone where you can think of. Then we spoke about seizure of properties on suspicion. I suspect that he's got narcotics in his house, so I will go and... It's not right. Seizures are not the right thing to do. Suspicion is not the right thing. So you can work on that. Then, media material that is prepared by governmental agencies. We've seen in many of these newspapers, tabloids, you will find media material prepared by the governmental agencies and disseminated by whom? Non-governmental agencies with utmost secrecy. This is yet another one which we have to think about, ponder about it. Say where you can put a full stop to this. Then comes imposition of fines, excessive fine. Somebody is not wearing a helmet. Of course, it's dangerous to public safety, no difficulty. He goes to court. The judge looks at him. Young fellow, how dare he do such things? Old man is all right. But a young guy, all right, 500 rupees fine. What discretion? What kind of this impunity? What impunity you are going to do this just because he's a youngster? These excessive fines are also not right. So you must bring down the effects of excessive fines. Then, cruel and unusual punishments imposed. I remember an incident. I was asked to go to Singapore to attend a college. I was there for about 4 or 5 days, and then the college took me through the courts in Singapore. So easy. It was made so simple. Not all this, the whole lot of CPC and all that. All that wasn't there. There was nothing called CPC there. You just make a complaint, and the complaint is taken. Everything is by way of digital information. And then what was this complaint? The complaint was, there was a boy who was a little against the neighbor because the neighbor had asked him to tone down the volume of his speaker where he had some very nice music going on, and the neighbor didn't like it. So when he asked him to tone down that, he was a little aggressive. So what he did was, when his mother asked him to take the garbage and throw it out into the garbage bin, he took it and threw it right on the doorstep of this house, the neighbor. That was the case. So the judge was very nice. I really appreciate it because first thing he did was, he put that clipping, the streaming of what exactly he had done on the TV, on the monitor, and then asked him, now tell me, do you plead guilty or not? And he also told him, if you plead guilty, less punishment. If you plead you're not guilty, and if I find you guilty after the trial, then the punishment will be something different. So the boy looked at it and pondered over it for a minute and said, it's better to take a lesser punishment. Everything is digitally recorded. What else is there? You don't need a lawyer for all this. So finally the judge said, all right, you want a lesser punishment, but since you're a youngster and you're capable of redoing it again, look at the situation. Redoing. You're not going to change your attitude. That was in the mind of the judge. So he said, you wear a overall, some kind of a coat, and then on the back it is printed, I will not litter garbage on my neighbor's door. And then where is he supposed to go with that overall? Go there and sweep the roads of Singapore. Every day 1 hour, you have to sweep the roads of Singapore. Now that was a little excessive. All right, you wear a overall for a few days, go to school, go to college, everybody looks at you, and then, you feel so remorse that you will not do it again. That's fine. Go and sweep the road. That became a little excessive, is what I thought. So, this unusual punishments being imposed upon. Then, we have electronic surveillance. What is electronic surveillance? Today, everybody, all of you know, look here, we are watching you. If you go to China, it seems every road has an electronic surveillance. Where you are, where you're going, who are you, the entire data of your personality is there. How do we stop it? The state has everything. Not only the state, you see, all of you go to those social media posts and you post everything. There is nothing left that the people don't know about you. It so happened a thief enters a house. You know about it. It's all in WhatsApp. About a thief entering into the house and then asking for all the jewelry, everything. And then he asks specifically, he says, where is that iPhone that was sent to you by your brother? Then he says, where is that jewelry that your husband gave you on your anniversary? And then he also adds, this is something very nice you made, pudding today. Why don't you give it to me? Then says, where do you get all this information? I say, it's all in Facebook. You have put it up. You gave us all the information. So I make use of it. So social networking, social sites are a place where you disseminate all kind of your personal information, and then be careful about it. Be careful of who is going to read it and what's going to happen. Then you go on online sites where you purchase things. When you purchase, you see, in most of the cases, you give them your card number, your debit card, credit card, whatever it is, and somebody uses it. Where is the regulation on all these things? Do we have a regulatory authority to impose some kind of restriction on the misuse of this data? If you download an app, you will get one agreement. All terms are mentioned there. Anybody read any of those terms? I'm sure nobody read it. Even I didn't read it. I simply say I agree. That's all. Because you want the app. You want the app onto your mobile, on your smartphone. So you see, there must be some restriction on all these things. I'm trying to tell you, where are the areas where you can think about bringing about restrictions where government can impose itself. Suddenly, the other day, I got a call. So he said, sir, your water purifier is about time for service. So I said, who are you? How did you know that my water thing has to come up for service? He was very silent. Because he had got the data from that agency who sold me the water purifier. You see how the data got disseminated? Where's the control for this data? He knows everything about my bank balance, my bank details. He knows everything. So how do you control this? These are things, on daily basis. Then the other aspects. Now this is all right as far as the electronics aspects of things is concerned. Then you come to Custodial interrogation. Do you know what is custodial interrogation? Have you ever been to a police station at any point of time? You've been. Have you seen what they do inside the cell there? Has anybody has an experience about it? Sorry, I didn't mean anything else. Just, I said, if anybody has seen anything happening inside the cell, the way they treat these people, different kinds of people. This interrogation cannot be by the use of a stick. What kind of reservation, what kind of regulations are necessary? Of course, there are regulations. I'm told on the Police Act and police rules, there are all these things, but nobody follows it. But then you got to think about it and make it much more stringent. Then there is this right to personal autonomy. Right to personal autonomy. Each one of us have something very personal, and it's meant only for us. It is autonomous to us. Then we have mixed motives and intentions. Sometimes, there are all mixed motives and intentions which we have. We are diabolic also. We are a human being. So we are diabolic as well. Such situations. Then the right to counsel. If you take the Land Reforms Act, lawyers are not permitted to appear before the tribunals. Land tribunals. Why? What did they do wrong? We don't understand. Why should not a party be given the right to have appearance of his lawyer before a particular tribunal? In fact, even the income tax tribunals, they don't allow lawyers. That this is not fair. So this is another aspect where, right to counsel. Then comes same-sex marriages. Less said about it, but then you can think about it. Then comes suspect classifications. See, such an important thing. Suspect classifications. Then the protection of voters in an election. Then, now, the latest thing is protection of lawyers also we need. Because lawyers are also being hammered, thulped, and so many things happening. With the recent, we saw about what happened to a lawyer. So, lawyers' protection is also an important thing. It's a right to privacy. I am entitled to argue a matter before court totally against whatever is the argument that the other side is going to canvass. But that doesn't mean to give him a right to thulp me as I come out. So these are certain rights, and many other such rights which I thought will influence your mind, activate your minds to imagine what kind of rights could be brought within the purview of right to privacy. It's been a wonderful listening spree, I hope. I hope all of you have understood what I'm trying to convey to the students, because you are our future. You are the citizens of this country. You are the ones who are going to be judges, who will become administrators, who will be wonderful lawyers, and more than anything, wonderful citizens. And you are the ones who are going to pave way to bring about a change. I mean, a change really. Thank you very much for listening. And I thank the organizers. I thank every one of them. I thank all the dignitaries who gave me this occasion to come and say a few words. Thank you very much.
Thank you, sir, for sharing such valuable insights about various dimensions of concept of privacy. Thank you, sir. I call upon Srinidhi Joshi, second year student of RVILS, to introduce Mr. Dwarkanath Babu, Director of Kilpa, to the gathering.
Polygraphy, examination, and the BEAP, they said it violates the rights of an individual, the privacy right of an individual. But then they added, when is it that the state can impose on this or infringe upon it? Only cases of public emergency and public safety. These are the only two things where the state could impose upon itself. Then came the Ram Jethmalani's case, 2011, very famous case. I think all law students will have read it over and over again. Right to privacy is an integral part of right to life, a cherished constitutional value, and it is important that human beings be allowed domains of freedom. The words are so pregnant with meaning. Domains of freedom that are free of public scrutiny unless they act in an unlawful manner. These were the words of the Supreme Court. I just quoted it. So these things must try help you in an understanding of what right to privacy is. Of course, the latest of the decision is Justice K.S. Puttaswamy's case, where the Supreme Court, in the case of Aadhaar, making it available, and it is in this judgment that both the earlier larger bench decisions of MP Sharma and Qatar Singh were set at naught. They said it is no good law. It was in this case. So, speaking of individual rights, what comes to my mind just as a commoner? Forget me as a judge. And just as a commoner, what does it strike me? The first is about law of abortion. In the present context of circumstances, emotions in children are growing haywire, there's no control. So then this law of abortion is such an important thing. Then bailments. I don't know if all of you know the kind of bails that are granted in courts. Stringent conditions. You shall go every evening to the police station and you will report. Police station is 100 kilometers away. Every evening he has to travel 100 kilometers. This kind of bailments is not proper. So it came to my mind because I had to deal with that kind of bails at a point of time. Of course, the latest one is Justice Nageshwar Rao yesterday in the Supreme Court said when one of those accused, one of those convicted in Rajiv Gandhi's murder case, he was released on bail, enlarged on bail. And there the words were used was that, you see, you can't expect this 100 kilometers traveling every week for this man from some place in Andhra Pradesh to Tamil Nadu and go and report to that. But these are certain things. You see, it comes to your mind. Your reflections on this as students is very essential, because you must think of various methods, means, circumstances that occur to you. May not occur to you, but then your imagination is so wild. It can go wild on all these things. Then there is this discrimination in employment. I happened to have one such thing when I was a judge. She was from one of those LBGT, and nobody wanted to give her an employment. I was very keen that this person, I call her a person, to be given an employment. So I requested Justice Manjula Chalur, who was then the chairman of the selection committee. And Sister Judge was so compassionate. They said, we are all human beings. It's unfortunate that she is born like that. Does it mean to say we should discriminate? We were the first of the high courts in the country to give her an employment. These are things that should strike you at that given moment. It's such an important thing. So I keep all these things in mind. I say when I sit and contemplate, the contemplation gives us so much of information that we can just note it, a pencil, because our memory fades. We just forget it because the next minute we have something else which is coming up. So we forget to make a note of it. So make a note. Doesn't matter. Even if it's the most idiotic thing that has come to your mind, just make a note. We are human beings. We are bound to err. Doesn't matter. Then conflicts between private individuals. between two private individuals, conflict. This is another thing where, the zone where you can think of. Then we spoke about seizure of properties on suspicion. I suspect that he's got narcotics in his house, so I will go and. It's not right. Seizures are not the right thing to do. Suspicion is not the right thing. So you can work on that. Then, media material that is prepared by governmental agencies. We've seen in many of these newspapers, tabloids, you will find media material prepared by the governmental agencies and disseminated by whom? Non-governmental agencies with utmost secrecy. This is yet another one which we have to think about, ponder about it. Say where you can put a full stop to this. Then comes imposition of fines. Excessive fine. Somebody is not wearing a helmet. Of course, it's dangerous to public safety, no difficulty. He goes to court. The judge looks at him. Young fellow, how dare he do such things? Old man is all right. But a young guy? All right, 500 rupees fine. What discretion? What kind of this impunity? With what impunity you are going to do this? Just because he's a youngster? These excessive fines are also not right. So you must bring down the effects of excessive fines. Then, cruel and unusual punishments imposed. I remember an incident. I was asked to go to Singapore to attend a college. I was there for about 4-5 days, and then the college took me through the courts in Singapore. So easy. It was made so simple. Not all this, the whole lot of CPC and all that. All that wasn't there. There was nothing called CPC there. You just make a complaint, and the complaint is taken. Everything is by way of digital information. And then what was this complaint? The complaint was, there was a boy who was a little against the neighbor because the neighbor had asked him to tone down the volume of his speaker where he had some very nice music going on, and the neighbor didn't like it. So when he asked him to tone down that, he was a little aggressive. So what he did was, when his mother asked him to take the garbage and throw it out into the garbage bin, he took it and threw it right on the doorstep of this house, the neighbor. That was the case. So the judge was very nice. I really appreciate it because first thing he did was, he put that clipping, the streaming of what exactly he had done on the TV, on the monitor, and then asked him, now tell me, do you plead guilty or not? And he also told him, if you plead guilty, less punishment. If you plead you're not guilty, and if I find you guilty after the trial, then the punishment will be something different. So the boy looked at it and pondered over it for a minute and said, it's better to take a lesser punishment. Everything is digitally recorded. What else is there? You don't need a lawyer for all this. So finally the judge said, all right, you want a lesser punishment, but since you're a youngster and you're capable of redoing it again, look at the situation. Redoing. You're not going to change your attitude. That was in the mind of the judge. So he said, you wear a overall, some kind of a coat, and then on the back it is printed, I will not litter garbage on my neighbor's door. And then where is he supposed to go with that overall? Go there and sweep the roads of Singapore. Every day, 1 hour, you have to sweep the roads of Singapore. Now that was a little excessive. All right, you wear a overall for a few days, go to school, go to college, everybody looks at you, and then, you feel so remorse that you will not do it again. That's fine. Go and sweep the road. That became a little excessive, is what I thought. So, this unusual punishments being imposed upon. Then we have electronic surveillance. What is electronic surveillance? Today, everybody, all of you know, look here, we are watching you. If you go to China, it seems every road has an electronic surveillance. Where you are, where you're going, who are you, the entire data of your personality is there. How do we stop it? The state has everything. Not only the state, you see, all of you go to those social media posts and you post everything. There is nothing left that the people don't know about you. It so happened a thief enters a house. You know about it. It's all in WhatsApp. About a thief entering into the house and then asking for all the jewelry, everything. And then he asks specifically, he says, where is that iPhone that was sent to you by your brother? Then he says, where is that jewelry that your husband gave you on your anniversary? And then he also adds, this is something very nice you made, pudding today. Why don't you give it to me? Then says, where do you get all this information? I say, it's all in Facebook. You have put it up. You gave us all the information. So I make use of it. So social networking, social sites are a place where you disseminate all kind of your personal information, and then be careful about it. Be careful of who is going to read it and what's going to happen. Then you go on online sites where you purchase things. When you purchase, you see, in most of the cases, you give them your card number, your debit card, credit card, whatever it is, and somebody uses it. Where is the regulation on all these things? Do we have a regulatory authority to impose some kind of restriction on the misuse of this data? If you download an app, you will get one agreement. All terms are mentioned there. Anybody read any of those terms? I'm sure nobody read it. Even I didn't read it. I simply say I agree. That's all. Because you want an app. You want the app onto your mobile, on your smartphone. So you see, there must be some restriction on all these things. I'm trying to tell you, where are the areas where you can think about bringing about restrictions, where government can impose itself. Suddenly, the other day, I got a call. So he said, sir, your water purifier is about time for service. So I said, who are you? How did you know that my water thing has to come up for service? He was very silent, because he had got the data from that agency who sold me the water purifier. You see how the data got disseminated? Where's the control for this data? He knows everything about my bank balance, my bank details. He knows everything. So how do you control this? These are things, on daily basis. Then the other aspects. Now this is all right as far as the electronics aspects of things is concerned. Then you come to custodial interrogation. Do you know what is custodial interrogation? Have you ever been to a police station at any point of time? You've been. Have you seen what they do inside the cell there? Has anybody has an experience about it? Sorry, I didn't mean anything else. Just, I said, if anybody has seen anything happening inside the cell, the way they treat these people, different kinds of people. This interrogation cannot be by the use of a stick. What kind of reservation, what kind of regulations are necessary? Of course, there are regulations. I'm told under the Police Act and police rules, there are all these things, but nobody follows it. But then you got to think about it and make it much more stringent. Then there is this right to personal autonomy. Right to personal autonomy. Each one of us have something very personal, and it's meant only for us. It is autonomous to us. Then we have mixed motives and intentions. Sometimes, there are all mixed motives and intentions which we have. We are diabolic also. We are a human being. So we are diabolic as well. Such situations. Then the right to counsel. if you take the Land Reforms Act, lawyers are not permitted to appear before the tribunals, land tribunals. Why? What did they do wrong? We don't understand. Why should not a party be given the right to have appearance of his lawyer before a particular tribunal? In fact, even the income tax tribunals, they don't allow lawyers. That this is not fair. So this is another aspect where, right to counsel. Then comes same-sex marriages. Less said about it, but then you can think about it. Then comes suspect classifications. See, such an important thing. Suspect classifications. Then the protection of voters in an election. Then, now the latest thing is protection of lawyers also we need. Because lawyers are also being hammered, thulped, and so many things happening. With the recent, we saw about what happened to a lawyer. So, lawyers' protection is also an important thing. It's a right to privacy. I am entitled to argue a matter before court totally against whatever is the argument that the other side is going to canvass. But that doesn't mean to give him a right to thulp me as I come out. So these are certain rights and many other such rights which I thought will influence your mind, activate your minds to imagine what kind of rights could be brought within the purview of right to privacy. It's been a wonderful listening spree, I hope. I hope all of you have understood what I'm trying to convey to the students, because you are our future. You are the citizens of this country. You are the ones who are going to be judges, who will become administrators, who will be wonderful lawyers, and more than anything, wonderful citizens. And you are the ones who are going to pave way to bring about a change. I mean, a change really. Thank you very much for listening. And I thank the organizers. I thank every one of them. I thank all the dignitaries who gave me this occasion to come and say a few words. Thank you very much.
Thank you, sir, for sharing such valuable insights about various dimensions of concept of privacy. Thank you, sir. I call upon Srinidhi Joshi, second year student of RVILS, to introduce Mr. Dwarkanath Babu, Director of Kilpa, to the gathering.
Good morning everyone present here. I am Srinidhi Joshi, studying 3rd semester BBA LLB in RV Institute of Legal Studies. It is indeed my pleasure to welcome the President of the workshop today, Shri K. Dwarkanath Babu, presently designated as the Director of Karnataka Institute of Law and Parliamentary Reform, that is KILPAR. Sir has completed his bachelor's in RC College of Commerce, Bengaluru. Sir successfully completed his LLB degree from VV Puram College of Law. Sir also holds a master's degree in Kannada from Bengaluru University. Sir has served for more than 38 years in government service. He has been in Group A since 1998. Sir has been the Special Secretary to Government Department of Parliamentary Affairs and Legislation from 2013 to 2016. Sir has also been the Secretary to Government Department of Parliamentary Affairs and Legislations from 2016 to 2021. Sir has also been the member of Syndicate Karnataka Legislation Law from 2016 to 2021. Sir has also served as a member of the Academic Council of Karnataka State Law University, that is KSLU Hubli, from 2016 to 2021. Sir has also served as a member of Karnataka Institute of Law and Parliamentary Reform from 2016 to 2021. Sir was strongly serving for more than 4 designations in a span of 5 years. He has worked for more than 10 years as Secretary of the Scrutinizing Committee under the chairmanship of the Honorable Law Minister. He has also worked as advisor to the Committee on Subordinate Legislation of State Legislature for more than 10 years. Sir has also drafted major legislations. It is an honor to have your presence amongst us, sir. Thank you.
Thank you, Srinidhi. Now I request Sir to deliver the keynote address to the gathering.
ಎಲ್ಲರಿಗೆ ನಮಸ್ಕಾರ ಹಾಗೂ ಶುಭೋದಯ. ಇವತ್ತಿನ ದಿನ ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ ಹಾಗೂ RV ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಲೀಗಲ್ ಸ್ಟಡೀಸ್ ಈ ಸಹಯೋಗದೊಂದಿಗೆ ರೈಟ್ ಟು ಪ್ರೈವಸಿ, ಇಟ್ಸ್ ಡೈಮೆನ್ಷನ್ಸ್ ಆ್ಯಂಡ್ ಲಿಮಿಟ್ಸ್ ಬಗ್ಗೆ ಈ ವರ್ಕ್ಶಾಪ್ ಏರ್ಪಡಿಸಿದ್ದೀವಿ. ಈ ದಿನ ವೇದಿಕೆ ಮೇಲೆ ಆಸೀನರಾಗಿರುವಂಥ ಮಾನ್ಯ ಜಸ್ಟಿಸ್ ರಾಮಮೋಹನ್ ರೆಡ್ಡಿ ಸರ್ ಅವರೇ ಹಾಗೂ ಈ ಸಂಸ್ಥೆಯ ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಿರುವಂಥ ದತ್ತರಾಜ್ ಅವರೇ, ಈ ಸಂಸ್ಥೆಯ ಪ್ರಿನ್ಸಿಪಾಲ್ರಾದಂಥ ಅಂಜನಾ ರೆಡ್ಡಿ ಅವರೇ, ಈ ವರ್ಕ್ಶಾಪ್ನಲ್ಲಿ ತಮಗೆಲ್ಲ ಮತ್ತಷ್ಟು ಈಗಾಗಲೇ ಮಾನ್ಯ ಜಸ್ಟಿಸ್ ರಾಮಮೋಹನ್ ರೆಡ್ಡಿ ಅವರು ರೈಟ್ ಟು ಪ್ರೈವಸಿಯ ಆದಿಯಿಂದ ಅಂತ್ಯದವರೆಗೆ ಎಲ್ಲ ಹೇಳಿದ್ದಾರೆ, ಏನೂ ಬಿಟ್ಟಿಲ್ಲ. ಆದರೂ ನಿಮ್ಮ ಏನು ಪ್ರಿಪ್ರೇಷನ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದೀರಾ, ನಿಮ್ಮ ಪ್ರೆಸೆಂಟೇಷನ್ನ ಮೇಲೆ ಇಲ್ಲಿ ಬಂದಿರುವಂಥ ರಿಸೋರ್ಸ್ ಪರ್ಸನ್ ಆದಂಥ ಪ್ರೊಫೆಸರ್ CS ಪಾಟೀಲ್ ಅವರು ಹಾಗೂ JR ಜಗದೀಶ್ ಅವರು ತಮಗೆ ಇನ್ನಷ್ಟು ಈ ವಿಚಾರದಲ್ಲಿ ಬೆಳಕು ಚೆಲ್ಲೋರಿದ್ದಾರೆ. ಇದ್ರ ಬಗ್ಗೆ ಈ ಕಾರ್ಯಕ್ರಮ ನಾವು ಹಮ್ಮಿಕೊಳ್ಳೋಕ್ಕೆ ಮೂಲ ಕಾರಣ ಇಷ್ಟೇ. 1948ರಲ್ಲಿ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಏನು ಯುನೈಟೆಡ್ ನೇಷನ್ಸಲ್ಲಿ ಹೇಳಿದರು, ಅಲ್ಲಿ ಕೂಡ ರೈಟ್ ಟು ಪ್ರೈವಸಿ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ಮಾಡಿದರೂ ಕೂಡ ನಮ್ಮ ಸಂವಿಧಾನದಲ್ಲಿ ಲೈಫ್ ಆ್ಯಂಡ್ ಲಿಬರ್ಟಿ ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ. ಆಗಲಿ ಪ್ರೈವಸಿ ಬಗ್ಗೆ ಯಾವುದೇ ಉಲ್ಲೇಖ ಇರಲಿಲ್ಲ. ಮಾನ್ಯ ರಾಮಮೋಹನ್ ರೆಡ್ಡಿ ಸರ್ ಅವರು ಹೇಳಿದಾಗೆ ಸೀರೀಸ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಬಂದ ನಂತರ ರೈಟ್ ಟು ಲೈಫ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ರೈಟ್ ಟು ಪ್ರೈವಸಿ ಅನ್ನುವಂಥ ಒಂದು ತೀರ್ಮಾನ ಜಡ್ಜ್ಮೆಂಟ್ ಬರೋವರೆಗೆ ಇದರ ಒಂದು ಸರಿಯಾದ ಚಿತ್ರಣ ಸಾರ್ವಜನಿಕರಿಗೆ ಇರಲಿಲ್ಲ. ಇಷ್ಟಾಗಿ ರೈಟ್ ಟು ಪ್ರೈವಸಿ ಅಂದರೆ ಏನು ಅಂತ ಡಿಫೈನ್ ಮಾಡೋಕ್ಕೆ ಒಂದು ಕಾನೂನು ತರಬೇಕು ಅಂತ ಸರ್ಕಾರ, ಕೇಂದ್ರ ಸರ್ಕಾರ 3 ಬಾರಿ ಪ್ರಯತ್ನ ಮಾಡಿದೆ. 3 ಬಿಲ್ ಡ್ರಾಫ್ಟ್ ಮಾಡಿ ಪಾರ್ಲಿಮೆಂಟಲ್ಲಿ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, ಆದರೂ ಅದು ಸೆಲೆಕ್ಟ್ ಕಮಿಟಿಯಲ್ಲಿ ಹೋಗಿ ಆಮೇಲೆ ಅದು ಥ್ರೂ ಆಗಲಿಲ್ಲ. ಇದರಲ್ಲಿ 2 ಅರ್ಥ ಬರುತ್ತೆ. ಒಂದು, ಸರ್ ಈಗಾಗಲೇ ಹೇಳಿದಾಗೆ ಪ್ರೈವಸಿ ಅನ್ನೋ ಪದ ಸುಲಭವಾಗಿ ಡಿಫೈನ್ ಮಾಡುವಂಥ ಸ್ಟ್ಯಾಟಿಕ್ ವರ್ಡ್ ಅಲ್ಲ. ಇಟ್ಸ್ ಎ ಡೈನಮಿಕ್ ವರ್ಡ್ ಆ್ಯಂಡ್ ಇಟ್ ಕೀಪ್ಸ್ ಆನ್ ಚೇಂಜಿಂಗ್ ಎವ್ರಿ ಡೇ. ಗೌರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಫೌಂಡ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್ ಟು ಡಿಫೈನ್ ಆ್ಯಂಡ್ ಬ್ರಿಂಗ್ ಎ ಲೆಜಿಸ್ಲೇಷನ್. ಇಟ್ಸ್ ಒನ್ ಆಫ್ ದಿ ಪಾರ್ಟ್, ಐ ಅಗ್ರಿ. ಅದೇ ರೀತಿ unless there is an express provision to confer right of privacy, you cannot restrict infringement of right to privacy. ನಿಮ್ಮ ಹಕ್ಕು ಏನು? ರೈಟ್ ಟು ಪ್ರೈವಸಿ ಅಂದರೆ ರೈಟ್ ಟು ಲೈಫ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ರೈಟ್ ಟು ಪ್ರೈವಸಿ, ಐ ಅಗ್ರಿ. ದೆನ್ ವಾಟ್ ಈಸ್ ಪ್ರೈವಸಿ? ವಾಟ್ ಎಕ್ಸ್ಟೆಂಟ್? ನೋ ಡೌಟ್ ಇಟ್ ಈಸ್ ಎ ಥಿನ್ ಲೈನ್ ಬಿಟ್ವೀನ್ ಪಬ್ಲಿಕ್ ಆ್ಯಂಡ್ ಪ್ರೈವೇಟ್ ಲೈಫ್. But even you may not be a celebrity. See, there are a few people who are celebrities and who are well-known politicians even you. See here, though they are public figures, they have private life. Their private life has to be protected. Unless we define what is privacy and how it should be protected, you cannot penalize a person who is infringing private right of a person. See, privacy is subject to invasion in three manners. One, government invasion, as Sir said, tapping of phone, tapping of your data, as the Supreme Court said, Aadhaar case also. The second, this even police search, this thing also falls under that. The second phase or this thing, invasion of right to privacy is by the media. There are two medias. One, the print media and TV media. The other part is social medias. The media people many a time invade on your privacy. You have private life. No doubt you may be a public figure, but you have private life. But there should be some restriction on this invasion. So there should be a law, unless there is an express provision to restrict this kind of invasion, you cannot penalize them and restrict it. Thirdly, individual invasion. First is government invasion, second is media invasion, third one is individual invasion. Even an individual of your own friends or other, they should not invade on your privacy right. So here we should think of defining it, conferring right on every individual this right of privacy. So that is the challenge while drafting a legislation on right to privacy. The second thing is we have to examine the legislative competence of the state legislature if it thinks to bring a legislation on this. And the next part is, see, right to privacy, no doubt it is conferred under as an integral part of Article 21. The reasonable restrictions, when we think of reasonable restrictions, it should be linked with Article 19(1)(a). 19(1)(a), see, freedom of expression. See, there the right to media is there, but that right, here public and private distinction is there, where it should be restricted to public life, from where it should be treated as private life. This thin line, unless we define it, we cannot confer and make penal provision upon those issues. Finally, see, though there is no infringement of Article 19(1), sometimes a public morale, public interest are the reasonable restrictions on private rights. So all this has to be taken into consideration before drafting a legislation. These are the challenges before the state legislature. So today it is a brainstorming workshop for you. You must come out with your young and dynamic ideas. You might have gone through the judgments and Supreme Court landmark judgments. So out of this and your other knowledge, young people are more dynamic with new ideas. So now today it is your day to express your idea and to come out with new suggestions what can be done by the government to confer such right and restricts invasion on the privacy. Thank you.
Thank you, sir, for such a thought-provoking address. As a guest of honor, Professor Dr. C.S. Patil sir and Professor Dr. G.R. Jagdish sir would be with us for the next session. They will be addressing us in the technical session. We are eagerly waiting for your deliberation, sir. Now I call upon Mr. Chinmay, 4th year student RVLS, to introduce the president of the session, Mr. M.K. Dattaraj, to the gathering.
A very good morning, one and all. Myself, Chinmay M, studying in 7th sem of BA LLB. It's my honor to introduce sir to this gathering. Shri M.K. Dattaraju sir was born on 11th August 1945, who hails from the well-known business and industrialist Medha family. This scientist entrepreneur has his Bachelor of Science degree from the University of Mysore and Bachelor of Law from the University of Bengaluru and Masters of Science degree from Kansas State University, USA. Sir has specialized in flour and feed milling technology from St. Gallen, Switzerland. He has visited many advanced countries like USA, Japan, Switzerland, Germany for updating his knowledge and to share his expertise with the scientist and industrialist. He is giving a business leadership to Sri Krishna group of companies which is engaged in diversified activities. Sir, Shri M.K. Dattaraju sir is connected with many scientific, educational, charitable and social institutions. He is a member of board of directors of several industries primarily connected with the human food and animal feed. His contribution as technical director is in making the Mysore Food Limited as a high-tech feed manufacturing unit in this part of world is recognized by all connected with livestock production. Presently, sir is the managing director of Krishna Flour Mills Limited, Bengaluru. He is actively engaged in restructuring this prestigious and landmark industrial unit in Bengaluru. Sir has also been designated in various positions, some of which are Director of Mysore Vegetable Oil Production Limited, Karthik Food Lines Limited, Shakti Kiran Food Private Limited. And Sir is a trustee of RV Shikshana Samiti Trust, Medha Kasturi Ranga Charitable Trust, M.K. Dattaraju Charitable Trust. Sir was the former chairman of governing committee, RV Institute of Legal Studies. Sir, we are pleased to have you here on this day. Thank you, sir.
Thank you, Chinmay. Now I request sir to deliver the presidential address.
Honorable Justice Ramon Reddy, Sri Dwarkanath Babu, Dr. C.S. Patil, Dr. G.R. Jagdish, Dr. Anjana Reddy, Dr. Evaya Vadayar, members of the faculty, delegates and my dear students. I am delighted to be a part of this wonderful seminar on right to privacy. You will all be with me when I say it has been a pleasant morning hearing Justice Ramon Reddy, who has brought so much of enthusiasm and inspiration on this most controversial, I would say, subject which is evolving, and like he rightly said, right to be alone, right to be let alone, that is the thing. And he has been such a pleasant person. In the morning when we were, before the meeting we were discussing, Dr. Patil said he has seen Justice Ramon Reddy getting angry. I wonder. Can you believe such a pleasant, ever smiling person be ever angry at all? Anyway, that is on the lighter side. You know, my parents, Nagaratnamma and Meda Kasturing Shetty, they were inspired by the activities of RV institutions at that time. And when my father was the president of the trust, the proposal to start a college at that time for women in this part of the Bangalore, but was a very, very dire necessity. And he offered to the trustees, I think there were some 25, 26 trustees, that whoever is donating a particular amount would, their name would be given to the institution which is to be set up. Unfortunately or fortunately, nobody came up, and it was my parents who funded the establishment of this NMKRV college. And why I am sharing this piece of information is I'm so proud and I'm so happy that this institution has grown so much, and this new edition of RV Institute of Legal Studies is making me even more enthusiastic the way it is progressing. And today's program, this right to privacy, has been thought of so very well, and Justice Ramon Reddy has given such a flying start, and I'm sure you will have so much of the information that he has given to cherish for a long time. I think this time travel paradox is one of the judges, I think, had said that this beautiful exposition which Justice Ramon Reddy has taken us through is very, very interesting. Thank you very much, sir. Sri Dwarkanath Babu, he has mentioned about the different dimensions to this wonderful right to privacy, which is part of the right to life. And one little thing that I wanted to add is he mentioned about the invasion of privacy by the people, especially for the celebrities. You must have heard this paparazzi. These paparazzi people, they haunt the celebrities, and like he rightly pointed out, a law is required. It is unfortunate that 3 attempts were made to bring about the legislation. We're still hoping to see something happening. And the speakers mentioned about the media, especially Dr. Justice Ramon Reddy also mentioned about the invasion of privacy, especially Google and whatnot. What I want to share is, we were told this WhatsApp is encrypted end to end, and whatever we are sending messages or receiving messages and even talking to somebody, that also can be accessed with this Pegasus software, that controversy which is looming all over. It seems, somebody told me, with that software, even that can be accessed. So, the privacy, where is the privacy now? Like you mentioned, my Google Assistant will know that I am here, being a part of this function. So, as I go home, I get a message saying that, how was your visit to NMKRV College? So, this is going too far and too much, you will all see. And as it is, we are a little extended time, and I don't want to say anything more because the speakers have covered everything. Although I had made some notes which I wanted to share with you, I think I will stop at this and let Dr. Patil and the other speakers give you a full exposition of this wonderful right to privacy. Thank you, and I thank the organizers for giving me this opportunity.
Thank you, sir, for sharing your views with us. As we have come to the end of the inaugural session, I call upon Dr. Pavitra S.T., Assistant Professor of Management, to propose the vote of thanks.
Acknowledging the good that you already have in your life is the foundation for all abundance. Thank you is the best prayer that we can offer to all those who have participated in today's inaugural program of the workshop on right to privacy, its dimension and limits. Firstly, I take this opportunity to thank the chief guest of today's inaugural program, Honorable Justice Ram Mohan Reddy, former Judge, High Court of Karnataka, for sparing his valuable time and delivering an enlightened and highly memorable address to all of us. Sir, on behalf of KILPAR, RVLS and RSST, we submit our sincere thanks to you. I request Sri M.K. Dattraj, Trustee, RSST and Member of Governing Council, RVLS, and Mr. Dwarkanath Babu, Director, KILPAR, to honor Mr. Justice Ram Mohan Reddy. Thank you, sir. I take this opportunity to thank Mr. K. Dwarkanath Babu, Director, KILPA, for delivering the keynote address and appraising all of us on the theme of the workshop. On behalf of RVLS and RSST, we submit our sincere thanks to you, sir. I also take this opportunity to thank the guests of honor, Professor Dr. C.S. Patil, Professor of Law, Head Research Center, Research in Democracy and Constitutional Government, KSLU Hubballi, and Professor Dr. G.R. Jagadish, Principal, National College of Law, Shimoga, for their presence in today's inaugural program. I thank Dr. Revaya Odiyar, Research Head, KILPAR, for giving us the brief preamble on the activities of KILPAR. Thank you, sir. I also take this opportunity to submit our sincere gratitude to Sri M.K. Dattraj, Trustee, Rashtriya Shikshana Samiti Trust, Member, the Governing Council, RVLS, for presiding over the program. On behalf of KILPAR, RVLS, we thank you very much, sir. I request our principal, Professor Dr. Anjana Reddy, to hand over a memento as token of our gratitude to Sri M.K. Dattraj. I thank Professor Dr. Anjana Reddy KR, Principal, RVLS, for his untiring efforts, continuous support and guidance in organizing this program. Thank you, sir. We thank all the invitees, special guests, well-wishers and media friends for their valuable presence in today's program. We thank all the participants for their participation in this inaugural function. On behalf of KILPAR, RVLS, and on my behalf, I thank all student volunteers and other students who were present here for their cooperation in making this program a successful one. We thank all the members of KILPAR and the teaching and administrative staff of RVLS for their coordination at each level in organizing this program. Finally, we thank each and every one of you for making this program a highly memorable one. Thank you. Have a great day.
Thank you, ma'am, and thank you all. Now we will have a tea break for about 15 minutes and we will resume back after 15 minutes to the technical session. Kindly head towards the entrance hall for the tea.
ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಒಳ್ಳೆಯದು.
I request Professor Anjana Reddy sir to escort the dignitaries to the dais. Students, kindly settle down immediately. Distinguished guests, faculty members, participants and all of you present here, a very good afternoon and warm welcome to all of you. I, Ms. Safalya Wagle, Assistant Professor of Law, RVILS, feel extremely privileged to compare the technical sessions 1 and 2 of one-day workshop on right to privacy, its dimensions and limits, organized by Karnataka Institute for Law and Parliamentary Reform, Bengaluru, and RV Institute of Legal Studies, Bengaluru. Small cheer and great welcome make a merry feast. With that being said, I feel privileged to welcome a distinguished personality, Professor Dr. G.R. Jagdish, Principal, National College of Law, Shivamogga, who will be addressing us on the topic Dimensions of Right to Privacy. Sir, on behalf of KILPAR and RVLS, I extend a warm welcome to you to this program. Welcome you, sir. It's an honor to me to welcome Professor Dr. C.S. Patil, Professor of Law, Head, Research Center, Research in Democracy and Constitutional Government, Karnataka State Law University, Hubballi, to this program. Sir will be addressing us in the second technical sessions. Sir, on behalf of KILPAR and RVLS, I extend a warm welcome to you, sir. I take this opportunity to welcome Shri K. Dwarakanath Babu, Director KILPAR, to the session. Welcome to you, sir. A warm welcome to Dr. Revaya Odeyar, Research Head, KILPAR, to the session. Welcome to you, sir. It's my privilege to welcome the delegates of RSST, Bengaluru, to the session. I extend a hearty welcome to our beloved principal of RVLS, Professor Dr. Anjana Reddy KR, to the session. Lastly, I also welcome all the faculty members, participants from various institutions, and one and all present here to the sessions. May I now request Ms. Sanjana, student of first semester BA LLB, to introduce our resource person to the gathering.
Good day, everyone. My name is Sanjana Naidu from first semester BA LLB, and it is my honor to introduce a person as remarkable as you, sir. Professor Dr. G.R. Jagdish was born on 7 February 1963 at Channagiri of Davangere district of Karnataka state, where he completed his school education. Sir graduated from Sir M.V. College, Bhadravati, and Tunga First Grade College, Tirthahalli, where he obtained his BSc degree from University of Mysore. Professor Jagdish pursued his studies in law at National College of Law, Shivamogga, where he completed his LLB. He obtained his master's degree from Law LLM from University of Mysore, specializing in constitutional law. Sir was awarded PhD by Kuvempu University for his research thesis titled Constitutional Framework and Legal Structure Governing Panchayat Raj Institutions, a study of decade experience in the district of Shivamogga of Karnataka state. Sir is presently the principal of CBR National College of Law and Center for Postgraduate Studies in Law, Shivamogga. Sir has also been designated with various positions, such as Vice Chancellor, Karnataka State Law University, in the capacity of Dean from January 2013 to February 2013. Chairman Expert Committee to recommend unaided colleges for grants, Government of Karnataka, Bangalore. Dean of Kuvempu University from 2009 to 2010. Dean of KSLU from June 2012 to July 2013. He's been Chairman of Local Inspection Committee for Affiliation, Chairman for Board of Postgraduate Studies, Board of Studies Undergraduate, Board of Examiners at Kuvempu University, KSLU. He was also the member or chairman of local inspection committees for affiliation of more than 50 law colleges in the state of Karnataka. Honorary Secretary and later President of the NES Building House Cooperative Society, Shivamogga, where he served for 16 years. He was a member of the Board of Appointment of Examiners and also the Chairman of Board of Examiners thrice, and he was also in the Anti-Malpractice Examination Squad. In fact, Sir has been Chairman of Malpractice Consideration Committee of Karnataka State Law University. He's also been at the Academic Council member at Kuvempu University. Sir has authored 4 books, to name a few: Need for Legal Reforms in Legal Education and Legal Education. In 2021, Sir was awarded as the Best Principal. We are honored to have you here today, sir.
Thank you, Sanjana. I now humbly request Professor Dr. G.R. Jagdish to take over the session. Over to you, sir.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ಸಮಾರಂಭದಲ್ಲಿ ಇವತ್ತು ಈ ಅಧಿವೇಶನದ ಅಧ್ಯಕ್ಷತೆ ವಹಿಸಿರ್ತಕ್ಕಂಥ ಕರ್ನಾಟಕ ಕಾನೂನು ಸುಧಾರಣಾ ಸಂಸ್ಥೆಯ ಮುಖ್ಯಸ್ಥರಾಗಿರ್ತಕ್ಕಂಥ ದ್ವಾರಕನಾಥ್ ಬಾಬು ಸರ್ ಅವರೇ, ನನ್ನ ಸ್ನೇಹಿತ ಪ್ರೊಫೆಸರ್ CS ಪಾಟೀಲ್ ಅವರೇ, ಪ್ರೀತಿಯ ವಿದ್ಯಾರ್ಥಿ ಮಿತ್ರರೇ, ಮತ್ತು ನಿಮ್ಮ ಎಲ್ಲ ಗುರುಗಳು ಮತ್ತು ನನ್ನ ಸ್ನೇಹಿತರಾಗಿರ್ತಕ್ಕಂಥ ಅಂಜನಾ ರೆಡ್ಡಿ ಮತ್ತು ಅವರ ಕೊಲೀಗ್ಸೇ, ಸಾಕಷ್ಟು ವಿಚಾರಗಳನ್ನು ಜಸ್ಟಿಸ್ ರಾಮಮೋಹನ್ ರೆಡ್ಡಿ ಅವರು ಜೊತೆಗೆ ಕಿಲ್ಪಾರ್ನ ಮುಖ್ಯಸ್ಥರಾದಂಥ ದ್ವಾರಕನಾಥ್ ಬಾಬು ಅವರು ಹಾಗೂ ದತ್ತರಾಜ್ ಸರ್ ಅವರು ಈ ವಿಚಾರದಲ್ಲಿ ಏನು ಖಾಸಗಿತನದ ಪರಿಕಲ್ಪನೆ ಅನ್ನೋ ವಿಚಾರನ ಇಟ್ಟಿದ್ದಾರೆ. ನಮ್ಗೆ ಭಾಳ ಕಡಿಮೆ ವಿಚಾರವನ್ನು ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ. ದೇ ಹ್ಯಾವ್ ಬಿಕಮ್ ರಿಸೋರ್ಸ್ ಪರ್ಸನ್ಸ್ ಆ್ಯಂಡ್ ವಿ ಆರ್ ಗೆಸ್ಟ್ ಆಫ್ ಆನರ್. ನಥಿಂಗ್ ಮೋರ್ ಯು ಹ್ಯಾವ್ ಟು ಸ್ಪೀಕ್ ಅಂತ. ಸೊ ಈ ಕಾಂಟೆಕ್ಸ್ಟಲ್ಲಿ ಏನು ಮಾಡ್ಬೋದು ಅಂತೇಳಿದರೆ, ಈ ಖಾಸಗಿತನ ಅಂತಕ್ಕಂಥದ್ದು ವ್ಯಕ್ತಿಗೆ ಯಾವ ರೀತಿ ಹೆಚ್ಚಿನ ಪ್ರಾಮುಖ್ಯತೆ ಪಡೀತು ಅಂತೇಳಿದರೆ, 2017ರಲ್ಲಿ ಏನು ಜಸ್ಟಿಸ್ ಪುಟ್ಟಸ್ವಾಮಿಯವರು, ಕರ್ನಾಟಕದವರೇ, ರಿಟೈರ್ಡ್ ಜಸ್ಟಿಸ್ ಅವರು ಒಂದು ಪ್ರಶ್ನೆ ಮಾಡ್ತಾರೆ. ಏನು ನಾವುಗಳೆಲ್ಲ ಆಧಾರ್ ಕಾರ್ಡಿಗೆ 10 ಬೆರಳನ್ನು ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀವಿ, ಆ ಸ್ಕ್ಯಾನ್ ಮಾಡಿ ತೊಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅದು ಸರ್ಕಾರ ಮಾಡ್ತಾ ಇದೆ, ನಾವೇನು ಸುಮ್ಮನೆ ಕೊಟ್ಬಿಟ್ವಿ ನಮಗೊಂದು ಕಾರ್ಡ್ ಸಿಕ್ತಲ್ಲ ಅಂತ. ಆದರೆ ಏನು ತಮ್ಮ ಮ್ಯಾನೇಜ್ಮೆಂಟಿನ ದತ್ತರಾಜ್ ಹೇಳ್ದಾಗೆ, ನಾವು ಇವತ್ತು ಇಲ್ಲಿ ಬಂದಿದ್ವಿ ಅನ್ನೋದು ನಮಗೆ ರಿಪೋರ್ಟು ನೆಕ್ಸ್ಟ್ ಮಂತಲ್ಲಿ ನನ್ನ ಗೂಗಲಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿ ಹೋಗಿದ್ದೆ ಎಲ್ಲ ಬಂದ್ಬಿಡುತ್ತೆ. ನಿಮ್ಮ ಪ್ರಿನ್ಸಿಪಾಲ್ರು ನನ್ನ ಪಾಡಿಗೆ ಬಿಟ್ಟು ನಾನು ಬರ್ತೀನಿ ಅಂದರೆ ಕೇಳಲಿಲ್ಲ, ಇಲ್ಲ ನೀವು ಟ್ರೈನಲ್ಲಿ ಬನ್ನಿ ಅಂತ ರಿಸರ್ವ್ ಮಾಡಿಸ್ಬಿಟ್ರು. ನನ್ನ ಮೊಬೈಲ್ ಇಟ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀನಿ ಅಂದರೆ ನಾನು ಆಗ ಬಂದಿದ್ದೀನಿ, ಇಲ್ಲಿಗೆ ಬಂದಿದ್ದೀನಿ, ಸರ್ ಜೊತೆಗಿದ್ದೀನಿ, ಎಲ್ಲದೂ ಸಿಂಕ್ ಆಗತ್ತೆ. ನಾನು ಕ್ರೆಡಿಟ್ ಕಾರ್ಡು ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ, ಡೆಬಿಟ್ ಕಾರ್ಡ್ ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ, ನನ್ನ ಮೊಬೈಲ್ ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ, ಎಲ್ಲೆಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದೀವಿ ಅನ್ನೋದೆಲ್ಲ ನಮ್ಮ ಇನ್ಫಾರ್ಮೇಷನ್ನು ಆಟೋಮೆಟಿಕಲಿ ರಿವೀಲ್ ಆಗ್ತಾ ಇದೆ. ಹಾಗಾಗಿ ಈಗ ಬರ್ತಾ ಇರ್ತಕ್ಕಂಥ ಯುಗ ಅಂದರೆ ಮೆಟಾವರ್ಸ್. ನಮ್ಮೆಲ್ಲ ಡಾಟಾ ಇನ್ಫಾರ್ಮೇಷನ್ನು ಬಹಿರಂಗಗೊಳ್ತಾ ಇದೆ. ನಾನದೇ ವೆರಿ ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಮೇಷ್ಟ್ರುಗಳಿಗೆ ರೈಟ್ ಟು ಪ್ರೈವೇಸಿ ಅನ್ನೋದೇ ಇಲ್ಲ, ನಾವೇನು ಸೆಲೆಬ್ರಿಟಿಗಳಲ್ಲ. ಆದರೆ ಇಲ್ಲಿ 100 ಜನ ವಿದ್ಯಾರ್ಥಿಗಳಿದ್ದಾರೆ ಅಂದರೆ 200 ಕಣ್ಣು ನಮ್ಮನ್ನು ನೋಡ್ತಾ ಇರುತ್ತೆ ಅಂತ. ವಿ ಆರ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ಅವರ್ ಓನ್ ಲೆಟ್ ಟು ಬಿ ಅಲೋನ್. We are meant for that. We have to say something related to this, what the concept of privacy, how it developed. ಏನು ರಾಜಮೋಹನ್ ಸರ್ ತಿಳಿಸಿದಾಗೆ, ವಾರನ್ ಆ್ಯಂಡ್ ಬ್ರ್ಯಾಂಡೀಸ್ ಇವರಿಬ್ಬರು ಅವರ ಒಬ್ಬ ಬ್ರದರ್ನ ಸೇಫ್ ಗಾರ್ಡ್ ಮಾಡೋದಕ್ಕೋಸ್ಕರನೇ ಪೇಪರ್ಗೆ ಆರ್ಟಿಕಲ್ಸನ್ನು ಬರಿತಾ ಬರ್ತಾರೆ. ಯಾಕಂದರೆ ಅವತ್ತಿನ ದಿನ ಈ ಹೋಮೋಸೆಕ್ಷುಯಾಲಿಟಿ ಅನ್ನೋದು ಅಫೆನ್ಸ್. ಪ್ರೆಸ್ ಅವ್ರು ಹುಡುಕ್ತಾ ಇದ್ರು ಯಾವ ಥರ ರಿಚ್ ಮ್ಯಾನ್ಸ್ದು ಡಾಂಕಿ ಇಂಜುರಿ ಆಗಿದೆ ಅನ್ನೋ ರೀತಿಯಲ್ಲಿ, ಇಂಥವನೊಬ್ಬ ಹೋಮೋಸೆಕ್ಷುವಲ್ ಇದ್ದಾನೆ ಅನ್ನೋದು ಭಾಳ ಕನ್ವಿಕ್ಷನ್ ಆಗಿ ನೋಡ್ತಾ ಇದ್ರು. ಅವನಿಗೆ ಪನಿಷ್ಮೆಂಟ್ ಮಾಡೋದನ್ನು ಭಾಳ ದೊಡ್ಡ ವರ್ಣರಂಜಿತವಾಗಿ ವೈಭವೀಕರಿಸಿ ಪೇಪರಿಗೆ ಬರೀತಾ ಇದ್ರು. ಬೆಂಗಳೂರವರೇ ರಾಹುಲ್ ಮತ್ತನ್ ಹ್ಯಾಸ್ ರಿಟನ್ ಎ ವಂಡರ್ಫುಲ್ ನಾವೆಲ್, ಪ್ರೈವೇಸಿ ಬುಕ್. ಒಂಥರ ಎಲ್ಲ ಮಿಕ್ಸ್ ಇದೆ ಅದರಲ್ಲಿ. ಪ್ರೈವೇಸಿ 3.0 ಓದಿದರೆ ಎಲ್ಲರಿಗೂ ವಿಚಾರ ತಿಳಿಯತ್ತೆ. ನಾವು ಮಾಡೋದು ಲೀಗಲ್ ಅನಾಲಿಸಿಸ್. ನಮ್ಮ ಇಂಡಿಯಾದಲ್ಲಿ ನಾವು ತೆಗೆದುಕೊಂಡ್ರೆ 2 ಆ್ಯಂಗಲಲ್ಲಿ, ಸರ್ 3 ಆ್ಯಂಗಲಲ್ಲಿ ಇನ್ವೇಷನ್ ಆಗತ್ತೆ ಅನ್ನೋದನ್ನು ಹೇಳಿದರು. ನಾವು ಟ್ಯಾಕಲ್ ಮಾಡ್ತಕ್ಕಂಥದ್ದು ಕೋರ್ಟ್ ಆಫ್ ಲಾದಲ್ಲಿ ಒಂದು ಟ್ರೆಡಿಷನಲ್ ಟಾರ್ಟ್ ಆಗಿ ನೋಡ್ತೀವಿ. ಪ್ರೈವೇಸಿ ಆಸ್ ಸಚ್ ಅದಕ್ಕೆ ವಯಲೇಟ್ ಆದರೆ ಕಾಮನ್ ಲಾ ರೆಮಿಡೀಸ್ ಏನಿದೆ, ಟಾರ್ಟ್ ರೆಮಿಡೀಸ್ ಏನಿದೆ ಅಂತ ಒಂದು ಆ್ಯಂಗಲಲ್ಲಿ ನೋಡ್ತೀವಿ. ಈಗ ಜಸ್ಟಿಸ್ ಪುಟ್ಟಸ್ವಾಮಿ ಅವ್ರ ಕೇಸನ್ನು ನಾವು ತೆಗೆದುಕೊಂಡಾಗ 2ನೇ ಆ್ಯಂಗಲ್ಲು, ನಮ್ಮ ಮಾಹಿತಿ ಸರ್ಕಾರದ ಹತ್ರ ಇದೆ, ಅದು ಯಾವ ರೀತಿ ಬಹಿರಂಗಗೊಂಡು ನಮ್ಮ ಅಸ್ತಿತ್ವದ್ದೇ ಪ್ರಶ್ನೆ ಬರೋದು ರೀತಿಯಲ್ಲಿ ಆಗತ್ತದು. ದಟ್ಸ್ ದಿ ಸೆಕೆಂಡ್ ಪಾರ್ಟ್, ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಪರ್ಸ್ಪೆಕ್ಟಿವ್ ಆಫ್ ದಿಸ್ ವೆರಿ ಪ್ರೈವೇಸಿ ರೈಟ್. ಸೊ ಈ ಬ್ಯಾಕ್ಗ್ರೌಂಡಲ್ಲಿ ಸರ್ ತಿಳಿಸಿದಾಗೆ ಯೂನಿವರ್ಸಲ್ ಡಿಕ್ಲರೇಷನ್ ಆಫ್ ಹ್ಯೂಮನ್ ರೈಟ್ಸಲ್ಲಿ ಇದ್ರ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ಇದೆ. ಹಾಗೆ ಕೋವೆನೆಂಟ್ ಆನ್ ಸಿವಿಲ್ ಆ್ಯಂಡ್ ಪೊಲಿಟಿಕಲ್ ರೈಟ್ಸ್ ಬಗ್ಗೆ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಇದರಲ್ಲೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ. ಇಷ್ಟೆಲ್ಲ ಇದ್ದರೂ ನಮ್ಮ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆಫ್ ಪ್ರೈವೇಸಿ ಏನಿದೆ ಇದು ವೇರಿ ಆಗತ್ತೆ. ಒಬ್ಬರಿಗೆ ಪ್ರೈವೇಸಿ ಅನ್ನೋದು ಇನ್ನೊಬ್ಬರಿಗೆ ಅಲ್ಲ ಅನಿಸ್ಬೋದು. ಅದು ಈ ಕಾಂಟೆಕ್ಸ್ಟಲ್ಲಿ ಇದಕ್ಕೊಂದು ಸ್ಪಷ್ಟವಾದ ರೂಪರೇಷೆಗಳನ್ನು ಕೊಡೋ ಒಂದು ಪ್ರಯತ್ನ ತುಂಬ ಕೇಸ್ಗಳಲ್ಲಿ ನಡೀತು. ಪ್ರಾರಂಭದಲ್ಲಿ 20 ಕ್ಲಾಸ್ 3 MP ಸತೀಶ್ ಚಂದ್ರ ವರ್ಸಸ್ ಶರ್ಮಾ ಕೇಸ್ ಇಲ್ಲಿ ಅಂದ್ರಲ್ಲ, ಸೊ ಅಲ್ಲಿ ಈ ವಿಚಾರದ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಈ ಇನ್ಕ್ರಿಮಿನೇಟಿಂಗ್ ಅಂತ ಹೇಳಿದರೆ ಪ್ರೈವೇಸಿ ಅಲ್ಲಿ ಹೊರಗೆ ಬರುತ್ತೆ ಅಂತ. ರೈಟ್ ಎಗನೆಸ್ಟ್ ಸೆಲ್ಫ್ ಇನ್ಕ್ರಿಮಿನೇಷನ್ ದಟ್ ಈಸ್ ನಾಟ್ ಅಡ್ಮಿಸಬಲ್ ಇನ್ ದ ಕೋರ್ಟ್ ಆಫ್ ಲಾ ಅಂತ ಭಾಳ ಸ್ಪಷ್ಟವಾಗಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಸ್ಟೇಟಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಬಟ್ ದೆರ್ ವರ್ ಸಮ್ ಅಟೆಂಪ್ಟ್ಸ್. ನಂತರ ಏನು ಸರ್ ಕೋರ್ಟ್ ಮಾಡಿದ ಕರಕ್ ಸಿಂಗ್ ಕೇಸ್ ಹೇಳಿದರು, ಅಲ್ಲಿ ಪೊಲೀಸ್ ರೆಗ್ಯುಲೇಷನ್ ಆಫ್ ಹ್ಯಾವಿಂಗ್ ಸಮ್ ಸರ್ವೆಲೆನ್ಸ್. ಕರಕ್ ಸಿಂಗ್ ಮೇಲೆ ಡಕಾಯಿತಿ ಮಾಡಿದ್ದಾನೆ, ರಾಬರಿ ಮಾಡಿದ್ದಾನೆ ಅನ್ನೋ ಆಪಾದನೆ ಇದೆ. ಬಟ್ ಸಫಿಷಿಯೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲದೆ ಇರೋದ್ರಿಂದ ಅವನ ಮೇಲೆ ಯಾವುದೂ ಗಿಲ್ಟ್ ಪ್ರೂವ್ ಆಗಲ್ಲ. ಆದರೂ ಪೊಲೀಸು ಒಂದು ಕಣ್ಣಿಟ್ಟಿರ್ಬೇಕು ಇವನ ಮೇಲೆ ಅಂತೇಳಿ ಸರ್ವೆಲೆನ್ಸ್ ಮಾಡ್ತಾಯಿದ್ರು. ನಾವು 1988ರಲ್ಲಿ USSR ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಓದಬೇಕಾದ್ರೆ ಅಲ್ಲಿ ಪ್ರಾವಿಷನ್ ಅಲ್ಲಿ ಹೇಗೆ ನಡೆದಿದೆ ಅನ್ನೋದು ಎಲ್ಲರೂ ಸಸ್ಪೆಕ್ಟ್ ಮಾಡೋದು. ಪ್ರೊಕ್ಯುರೇಟರಲ್ ಜನರಲ್ ಸಿಸ್ಟಮಲ್ಲಿ ಸರ್ವೆಲೆನ್ಸ್ ಅನ್ನೋದು ಕಂಟಿನ್ಯೂಸ್ ಆಗಿದೆ. ಈಗ ಇಂಡಿಯಾದಲ್ಲಿ ನಿಜ ಆಗಿದೆಯೇನೋ ಅನ್ನೋ ಮಟ್ಟಕ್ಕೆ ಆಗಿದೆ. ಆ ಸರ್ವೆಲೆನ್ಸನ್ನು ಕ್ವಶನ್ ಮಾಡ್ತಾರೆ, ವೆದರ್ ದೀಸ್ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಆರ್ ಇನ್ವೇಡಿಂಗ್ ದ ಪ್ರೈವೇಸಿ ಆಫ್ ದಟ್ ಕಾಮನ್ ಮ್ಯಾನ್ ಹೂ ಈಸ್ ವಿಸಿಟಿಂಗ್ ಹಿಸ್ ಹೌಸ್ ಆ್ಯಂಡ್ ವೇರ್ ಅಬೌಟ್ಸ್ ಅಟ್ ದ ಲೇಟ್ ಈವ್ನಿಂಗ್ ಅವನ ಮನೆ ಬಾಗಿಲು ತಟ್ಬಿಟ್ಟು ಇದೆಯಾ ಇಲ್ವಾ ಎಲ್ಲೋಗಿದೆಯಾ ಅನ್ನೋದು ವಿಚಾರಣೆ ಮಾಡ್ತಾಯಿದ್ರು. ವೆನ್ ಯು ಕ್ವಶನ್ ದ ರೆಗ್ಯುಲೇಷನ್ ದೇ ಸೆಡ್ ದಿಸ್ ರೈಟ್ ಟು ಲೈಫ್ ಅನ್ನೋದು ಆರ್ಟಿಕಲ್ 21 ಬಿಟ್ಟು ಹೊರಗೆ ಹೋಗಲ್ಲ. ಆದರೆ ಈ ಪೊಲೀಸ್ ರೆಗ್ಯುಲೇಷನ್ಸು ಯಾವಾಗ ಎಕ್ಸೆಸಿವ್ ಆಗ್ತದೆ ದೆನ್ ಇಟ್ ಈಸ್ ಇನ್ವೇಡಿಂಗ್ ದ ಪ್ರೈವೇಸಿ ಆಫ್ ದಟ್ ವೆರಿ ಪರ್ಸನ್ ಅಂತೇಳಿ ಅಷ್ಟೇಳಿ ಬಿಟ್ಬಿಡ್ತಾರೆ. ನಾವು ಗೋವಿಂದ್ ವರ್ಸಸ್ ನೆಕ್ಸ್ಟ್ ಬರ್ತಕ್ಕಂಥದ್ದು ಗೋವಿಂದ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಮಧ್ಯಪ್ರದೇಶಲ್ಲಿ ಸೀರಿಯಸ್ ಕ್ರೈಮ್ಸನ್ನು ತಡೆಗಟ್ಟಲಿಕ್ಕೆ ಪೊಲೀಸ್ ಕ್ಯಾನ್ ಹ್ಯಾವ್ ಸಚ್ ಎ ರೈಟ್ ಆಫ್ ಮೇಕಿಂಗ್ ಸರ್ವೆಲೆನ್ಸ್ ಅಂತೇಳಿ ಅಪೋಲ್ಡ್ ಮಾಡ್ತಾರೆ. ಬಟ್ ರೈಟ್ ಟು ಲೈಫಲ್ಲಿ ಪ್ರೈವೇಸಿ ಅನ್ನೋದು ಇದು ಅಂತ ಫಸ್ಟ್ ಟೈಮ್ ಒಪ್ಕೊಳ್ತಾರೆ. ನಮ್ಮ ಟ್ರ್ಯಾಜಿಡಿ ಏನಂದರೆ ಇಂಡಿಯಾದ್ದು ನಾವು ಕ್ರಿಟಿಸೈಸ್ ಮಾಡೋ ವಿಚಾರ ಇಲ್ಲಿ. ನಮ್ಮ ಜಡ್ಜಸ್ಸು ಅಮೆರಿಕಾದಲ್ಲಿ ಏನಾಗ್ತಾ ಇದೆ, ಇಂಗ್ಲೆಂಡಲ್ಲಿ ಏನಾಗ್ತಾ ಇದೆ ಅಂತ ಕಾಯ್ತಾ ಕೂತಿರ್ತಿದ್ರು. ಅಂದರೆ ಅಲ್ಲಿ ಡಿಸಿಷನ್ ಆದ ಬೇಸಿಸ್ ಮೇಲೆ ನಮ್ಮ ಡಿಸಿಷನ್ಸ್ಗಳು ಇಲ್ಲಿ ಆಗ್ತಾ ಇತ್ತು. ಅಷ್ಟೊತ್ತಿಗೆ ಅಲ್ಲಿ ಕನೆಕ್ಟಿಕಟ್ ಕೇಸ್ ಆಗಿತ್ತು, ರೋ ವರ್ಸಸ್ ವೇಡ್ ಕೇಸ್ ಆಗಿತ್ತು. ಹಾಗಾಗಿ ನಂತರದ ಕೇಸಲ್ಲಿ ನಮಗೆ ಐಡಿಯಾ ಸಿಕ್ತಲ್ಲ, ಬೇಸಿಸ್ ಸಿಕ್ತಲ್ಲ ಅಂತೇಳ್ಬಿಟ್ಟು they also started incorporating this idea of privacy into the concept of life and personal liberty under the constitution. ಎಮರ್ಜೆನ್ಸಿ ಮುಗಿಬೇಕಾಯ್ತು ನಮ್ಮ ಜಡ್ಜಸ್ಗೆ ಒಂದು ಸ್ವಲ್ಪ ಲಿಬರಲ್ ಅಪ್ರೋಚ್ ಬರೋಕ್ಕೆ. 25 ವರ್ಷ ರೈಟ್ ಟು ಪ್ರೈವೇಸಿ ಅನ್ನೋದನ್ನು ಯಾರು ಗಟ್ಸಲ್ಲಿ ಭಾಳ ಸ್ಪಷ್ಟವಾಗಿ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮಾಡಲಿಕ್ಕೆ ಧೈರ್ಯನೇ ಬರಲಿಲ್ಲ. ಎಮರ್ಜೆನ್ಸಿ ಮುಗೀತು, 18 ತಿಂಗಳು ಎಮರ್ಜೆನ್ಸಿ ಮುಗಿದ್ಮೇಲೆ ದೆನ್ ಇನ್ ಮೇನಕಾ ಗಾಂಧಿ ವರ್ಸಸ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾದಲ್ಲಿ ಈ ರೈಟ್ ಟು ಲೈಫ್ ಮತ್ತು ಪರ್ಸನಲ್ ಲಿಬರ್ಟಿ ಅನ್ನೋ ಕಾನ್ಸೆಪ್ಟ್ಸ್ಗಳೇನಿದೆಯಲ್ಲ ಇದು ಅದಕ್ಕೆ ಒಂದು ಅರ್ಥ ಇದೆ. ಆ ಲೈಫ್ ವಿತೌಟ್ ದಿಸ್ ಪ್ರೈವೇಸಿ ಈಸ್ ನಾಟ್ ಮೀನಿಂಗ್ಫುಲ್, ಈಸ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ಎನಿ ಮೀನಿಂಗ್ ಅಟ್ ಆಲ್ ಅನ್ನೋ ಮಟ್ಟಕ್ಕೆ ದೇ ಸ್ಟಾರ್ಟೆಡ್ ಇಂಟರ್ಪ್ರಿಟಿಂಗ್. ಅಂದರೆ ನಮಗೆ ಡ್ಯೂಟಿ ಫ್ರೀ ಐಡಿಯಾ ಬರೋ ತನಕ ಕಾಯ್ತಾ ಇದ್ವಿ ನಾವು ಲೀಗಲ್ ಅನಾಲಿಸಿಸ್ ಆಫ್ ದಿಸ್ ವೆರಿ ರೈಟ್ ಟು ಪ್ರೈವೇಸಿ ಅಂತ ಒಂದು ಅಸೆಸ್ ಮಾಡಲಿಕ್ಕೆ. ನಂತರದ ನಾವು ಈ ಬೆಳವಣಿಗೆಗಳನ್ನು ಕಾನ್ಸೆಪ್ಚುವಲೈಸ್ ಮಾಡೋದಾದರೆ ವಿ ಹ್ಯಾವ್ ಟು ಅಸೆಸ್ ಈವನ್ ಹೌ ದಿ ಜುಡಿಷಿಯರಿ ಹ್ಯಾಸ್ ಮೇಡ್ ದಿಸ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಇನ್ ದಿ post 1978 onwards. Till that the concept of privacy was never given any due importance in the judicial history here. Maybe this very ಏನು ಬೇರೆ ಬೇರೆ ಬ್ಲ್ಯಾಕ್ ಸ್ಟೋನ್ದು ಎಕ್ಸಾಂಪಲ್ ಕೊಟ್ಟರು, ಹಾಗೆ ಆಕ್ಸ್ಫರ್ಡ್ ಡಿಕ್ಷನರಿಯವರು ಇದ್ರ ಬಗ್ಗೆ ಎಲ್ಲ ಒಂದು ವ್ಯಾಖ್ಯಾನ ಅಥವಾ ಇಂಟರ್ಪ್ರಿಟೇಷನನ್ನು ಮೀನಿಂಗನ್ನು ಕೊಡೋಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ನಮ್ಮ ಜನ ಯಾವ್ಯಾವ ರೀತಿ ಡೈವರ್ಸಿಟಿ ಇದೆ, ಐದರ್ ಕಾಮನ್ ಲಾ ಟ್ರೆಡಿಷನಲ್ಲಿ ಇರ್ಬೋದು, ಕಸ್ಟಮರಿ ಪ್ರಾಕ್ಟೀಸಸಲ್ಲಿ ಇರ್ಬೋದು, ಅಥವಾ ನಮ್ಮ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಪ್ರಾವಿಷನ್ಸ್ ಬ್ಯಾಕ್ಗ್ರೌಂಡಲ್ಲಿ ನಾವು ಈ ರೈಟ್ ಟು ಪ್ರೈವಸಿಯನ್ನು ಕಾನ್ಸೆಪ್ಚುಯಲೈಸ್, ಅದರ ಪರಿಕಲ್ಪನೆ ಏನು ಮತ್ತು ಅದರ ಆಯಾಮ ಏನು ಅಂತ ನೋಡ್ತಾ ಹೋಗ್ತೀವಿ. ಇದು ಆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಪರ್ಸನಲ್ ಲಿಬರ್ಟಿ ಅಂತ ನಾವು ಸಾಧ್ಯ ಮಾಡಿದ್ದು. ಬಟ್ ರೈಟ್ ಟು ಲೈಫಲ್ಲಿ ಈ ಪ್ರೈವಸಿ ಇಲ್ಲ ಅನ್ನೋ ಮಟ್ಟಕ್ಕೆ ನಾವು ADM ಜಬ್ಬಲ್ಪುರ್ ವರ್ಸಸ್ ಶಿವಕಾಂತ ಶುಕ್ಲಾ ಅಂತ ಎಮರ್ಜೆನ್ಸಿ ಟೈಮಲ್ಲಿ ಒಂದು ಕೇಸ್ ಡಿಸೈಡ್ ಆಗ್ತದೆ. ಎಂಥ ಟ್ರ್ಯಾಜಿಡಿ ಅಂದರೆ, ಎಮರ್ಜೆನ್ಸಿ ಆದಾಗ ನೀವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬಾಗಿಲು ತಟ್ಟಕ್ಕಾಗಲ್ಲ, ನಿಮಗೆ ರೆಮಿಡಿ ಕೊಡೋಕ್ಕಾಗಲ್ಲ, ನಿಮ್ಮ ಪರ್ಸನಲ್ ಲಿಬರ್ಟಿ ಡಿಟೈನ್ ಆದರೆ ನೀವು ಎಮರ್ಜೆನ್ಸಿ ಆದಮೇಲೆ ಬನ್ನಿ ಅನ್ನಂಗೆ ಕೊಡ್ತಾರೆ. ಯಾರು? ಚಂದ್ರಚೂಡ್. ಈಗ ಅದನ್ನು ಸೆಟ್ರೈಟ್ ಮಾಡಿ ಅಪ್ಪ ಸರಿಗೆ ಬರ್ದಿಲ್ಲ ಅಂತೇಳಿ ಅವ್ರ ಮಗ ಚಂದ್ರಚೂಡು ಲಿಬರಲ್ಲಾಗೆ ಪುಟ್ಟಸ್ವಾಮಿ ಕೇಸಲ್ಲಿ ಬರೀತಾರೆ. ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಡಿಸ್ಪೆನ್ಸ್ಡ್. We will overrule that ADM Jabalpur Shivakanta Shukla principle as well as MP Sharma versus Satish Chandra. So this is what the rational approach adopted by the younger judges. ಅವತ್ತಿನ ಜಡ್ಜಸ್ಗೆ ಟ್ರೆಡಿಷನಲ್ ಆರ್ಥೋಡಾಕ್ಸ್ ಅಂಡ್ ರಿಜಿಡ್ ಮೈಂಡ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ ಲೈಫ್ ಅಂಡ್ ಪರ್ಸನಲ್ ಲಿಬರ್ಟಿ. ಮೇ ಬಿ ಈ ಕಾಂಟೆಕ್ಸ್ಟಲ್ಲಿ ನಾವು ಸೋರ್ಸಸ್ಸನ್ನು ನಾನು ಹೇಳ್ದಾಗೆ ಐದರ್ ಕಾಮನ್ ಲಾ ಸೋರ್ಸಸ್ಸನ್ನು ನಾವು ನೋಡ್ತೇವೆ ಅಥವಾ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಇದರಲ್ಲಿ ನೋಡ್ತೇವೆ ಪರ್ಸನಲ್ ಲಿಬರ್ಟಿ ಬಗ್ಗೆ. ಇದ್ರ ಜೊತೆಗೆ ಸುಮಾರು ಲೆಜಿಸ್ಲೇಷನ್ಸನ್ನು ನಾವು ಬಿಫೋರ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕಮಿಂಗ್ ಇನ್ ಟು ಫೋರ್ಸ್ ವಿ ಹ್ಯಾವ್ ಎನ್ಯಾಕ್ಟೆಡ್. ಆ ವಿಚಾರದಲ್ಲಿ ಇನ್ಫ್ಯಾಕ್ಟ್ ಅಕೌಂಟಬಿಲಿಟಿ ವಿಚಾರದಲ್ಲಿ ಪ್ರೊಫೆಸರ್ CS ಪಾಟೀಲ್ ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಯಾವಾಗ ಇನ್ವೇಷನ್ ಆಫ್ ಪ್ರೈವೇಸಿ ಆಗತ್ತೆ ಅದಕ್ಕೆ ಟಾಟ್ ಲಾ ರೆಮಿಡಿ ಎಲ್ಲ ಅಥವಾ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ರೆಮಿಡಿ ಏನು ಅಂತ ನಮ್ಗೆ ಸಾಧ್ಯ ಆಗತ್ತಾ ಅಂತ. ನೋಡಿ, ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಬಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದರು. ಸರ್ಚ್ ಆ್ಯಂಡ್ ಸೀಸರ್ ಏರಿಯಾ ಇರ್ಬೋದು. ಇಂಡಿಯನ್ ಪೀನಲ್ ಕೋಡಲ್ಲೂ ನಾವು ಕೆಲವು ವಿಚಾರಗಳನ್ನು ಈ ಬಗ್ಗೆ ಮಾಡಿದ್ದೀವಿ. ಆಮೇಲೆ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟ್ 1872 ಅಲ್ಲಿ ಫಾರ್ ಇನ್ಸ್ಟೆನ್ಸ್ ದೋಸ್ ಹೂ ಆರ್ ಸ್ಟಡಿಡ್ ದಿಸ್ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟ್ ಸೆಕ್ಷನ್ 122 ಅಲ್ಲಿ ಪ್ರಿವಿಲೇಜ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿ ಕಮ್ಯುನಿಕೇಷನ್ ಬಿಟ್ವೀನ್ ದ ಹಸ್ಬೆಂಡ್ ಆ್ಯಂಡ್ ವೈಫ್. ಅವ್ರ ಬೆಡ್ರೂಮಲ್ಲಿ ಏನು ಮಾತಾಡಿದ್ರು ಅದನ್ನು ಯಾರು ಯಾವ ಕೋರ್ಟಲ್ಲೂ ಎವಿಡೆನ್ಸ್ ಆಗಿ ಪ್ರಶ್ನೆ ಮಾಡಿ ಹೊರಗೆ ತೆಗಿಯಕ್ಕೆ ಬರಲ್ಲ. ನೋಡಿ, 1872 ಅಲ್ಲಿ ಅದ್ರ ಬಗ್ಗೆ ನಮಗೆ ಕಾಮನ್ ಲಾ ಪ್ರಿನ್ಸಿಪಲ್ಸನ್ನು ನಾವು ಲಾ ಆಗಿ ಕನ್ವರ್ಟ್ ಮಾಡಿ ಇಟ್ಕೊಂಡಿದ್ದೀವಿ. ಸೆಕ್ಷನ್ 122 ಆಫ್ ದಿ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟ್. ನಮಗೆ ಭಾಳ ಪೆಟ್ಕೊಟ್ಟಿದ್ದು ಅಂತೇಳಿದರೆ ಇಂಡಿಯನ್ ಟೆಲಿಗ್ರಾಫ್ ಆ್ಯಕ್ಟ್ 1885. ಈ ಟೆಲಿಫೋನ್ ಟ್ಯಾಪಿಂಗ್ ಇರ್ಬೋದು ಅಥವಾ ಟೆಲಿಗ್ರಾಫ್ ವಿಚಾರದಲ್ಲಿರ್ಬೋದು, ಅಲ್ಲಿ ಸೆಕ್ಷನ್ 5 ಅನ್ನೋದು ಯಾವಾಗ ಬೇಕಾದರೂ ನಮ್ಮ ಏನು ಕಮ್ಯುನಿಕೇಷನನ್ನು ಸರ್ಕಾರ ಇಂಟರ್ಸೆಪ್ಟ್ ಮಾಡ್ಬೋದು ಅನ್ನೋದಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಇದೆ ಅಲ್ಲಿ. ಆ ಟೆಲಿಗ್ರಾಫ್ ಆ್ಯಕ್ಟಿನ ವಿಚಾರದಲ್ಲಿ ಒಂದು ಅಟೆಂಪ್ಟ್ 1984ರಲ್ಲಿ 85ರಲ್ಲಿ ನಡೆಯುತ್ತೆ. ರಾಜೀವ್ ಗಾಂಧಿ ಅವರು ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ ಆಗಿರಬೇಕಾದ್ರೆ ಒಂದು ಪೋಸ್ಟಲ್ ಬಿಲ್ ಅಂತೇಳಿ ಪ್ರಯತ್ನ ಮಾಡ್ತಾರೆ. ಆ ಪೋಸ್ಟಲ್ ಬಿಲ್ಲನ್ನು ಪಾಸ್ ಮಾಡಲಿಕ್ಕೆ ನಮ್ಮ ಲೆಟರ್ಸ್ ನೋಡಿ, ಅವತ್ತಿನ ಥರ ಇಷ್ಟು ಸೋಷಿಯಲ್ ಮೀಡಿಯಾ ಇದೆಲ್ಲ ಅಡ್ವಾನ್ಸ್ ಆಗಿರಲಿಲ್ಲ. ಲವ್ ಲೆಟ್ರ್ ಬರೆದ್ರೂ ಸಹ ಗೌರ್ಮೆಂಟ್ ಆಫ್ ಇಂಡಿಯಾ ಇಂಟರ್ಸೆಪ್ಟ್ ಮಾಡಿ ಹೊರಗಡೆ ತೆಗೆದು ನೋಡ್ಬೋದಾಗಿತ್ತು. ಅವಾಗ ಅದೊಂದೇ ಮಾಧ್ಯಮ ಇದ್ದಿದ್ದು, ಯಾರ್ದಾರ ಮುಖಾಂತರ ಕಳಿಸ್ಬೇಕದನ್ನ ಅಲ್ವಾ. ಆ ಕಾಂಟೆಕ್ಸ್ಟಲ್ಲಿ ನೇರವಾಗಿ ಕೊಡೋಕೆ ಆಗದೆ ಇದ್ದರೆ ಆ ಪೋಸ್ಟಲ್ ಏನಾದ್ರು ಮಾಡಿದರೆ ದೇ ಕುಡ್ ಇಂಟರ್ಸೆಪ್ಟ್ ಅಂತೇಳಿ ಆ ಪೋಸ್ಟಲ್ ಬಿಲ್ಲನ್ನು ಮೂವ್ ಮಾಡ್ತಾರೆ. 395ಕ್ಕೂ ಹೆಚ್ಚು ಜನ MP ಇದ್ದರು. ದಟ್ ಬಿಲ್ ವಾಸ್ ನಾಟ್ ಸೈನ್ಡ್ ಬೈ ದ ದೆನ್ ಪ್ರೆಸಿಡೆಂಟ್ ಜೈಲ್ ಸಿಂಗ್. ಅಂದರೆ ಪ್ರೈವೇಸಿ ರೈಟನ್ನು ಅದು ವಯೋಲೇಟ್ ಮಾಡತ್ತೆ ಅಂತ ಅವರು ವಾಪಸ್ಸು ಕಳಿಸ್ಲಿಲ್ಲ. ತಾವು ಯಾಕೋ ಅವಸರದಲ್ಲಿ ಇದನ್ನು ಮಾಡಿದ್ದೀರಾ, ದಯಮಾಡಿ ಪುನರ್ ಪರಿಶೀಲಿಸಿ ಅಂತೇಳಿ ಅವ್ರು ವಾಪಸ್ಸು ಕಳಿಸ್ಲಿಲ್ಲ. ಆದರೆ ಬಿಲ್ಲನ್ನು ತಂಬಳಿನೇ ಇಟ್ಕೊಂಡ್ರು, ಸೈನೂ ಮಾಡಲಿಲ್ಲ. This is how you can overcome the urgent approach by the legislature while making the law which is going to take out this very personal liberty or privacy right of the common man. ಈ ಸೆನ್ಸಲ್ಲಿ ಈ ಟೆಲಿಗ್ರಾಫ್ ಆ್ಯಕ್ಟು ನಮಗೆ ತುಂಬ ಇವತ್ತಿಗೂ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದೆ. ತುಂಬ ಇಂಟರ್ವೆನ್ಷನ್ನು ಸರ್ಕಾರನೂ ಮಾಡ್ತಾ ಇದೆ. ಸರ್ಕಾರದಿಂದ ಅಧಿಕೃತವಾದ ಏಜೆನ್ಸೀಸ್ಗಳು ಫ್ರಾಂಚೈಸಿಸು ಮಾಡ್ತಾ ಇದ್ದಾವೆ. ರಿಲಯನ್ಸ್ ಇವರು ಅಟ್ ದ ಇನ್ಸ್ಟೆನ್ಸ್ ಆರ್ ಅಟ್ ದ ಆರ್ಡರ್ ಆಫ್ ದ ಗವರ್ಮೆಂಟ್ ಅವರು ಸಹ ಈ ಥರದ್ದೊಂದು ಇಂಟರ್ಸೆಪ್ಷನನ್ನು ಮಾಡ್ತಾರೆ. ಲೇಟರ್ ದೇ ವರ್ ಆಲ್ಸೋ ಕಾಲ್ಡ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಆಫ್ ಲಾ. ನಾವು ಸರ್ಕಾರದ ಆದೇಶ ಇದು ಲಾಫುಲ್ ಆಗಿದೆಯಾ, ವ್ಯಾಲಿಡ್ ಆಗಿದೆಯೋ ಇಲ್ಲೋ ಅಂತಲೂ ಅವ್ರು ವೆರಿಫೈ ಮಾಡೋಕ್ಕೆ ಹೋಗಿರಲ್ಲ. ಇತ್ತೀಚೆಗೆ ನಮಗೆ ನೀವೆಲ್ಲ ಒಳ್ಳೆ ಯುಗದಲ್ಲಿ ಬಂದಿದ್ದೀರಾ, ಎಲ್ಲ ಟ್ರಾನ್ಸ್ಪರೆನ್ಸಿ ಬಗ್ಗೆ, ಅಕೌಂಟಬಿಲಿಟಿ ಬಗ್ಗೆ, ಪಾರ್ಟಿಸಿಪೇಷನ್ ಬಗ್ಗೆ ಎಲ್ಲ ಮಾತಾಡ್ತೀವಿ ನಾವು. 1991-92 ಆದಮೇಲೆ ಈ ಡಂಕಲ್ ಡ್ರಾಫ್ಟ್ ಬಂದಮೇಲೆ, ಗ್ಯಾಟ್ ಅಂತ ಆದಮೇಲೆ ಮಶ್ರೂಮಿಂಗ್ ಗ್ರೋತ್ ಆಫ್ ದೀಸ್ MNCs ಆ್ಯಂಡ್ ಪ್ರೈವೇಟ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ ಹ್ಯಾವ್ ಕಮ್ ಅಪ್. They started insisting you must have transparency in your administration. You must have some accountability for the power you exercise. ಅಂದಾಗ ನಾವು ಟ್ರಾನ್ಸ್ಪರೆನ್ಸಿ ಬಗ್ಗೆ ಆ್ಯಕ್ಟ್ ಮಾಡ್ತೀವಿ, ರೈಟ್ ಟು ಇನ್ಫಾರ್ಮೇಷನ್ ಬಗ್ಗೆ ಆ್ಯಕ್ಟ್ ಮಾಡ್ತೀವಿ 2005ಅಲ್ಲಿ. ದಿಸ್ ಈಸ್ ದ ಎರಾ ಆಫ್ ಟ್ರಾನ್ಸ್ಪರೆನ್ಸಿ. ಈ ಕಾಂಟೆಕ್ಸ್ಟಲ್ಲಿ ನಾವು ಒಂದು ಸ್ವಲ್ಪ ವಿ ಆರ್ ಮೋರ್ ಸ್ಟ್ರೆಂಥನ್ಡ್ to fight against the secrecy maintained by the bureaucracy. Bureaucracy always would like to maintain the secrecy. ಈ ಸೆನ್ಸಲ್ಲಿ ಮತ್ತೊಂದು ಅನಿವಾರ್ಯವಾಗಿ ನಾವು ಲೆಜಿಸ್ಲೇಷನ್ ಮಾಡಬೇಕಾಗ್ತದೆ. ಬಿಕಾಸ್ ಟೆಕ್ನಾಲಜಿಕಲ್ ಡೆವಲಪ್ಮೆಂಟ್ ಯಾವಾಗ ಟೆಕ್ನಾಲಜಿ ಡೆವಲಪ್ ಆಗಿದೆಯೋ ಆವಾಗೆಲ್ಲ ನಮ್ಮ ಪ್ರೈವೇಸಿಗೆ ಕುಂದು ಬಂದಿದೆ, ಕೊರತೆ ಆಗಿದೆ. ಸೊ ಟೆಕ್ನಾಲಜಿ ಯಾವಾಗಲೂ ಲಾಯಿನ ಅಹೆಡ್ ಆಗಿರುತ್ತೆ, ಲಾಗಿನ ಅಡ್ವಾನ್ಸ್ ಆಗಿರುತ್ತೆ. ಲಾ ಪೀಪಲ್ ಆರ್ ಸ್ಟ್ರಗ್ಲಿಂಗ್ ಟು ಕ್ಯಾಚ್ ದ ಟೆಕ್ನಾಲಜಿ ಆ್ಯಂಡ್ ಪುಟ್ ದಿ ರೆಗ್ಯುಲೇಷನ್ ಅಕ್ರಾಸ್ ದಿ ಟೆಕ್ನಾಲಜಿ. ನೋಡಿ, ಲಾಸ್ಟ್ ವೀಕ್ ಅಥವಾ 15 days ಬ್ಯಾಕ್ ಅದಾನಿ ಗ್ರೂಪ್ ಅವರು ದೇ ಹ್ಯಾವ್ ಸ್ಟಾರ್ಟೆಡ್ ಎ ಕಾರ್ಪೊರೇಟ್ ಸೆಕ್ಟರ್ ಆ್ಯಂಡ್ ಇನ್ಕಾರ್ಪೊರೇಟೆಡ್ ಎ ಕಂಪನಿ ಅಟ್ ಬಾಂಬೆ ಫಾರ್ ದಿ ಮೇಂಟೆನೆನ್ಸ್ ಆಫ್ ಡಾಟಾ. ಈ ವಾರದಲ್ಲಿ ಹೈದರಾಬಾದಲ್ಲಿ ಫೇಸ್ಬುಕ್ ಮತ್ತು ಗೂಗಲ್ ಅವರು 15,000 crores ಇನ್ವೆಸ್ಟ್ ಮಾಡ್ತಕ್ಕಂಥ ಒಂದು DPR ಡೀಟೇಲ್ಡ್ ಪ್ರಾಜೆಕ್ಟ್ ರಿಪೋರ್ಟನ್ನು ಮಾಡಿ ಹೈದರಾಬಾದಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರದ್ದೆಲ್ಲ ಏನು ಕೆಲಸ ಅಂದರೆ ನಮ್ಮದೆಲ್ಲ ಡಾಟಾ ಅವ್ರ ಹತ್ರ ಇರುತ್ತೆ. ಎನಿ ಡಾಟಾ, ಎನಿಬಡಿ ಕ್ಯಾನ್ ಬೈ ದಟ್ ಡಾಟಾ ಆನ್ ಪೇಮೆಂಟ್. ದಿಸ್ ಈಸ್ ದ ರಿಡಿಕ್ಯುಲಸ್ ಸಿಚುವೇಶನ್. ನಾವು ಈಗ ಏನು ಆಧಾರ್ಗೆ 10 ಬೆರಳು ಕೊಟ್ಟು ನಮ್ಮನ್ನು ಅಲ್ಲಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ, ನಾವೇನೇನು ಮಾಡೋದೆಲ್ಲ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲದಂಗೆ ಗೌರ್ಮೆಂಟ್ ಆಫ್ ಇಂಡಿಯಾದಲ್ಲಿ ಏನು ಆ ಡಾಟಾ ಇತ್ತು, UPA ಗೌರ್ಮೆಂಟ್ ಅವರು ಯಾವುದೇ ಲೆಜಿಸ್ಲೇಟಿವ್ ಸ್ಯಾಂಕ್ಷನ್ ಇಲ್ಲದೆ 36,000 ಕೋಟಿದು DPR ಅದು. ಆವಾಗ ಈಗಿರೋ ಸರ್ಕಾರ ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿಬಿಡುತ್ತೆ ತುಂಬ. ಮತ್ತು ಇವರು ಅಧಿಕಾರಕ್ಕೆ ಬಂದಾಗ ಚೆನ್ನಾಗಿದೆ, ನಾವು ದುಡ್ಡು ಮಾಡ್ಬೋದು ಇದರಲ್ಲಿ ಅಂತ. ಅದಕ್ಕೆ ಈ ದೇಶದಲ್ಲಿ ಆಯಿಲ್ ಮಾರೋರು ಹೇಳಿದರು, ಡಾಟಾ ಈಸ್ ದಿ ಮಾಡ್ರನ್ ಆಯಿಲ್ ಫಾರ್ ಡೂಯಿಂಗ್ ಬಿಸ್ನೆಸ್. ಇದೆಲ್ಲ ಬಿಸ್ನೆಸ್. ಸೊ ನಾವು ಅಗ್ರಿ ಅಂತ, ಅಕ್ಸೆಪ್ಟ್ ಅಂತ ಒತ್ತಬೇಕಾದ್ರೆ ವಿ ಮಸ್ಟ್ ಬಿ ಕೇರ್ಫುಲ್. ನೋಡಿ, ಎಲ್ಲೆಲ್ಲಿ ಯಾವ ಏರಿಯಾದಲ್ಲಿ ತೊಂದರೆಗೆ ಸಿಗಾಕೊಳ್ತಾರೆ ಇನ್ನು ಮುಂದೆ ಜನ ಅಂದರೆ, ಸೊ ದೀಸ್ private bodies or corporate sectors shall be treated as public functionaries. They are answerable for the violation of the privacy of the common man. ನಾಳೆ ನೀವು ಲಾಯರ್ ಆದಾಗ, ಜಡ್ಜಸ್ ಆದಾಗ, this is what your obligation, to protect the interest of the common man against the mighty power of the state. ಈ ಸೆನ್ಸಲ್ಲಿ ನಾವು ನಮ್ಮ ಮೈಂಡ್ ಸೆಟ್ಟನ್ನು ಬಿಲ್ಡ್ ಮಾಡಬೇಕಾಗಿದೆ. ಮೇ ಬಿ ಈ 4 ಲೆಜಿಸ್ಲೇಷನ್ಸ್, ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಇನ್ಫಾರ್ಮೇಷನ್ ಟೆಕ್ನಾಲಜಿ ಆ್ಯಕ್ಟ್ ಏನು ಬಂದಿದೆ, ಅದರಲ್ಲಿ ಈ ಫೇಲ್ಯೂರ್ ಟು ಪ್ರೊಟೆಕ್ಟ್ ಡಾಟಾ, ನಮ್ಮ ಇನ್ಫಾರ್ಮೇಷನನ್ನು ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಫೇಲ್ಯೂರ್ ಆಗಿದೆ ಅಂದರೆ ಯಾರು? ಗೌರ್ಮೆಂಟ್, ಒನ್ ಹೂ ಈಸ್ ಇನ್ ಕಸ್ಟಡಿ ಆಫ್ ಅವರ್ ಇನ್ಫಾರ್ಮೇಷನ್. ಈಗ ಕರ್ನಾಟಕದಲ್ಲಿ ಭೂ ದಾಖಲೆಗಳು ಸುಮಾರು 40 ಲಕ್ಷ ಭೂ ದಾಖಲೆಗಳು ಇವತ್ತು ನಿಮ್ಮ ಮನೆ ಬಾಗಿಲಿಗೆ ತಲುಪುತ್ತವೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. So data is there with the government and it is having its custody. So ಅದು ರಿವೀಲ್ ಆಗೋದಾದರೆ ಏನಾದರೂ ನಮ್ಮ ಪ್ರೈವೇಸಿ ರೈಟಿಗೆ ವಯಲೇಟ್ ಆಗತ್ತಾ ಅಂತ ನಾವು ನೋಡಬೇಕಾಗತ್ತೆ. ಆ ಕಾಂಟೆಕ್ಸ್ಟಲ್ಲಿ ಬ್ರೀಚ್ ಆಫ್ ಕಾನ್ಫಿಡೆನ್ಷಿಯಾಲಿಟಿ ಆ್ಯಂಡ್ ಪ್ರೈವೇಸಿ ಯಾವಾಗ ಇದೆಲ್ಲ ಮುಂಚೆ ಡೆವಲಪ್ ಆಗಿರೋದು. ರೈಟ್ ಟು ಬಿ ಲೆಟ್ ಅಲೋನ್, ಕಾನ್ಫಿಡೆನ್ಷಿಯಲ್ ಇನ್ಫಾರ್ಮೇಷನ್, ಇದೆಲ್ಲ ಯಾವಾಗ ಬಂತು ಅಂದರೆ ಈ ಟೆಲಿಗ್ರಾಫ್ ಡೆವಲಪ್ ಆದಾಗ, ಟೆಲಿಫೋನ್ ಇನ್ವೆನ್ಷನ್ ಆದಾಗ, ಈ ಥರ ಟೆಕ್ನಾಲಜಿ ಡೆವಲಪ್ ಆದಾಗ ಇದೆಲ್ಲ ಕಾನ್ಫಿಡೆನ್ಷಿಯಲಿಟಿ ಅನ್ನೋದನ್ನ ಅಥವಾ ಪ್ರೈವೇಸಿ ಅನ್ನೋದು ಯಾವಾಗ ರಿವೀಲ್ ಆಯಿತು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಕೇಸ್ ಲಾಗಳು ಇದೆ. ಸೊ ಮೇ ಬಿ ಈವನ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಲಾ, if there is a breach of this contract by disclosing the information which is said to be confidential, so there are provisions in the IT Act to punish or impose penalty. ನಾವು ಅದ್ಭುತವಾಗಿ ಇಲ್ಲಿ IT Act ಅಲ್ಲಿ ಅದ್ಭುತವಾಗಿ ಬರ್ಕೊಂಡಿರೋದು, ಫಸ್ಟ್ ಟೈಮ್ ಇದು ಕನ್ವಿಕ್ಷನ್ನು ಅಥವಾ ಪೆನಾಲ್ಟಿ ಅನ್ನೋದು 10 ಲಕ್ಷ ತನಕ ಪೆನಾಲ್ಟಿ ಆಗ್ತೀವಲ್ಲಿ, 1 ಕೋಟಿ ತನಕನೂ ಪೆನಾಲ್ಟಿ ಆಗ್ತೀವಿ. ಬರೀ ಪೆನಾಲ್ಟಿ ಹಾಕೋದಾದ್ರೆ ಹಾಗಾದ್ರೆ ನಾನು ಪೆನಾಲ್ಟಿ ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಕಟ್ತೀನಪ್ಪ. ಈಸ್ ಇಟ್ ದಿ ರೈಟ್ ಮೆಜರ್ ಆಫ್ ಲಿಮಿಟಿಂಗ್ ದಿಸ್ ಆರ್ ಹ್ಯಾಂಡ್ಲಿಂಗ್ ದಿಸ್ ಅನ್ನೋದು ಪ್ರಶ್ನೆ. ಈಗ ಮಲ್ಟಿನ್ಯಾಷನಲ್ ಕಂಪ್ನಿ ನನ್ನ ಹತ್ರ ಒಂದು 10-15 ಸಾವಿರ ಕೋಟಿ ಇದೆ, ಒಂದು 5,000 ಕೋಟಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿಬಿಡ್ತೀವಿ ಸರ್, ಯಾವಾಗ ನಾವು ವೈಲೇಟ್ ಮಾಡ್ತೀವಿ ಇದೆಲ್ಲ ಮುರ್ಕೊಳ್ಳಿ ಸರ್ ಪೆನಾಲ್ಟಿ ಕಡೆಗೆ ಅಂತ. ಪೊಲ್ಯೂಟರ್ ಪೇ ಪ್ರಿನ್ಸಿಪಲ್ ಅಂತ ಅಲ್ಲಿತ್ತಲ್ಲ, ಅದನ್ನ ಇಲ್ಲ ಹಾಕೋ ಪರಿಸ್ಥಿತಿ ಆಗ್ಬಿಡತ್ತೆ. ಹಾಗಾಗಿ ವೆದರ್ ದಿಸ್ ಇಂಪೊಸಿಷನ್ ಆಫ್ ದ ಪೆನಾಲ್ಟಿ ಈಸ್ ಸಫಿಷಿಯಂಟ್ ಇನ್ ಟ್ಯಾಕ್ಲಿಂಗ್ ದೀಸ್ ಟೈಪ್ ಆಫ್ ವಯಲೇಷನ್ ಆಫ್ ಪ್ರೈವೇಸಿ. ವಯಲೇಷನ್ ಆಫ್ ಏನು ಪ್ರೈವೇಸಿ ಅನ್ನೋದನ್ನ ನಾವು ಅಫೆನ್ಸ್ ಅಂತ ಮಾಡಿದರೆ ಅಲ್ಲಿ ಓನ್ಲಿ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ಪೆನಾಲ್ಟಿ ವಿ ವಾಂಟ್ ಟು ಮ್ಯಾನೇಜ್ ದಿಸ್. ಸೊ IT ಆ್ಯಕ್ಟು ತುಂಬಾ ಮಾಡಿಫೈ ಆಗಬೇಕಾಗತ್ತೆ. ಹಾಗೆ ಐಡೆಂಟಿಟಿ ಥೆಫ್ಟ್, ಏನೇನು ನಮ್ಮ ಪ್ರೈವೇಸಿ ಹೋಗುತ್ತೆ ಅಂದರೆ ನಮ್ಮ ಏನು ಪಾಸ್ವರ್ಡ್ ಇರ್ಬೋದು, ನಮ್ಮ ಕೀ ಇರ್ಬೋದು, ಸಂಬಡಿ ಸ್ಟೀಲ್ಸ್ ದಟ್, ದೆರ್ ಈಸ್ ಎನ್ ಇಂಪರ್ಸನೇಷನ್, ದಟ್ ಈಸ್ ಐಡೆಂಟಿಟಿ ಥೆಫ್ಟ್. ಸೊ ಯಾರು ಇತ್ತೀಚಿನ ಟೆಕ್ನಾಲಜಿ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಥವಾ ಅವರ ಒಂದು ದೈನಂದಿನ ಜೀವನದಲ್ಲಿ ಇದು ಇನ್ಎವಿಟಬಲ್ ಆಗಿದೆ. ಈಗ ಡಿಜಿಟಲ್ ಕರೆನ್ಸಿ, ಕಾರ್ಡ್, ಯಾವುದೇ ಕಾಂಟೆಕ್ಸ್ಟಲ್ಲಿ ನೀವು ಸ್ವೈಪ್ ಮಾಡಿದರೆ ವೇರಬೌಟ್ಸ್ ಆಫ್ ಯು ಈಸ್ ಮೇಡ್ ನೋನ್ ಟು ದಿ ಗ್ಲೋಬ್. ನನಗೆ ಎವ್ರಿ ಮಂತು ರಿಪೋರ್ಟ್ ನನಗೆ ಮೇಲಲ್ಲಿ ಬಂದ್ಬಿಡುತ್ತೆ, ಗೂಗಲ್ ಸರ್ ಹೇಳ್ದಂಗೆ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಬರೋದು, ಎವ್ರಿ ಮಂತ್ ಎಲ್ಲೆಲ್ಲಿ ಹೋಗಿದ್ರಿ ನೀವು, ಎಲ್ಲಿ ಹೋಗಿ ಬಂದ್ರಿ ಅಂತೇಳಿ. ಅದನ್ನು ನನ್ನ ಹೆಂಡ್ತಿ ನೋಡಿದರೆ ಗೊತ್ತಾಗತ್ತೆ ಅಲ್ವಾ. ರೈಟ್ ಟು ಬಿ ಲೆಟ್ ಅಲೋನ್ ಹೇಗೆ ಕಷ್ಟ. ಅದ್ಯಾಕೆ ಹೋಗಿದ್ರಿ RV ಕಾಲೇಜ್ಗೆ? ಪ್ರೈವೇಸಿ ಬಗ್ಗೆ ಮಾತಾಡೋಕ್ಕೆ. ನಿಮ್ಮ ಪ್ರೈವೇಸಿ ನೋಡಿ ಇಲ್ಲಿ ಡಿಸ್ಕ್ಲೋಸ್ ಆಗಿದೆ ಅಂತ ಅಲ್ವಾ. ನಮಗೆ ಅಂದರೆ ಈ ಮೆಟಾವರ್ಸ್ ಅನ್ನೋದು ಬಂದಮೇಲೆ ದಟ್ ಈಸ್ ಎನ್ ಎಂಡ್ ಆಫ್ ಪ್ರೈವೇಸಿ ಅಂತ. So how to put a legal framework for these people, one who is doing public function, ನಮ್ಮ ಸಾಮಾನ್ಯ ಜನದ ಡಾಟಾ ಅವ್ರ ಹತ್ರ ಇದೆ ಅಂದರೆ for what purpose it was given, only for that purpose it has to be made use and nothing more than that. ನೀವು KYC ಅಂತ ಏನಿದೆ ಅದೂ ಅಷ್ಟೇ, ನೋ ಯುವರ್ ಕಸ್ಟಮರ್ ಅನ್ನೋ ಹೆಸರಲ್ಲಿ ಸುಮ್ಮನೆ ವರ್ಷಕ್ಕೊಂದ್ಸರಿ ಬನ್ನಿ ಕೊಡಿ ಅಂತ ಇರ್ತಾರೆ. ಅದನ್ನು ಮತ್ತಾರಿಗೋ ಮಾರ್ಕೊಳ್ತಾ ಇರ್ತಾರೆ. ಅವನು ನನಗೆ ಫೋನ್ ಬರುತ್ತೆ, ಸರ್ ನಾವೊಂದು ನಿಮಗೆ ಒಂದು 10 ಲಕ್ಷ ಲೋನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿದೆ ಸರ್ ತಗೊಳ್ಳಿ. 10 ಲಕ್ಷ ಸಾಗಲ್ಲ, ಒಂದು 10 ಕೋಟಿ ಕೊಡಿ ಅಂತೀನಿ ನಾನು. RV ಕಾಲೇಜ್ ಥರ ನಾನೊಂದು ಲಾ ಕಾಲೇಜ್ ಕಟ್ಟಬೇಕು ಅಂತ 10 ಕೋಟಿನ ಸರ್ ಅದು. ಮತ್ತು 10 ಲಕ್ಷ ತಗೊಂಡು ಏನು ಮಾಡ್ತೀರಾ? See, unless he knew about my CIBIL score, he will not make an advance. ಅಲ್ವಾ? ಸಿಬಿಲ್ ಸ್ಕೋರ್ ಅನ್ನೋದು ಅವನಿಗೆ ಗೊತ್ತಿದೆ. ಈ ಬ್ಯಾಂಕ್ ಅವರು ಅವನಿಗೆ ಮಾರ್ಕೊಂಡಿದ್ದಾರೆ, ಈ ಸಾಲ ತಗೊಂಡಿದ್ದಾರಲ್ಲ ಈ ಮೇಷ್ಟ್ರು ಚೆನ್ನಾಗಿ ತೀರಿಸ್ತಾರೆ ಅವರು, ಬೇರೆಯವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ. ಅಂದರೆ ಇದು ಲಾಂಗ್ ಬ್ಯಾಕ್ ದಿ ಡಿಡ್ ಇನ್ ಯುನೈಟೆಡ್ ಸ್ಟೇಟ್ಸ್. ಬಿಸ್ನೆಸ್ ಏರಿಯಾದಲ್ಲಿ ಡಾಟಾ ಕಲೆಕ್ಟ್ ಮಾಡಿ ಕ್ರೆಡಿಟ್ ವರ್ತಿನೆಸ್ ಅನ್ನೋದನ್ನ ಒಬ್ಬರು ಅಸೆಸ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತಾರೆ. ಅಲ್ಲಿ ಇವನಿಗೆ ಸಾಲ ಕೊಡ್ಬೋದು, ಇವನಿಗೆ ಸಾಲ ಕೊಡ್ಬೋದು, ಅವನು ಸಾಲ ತೀರಿಸ್ತಾನೆ. ಅದನ್ನು ಅವನು ಹಂಚ್ಕೊಳ್ಳೋಕೆ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾನೆ. ನೋಡಿ, ಇದೆಲ್ಲ ಬಿಸ್ನೆಸ್ ಅಂದರೆ ಇವತ್ತು ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ದಲ್ಲ, ಅವತ್ತೇ. ಈಗ ಒಬ್ಬನಿಗೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವನು ಯಾರೋ ಒಬ್ಬ ಹಳೇದು ಓದ್ಬಿಟ್ಟ, ಹಾ ಇದ್ರಲ್ಲಿ ಮಾಡ್ಬೋದು ದುಡ್ಡು ಅಂತ. ಸೊ ಯು ಮಸ್ಟ್ ಬಿ ವೆರಿ ಕೇರ್ಫುಲ್ ವೈಲ್ ಗಿವಿಂಗ್ ಇನ್ಫಾರ್ಮೇಷನ್ ಟು ಸಂಬಡಿ. ನೋಡಿ, ನಿಮ್ಗೆ ಗೊತ್ತಿರೋರೇ ನಿಮಗೆ ಬಗಲ್ ಮೇ ಆಯ್ ದುಶ್ಮನ್ ಅಂತ ಅಲ್ವಾ? ನಮ್ಮ ಮಾಹಿತಿ ಬಗ್ಗೆ ನಮ್ಗೆ ಗೊತ್ತಿರೋರೇ ಮುಂದೆ ನಮ್ಮ ಶತ್ರುಗಳು. ಮಾಹಿತಿಯನ್ನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಬೇಕಾದ್ರೆ ಇನ್ಫಾರ್ಮೇಷನಲ್ ಪ್ರೈವೇಸಿ ಅನ್ನೋದು ಒಂದು, ಬಾಡಿಲಿ ಪ್ರೈವೇಸಿ ಅನ್ನೋದು ಮತ್ತೊಂದು. ಫಿಸಿಕಲ್ ಪ್ರೈವೇಸಿ ಬೇರೆ, ಇನ್ಫಾರ್ಮೇಷನಲ್ ಪ್ರೈವೇಸಿ ಬಗ್ಗೆ. ಇನ್ಫಾರ್ಮೇಷನ್ ಪ್ರೈವೇಸಿ ಕೊಡಬೇಕಾದ್ರೆ ಯು ಮಸ್ಟ್ ಬಿ ಮೋರ್ ಕಾಶಿಯಸ್. ಬಟ್ ಬಾಡಿಲಿ ಪ್ರೈವೇಸಿ ಅನ್ನೋ ವಿಚಾರ ಬಂದಾಗ ಬೇರೆ ಬೇರೆ ಸಮಸ್ಯೆಗಳಿದ್ದಾವೆ ಅಲ್ಲಿ. ಎಸ್ಪೆಷಲಿ ನಾವು ಇದನ್ನು 1983 ಆನ್ವರ್ಡ್ಸ್, ನಾನು ಸರ್ವೆಲೆನ್ಸ್ ಬಗ್ಗೆ ಒಂದು ಹೇಳಿದೆ, ಗೋವಿಂದ್ ಕೇಸ್ ಅಷ್ಟೊತ್ತಲ್ಲಿ ರೈಟ್ ಟು ಲೈಫ್ ಅಂದರೆ ಏನು ಅನ್ನೋದನ್ನು ಸ್ವಲ್ಪ ಮಟ್ಟಿಗೆ ಟಚ್ ಮಾಡ್ತಾರೆ ಅಂತ. ಬಟ್ 1983 ಅಷ್ಟೊತ್ತಿಗೆ ಈ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್ ಬಗ್ಗೆ ಒಂದು ಕೇಸ್ ಆಗತ್ತೆ, ಸರಿತಾ ವರ್ಸಸ್ ವೆಂಕಟ್ ಸುಬ್ಬಯ್ಯ. ಈ ಫೇಮಸ್ ಫಿಲಮ್ ಆ್ಯಕ್ಟ್ರೆಸ್ ಇದು, ಪಾಪ ಅವಳು 8th 9th ಓದ್ತಾ ಇದ್ಲು. ಅವಳು ಗಂಡನ ಅಣ್ಣಂಗೆ ಮದುವೆ. ಈ ಆಂಧ್ರ ಪ್ರದೇಶಲ್ಲಿ ಕರ್ನಾಟಕದ ರೂರಲ್ ಭಾಗಲ್ಲಿ ಒಂದು ಕಸ್ಟಮರಿ ಪ್ರಾಕ್ಟೀಸು, ದೊಡ್ಡವನಿಗೆ ಮದುವೆ ಮಾಡ್ಬೇಕಾದ್ರೆ ಸಣ್ಣವನಿಗೂ ಮಾಡಿಬಿಡಿ, ಯಾಕಂದರೆ ಮುಂದೆ ಇವರೆಲ್ಲ ಹೊರಗೆ ಹೋದರೆ ಅವ್ರನ್ನ ಕೇಳೋರು ಯಾರೂ ಇರಲ್ಲ, ಈಗಲೇ ಮಾಡಿಬಿಡಿ ಅಂತ. ಸರಿತಾ ಅಲ್ಲಿ ಹೈಸ್ಕೂಲ್ಗೆ ಹೋಗೋ ಹುಡುಗಿ, ವೆಂಕಟ್ ಸುಬ್ಬಯ್ಯ ಕಂಟ್ರಿ ಮ್ಯಾನ್, ಅವ್ರಿಗೆ ಮದುವೆ ಮಾಡಿಬಿಟ್ರು. ಅವನಲ್ಲ, ಅವನ ಪಾಡಿಗೆ ಅವ್ರ ಊರಲ್ಲಿದ್ದಾನೆ, ಇವನ ಪಾಡಿಗೆ ಇವಳು ಸ್ಕೂಲ್ಗೆ ಹೋಗ್ತಾ ಇದ್ದಾಳೆ. ಒಂದು ದಿವಸ ಯಾರೋ ಅವಳು ಪೋಸ್ಟ್ರು ನೋಡ್ಬಿಟ್ಟ, ಫೇಮಸ್ ಫಿಲಮ್ ಆ್ಯಕ್ಟ್ರೆಸ್ ಆಗಿ ಪೋಸ್ಟರ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಪಿಕ್ಚರಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅವ್ನು ಕೇಳ್ದ ವೆಂಕಟ್ ಸುಬ್ಬಯ್ಯಂಗೆ ಅವನ ಫ್ರೆಂಡು, ನಿನ್ನ ಹೆಂಡ್ತಿ ಅಲ್ವಾ ಇವಳು? ಹೌದೌದು. ಹಾಕಕ್ಕೆ ಸರ್ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್ ಆಯ್ತು, ಅವಳು ಬರಲಿ ನಿನ್ನ ಮನೆಗೆ ಅಂತ. ಅವಳಿಗೆ ಮರ್ತೇ ಹೋಗ್ಬಿಟ್ಟಿದ್ದೆ ನೀವು ಮದುವೆ ಆಗಿದ್ದೀನಿ ಅಂತ. ಆಟ ಆಡ್ತಾ ಇದ್ರು, ಕರ್ಕೊಂಬಂತು, ಮದುವೆ ಮಾಡಿಬಿಟ್ರು. ಈಗ ನೋಡಿದರೆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇದೆ, ಹೋಗಮ್ಮ ವೆಂಕಟ ಸುಬ್ಬಯ್ಯನ ಜೊತೆಗೆ. ನೋ, ಅಟ್ ದ ಇನ್ಸ್ಟೆನ್ಸ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಡಿಕ್ರಿ ಶಿ ಹ್ಯಾಸ್ ಟು ಬಿಗೆಟ್ ಎ ಚೈಲ್ಡ್ ಫಾರ್ ಹಿಮ್ ಹೂ ಈಸ್ ಅನ್ನೋನ್ ಟು ಹಿಮ್. ಬರೀ ಒಂದು ಮಂಗಳಸೂತ್ರ ಕಟ್ಟಿದ, ಆಮೇಲೆ ಪತ್ತೆ ಇಲ್ಲ, ಅವನ ಜೊತೆಗೆ ಸಂಸಾರ. ವಾಟ್ ರೈಟ್ ದ ಕೋರ್ಟ್ ಈಸ್ ಹ್ಯಾವಿಂಗ್ ಇನ್ ಬಿಟ್ವೀನ್ ದ ಹಸ್ಬೆಂಡ್ ಆ್ಯಂಡ್ ವೈಫ್ ಅಲ್ವಾ? 122 ಅಲ್ಲಿ ಅವ್ರು ಏನು ಮಾತಾಡ್ತಾರೆ ಅದನ್ನು ನೀವು ಕಮ್ಯುನಿಕೇಷನ್ನ ಹೊರಗೆ ತೆಗಿಯಂಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಂಗ್ಲೆಂಡಲ್ಲಿ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್ ಡಿಕ್ರಿನ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಆದರೆ ದಟ್ ಲೇಡಿ ಈಸ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ದ ರೈಟ್ ಹಿಯರ್ ಬಿಕಾಸ್ ಆಫ್ ದ ಆರ್ಡರ್. ಅಟ್ ವಾಟ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಶಿ ಕ್ಯಾನ್ ಬಿಗೆಟ್ ಚೈಲ್ಡ್ ಫಾರ್ ಹಿಮ್ ಆರ್ ಶಿ ಕ್ಯಾನ್ ಲೂಸ್ ಹರ್ ಪ್ರೈವಸಿ ರೈಟ್. And maybe even with respect to the marital rape being not considered as an offense even today, whether that amounts to invasion of privacy when she is not willing for that. ಈ ಥರದ್ದೆಲ್ಲ ಬಾಡಿಲಿ ಪ್ರೈವೇಸಿ ವಿಚಾರದಲ್ಲಿ ನಮ್ಮ ಮುಂದೆ ಬರ್ತಕ್ಕಂಥದ್ದು. ಇಂಡಿಯನ್ ಪೀನಲ್ ಕೋಡಲ್ಲೂ ಈ ಥರದ ಕೆಲವು ವಿಚಾರ ಇದೆ. ಸೆಕ್ಷನ್ 354 ಕ್ಲಾಸ್ 3ಅಲ್ಲಿ ಎನಿ ಮ್ಯಾನ್ ಹೂ ವಾಚಸ್ ಆರ್ ಕ್ಯಾಪ್ಚರ್ಸ್ ದ ಇಮೇಜ್ ಆಫ್ ಎ ವುಮನ್ ಎಂಗೇಜಿಂಗ್ ಇನ್ ಪ್ರೈವೇಟ್ ಆ್ಯಕ್ಟ್, that is an offense. Privacy, voyeurism, stalking, ನಿರಂತರವಾಗಿ ಬೆನ್ನತ್ತೋದು ಮಾತಾಡ್ಸಕ್ಕೆ, that is also offense. Privacy ಬಿಡೋದಿಲ್ಲ. ಲೆಟ್ ಟು ಬಿ ಅಲೋನ್ ಅಂದರೆ ಇಲ್ಲ, ನೋ ಯು ಕ್ಯಾನ್ಟ್ ಬಿ ಅಲೋನ್ ಅಲ್ವಾ? ತುಂಬ ಸಮಸ್ಯೆ. ವ್ಯಕ್ತಿಯಾಗಿ ಇರಲಿಕ್ಕೆ ನಾವು ಅವಕಾಶ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿದರೆ ಪ್ರತಿ ಸ್ಟೇಜಲ್ಲೂ ಇನ್ವೇಷನ್ ಆಫ್ ಪ್ರೈವೇಸಿ ಅಂತೇಳಿ. ನೋ, ಐ ಆಮ್ ಸ್ಪೀಕಿಂಗ್ ಅಬೌಟ್ ಪಬ್ಲಿಕ್ ರಾಂಗ್, ನಾಟ್ ಪ್ರೈವೇಟ್ ರಾಂಗ್. ಸೊ ಇದೆಲ್ಲ ಇಂಡಿಯನ್ ಪೀನಲ್ ಕೋಡಲ್ಲಿ ನಾವು ಸೇರಿಸಿದ್ದೀವಿ ಅಂದರೆ ಅರ್ಥ ಅದೇನೆ. ಮೇ ಬಿ ಡಿಸ್ಕ್ಲೋಸರ್ ಆಫ್ ಐಡೆಂಟಿಟಿ ಆಫ್ ದ ವಿಕ್ಟಿಮ್ ಆಲ್ಸೋ. ದಿಸ್ ಇಸ್ ವಾಟ್ ಐ ಕ್ಯಾನ್ ಸೇ ದ ಲಿಮಿಟೇಷನ್ ಇಂಪೋಸ್ಡ್ ಅಪಾನ್ ದ ಪ್ರೆಸ್ ಪೀಪಲ್. ಅಷ್ಟೆಲ್ಲ ನಾವು ಲಾ ಮಾಡಿಕೊಂಡು 228A ಸೇರಿಸಿದ್ರು ಪ್ರೆಸ್ ಅವರು ಸಮ್ಮಾರ್ದಿ ಅದರ್ ವೇ ಅವ್ರ ಮನೆಗೆ ಹೋಗೋದು, ಅವ್ರ ಹೋಗೋದು, ನಿಮ್ಗೆ ಏನಾಯ್ತು ಅವ್ರ ಅಪ್ಪ ಅಮ್ಮಂಗೆ ಕೇಳೋದು, ವಿಕ್ಟಿಮ್ಗೆ ಹೇಳಲ್ಲ ನಾವು. ಲುಕ್ ಎಟ್ ದ ವೇ ಅದರ್ ವೇ ಯು ಆರ್ ಡಿಸ್ಕ್ಲೋಸಿಂಗ್. ಈ ಥರದ್ದಿದ್ರೂ ವಯಲೇಟ್ ಮಾಡಿರೋ ಸಂದರ್ಭಗಳು ತುಂಬಾ ಇದೆ. ಈಗ ವಿಜುವಲ್ ಮೀಡಿಯಾ ಈಸ್ ಬ್ರಿಂಗಿಂಗ್ ಔಟ್ ಎವ್ರಿಥಿಂಗ್ ಆ್ಯಂಡ್ ವಿ ಆರ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ಎನಿ ಸಚ್ ಟೈಪ್ ಆಫ್ ಪ್ರೈವೇಸಿ ಇನ್ ದಿಸ್ ರಿಕಾರ್ಡ್. So maybe with respect to this unnatural offences also, 377, that has been read down. It was not declared totally unconstitutional. Only the first part has been read down, and the remaining part, if there is any carnal sex or unnatural sex to that extent, that continue to be a punishable offense. So especially ನಮಗೆ 2013 ಆದಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಲಾ ಅಮೆಂಡ್ಮೆಂಟ್ ಆ್ಯಕ್ಟ್ ಪಾಸ್ ಆದಮೇಲೆ ತುಂಬ ಕಷ್ಟ ಮೆನ್ಗೆ. ನಿರ್ದಿಷ್ಟವಾಗಿ ಯಾವುದೋ ಮೊನ್ನೆ ನೋಡಿ ಕಂಡಕ್ಟ್ರು ಯಾರೋ ಒಂದು ಗರ್ಲ್ಗೆ ಹಿಜಾಬ್ ಹಾಕೊಂಡು ಬಂದಿದ್ದಾಳೆ, ಅವಳಿಗೆ ನೀನೇ ಐಡೆಂಟಿಟಿ ಪಾಸಲ್ಲಿ ಇರೋದು ಹೇಗೆ ನಾನು ಐಡೆಂಟಿಫೈ ಮಾಡೋದಮ್ಮ ಅಂತ ಕೇಳಿದ್ದಾರೆ. ನನ್ನ ಕಣ್ಣು ನೋಡಿದರೆ ಗೊತ್ತಾಗಲ್ವಾ ನಿಮಗೆ? ಲುಕ್ ಅಟ್ ದಿಸ್. ಆ ಕಂಡಕ್ಟ್ರು ಏನಾದ್ರು ನಿರ್ದಿಷ್ಟವಾಗಿ ಅವಳ ಕಣ್ಣನ್ನೇ ನೇರವಾಗಿ 30 ಸೆಕೆಂಡುಗಳ ಕಾಲ ನೋಡಿದಲ್ಲಿ ಅದು ಅಪರಾಧ. ನನ್ನನ್ನು ಈ ಕಂಡಕ್ಟ್ರು ನೇರವಾಗಿ ದೃಷ್ಟಿಸಿ ನನ್ನ ಕಣ್ಣನ್ನೇ ನೋಡಿದ ಅಂತ ಹಾಗೆ ನೋಡೋದು ಅಪರಾಧ ಆಗ್ಬಿಡತ್ತೆ ಅಲ್ವಾ? ಈ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಇದೆ, ಪ್ರೈವೇಸಿ ರೈಟಲ್ಲಿ ಕಾನ್ಫ್ಲಿಕ್ಟ್ಗಳಿದೆ. ಅದನ್ನು ಹೇಗೆ ಬ್ಯಾಲೆನ್ಸ್ ಮಾಡೋದು ಅನ್ನೋದು ತುಂಬ ಸಮಸ್ಯೆ. ರೈಟ್ ಟು ನೋ ಇದೆ, ರೈಟ್ ಟು ಪ್ರೈವೇಸಿ ಇದೆ. ದೆರ್ ಈಸ್ ಎ ಕಾನ್ಫ್ಲಿಕ್ಟ್, ವಿ ಹ್ಯಾವ್ ಟು ಬ್ಯಾಲೆನ್ಸ್ ದಿಸ್. ತುಂಬ ಈಸಿಯಾಗಿ ಹೇಳ್ಬಿಡ್ತಾರೆ, ಡಿಸಿಷನ್ ಕೊಟ್ಬಿಟ್ರು. ಜಸ್ಟಿಸೇ ರಿಟೈರ್ಡ್ ಆದೋ ಜಸ್ಟಿಸ್ ಪುಟ್ಟಸ್ವಾಮಿ ಅವ್ರು ಬಂದುಬಿಟ್ಟಿದ್ದಾರೆ, ನಾವು ಅವ್ರಿಗೆ ನ್ಯಾಯ ಕೊಡದೇ ಇದ್ರೆ ಹೆಂಗೆ ಅಂತ. ರೈಟ್ ಟು ಪ್ರೈವೇಸಿ ಇಸ್ ಎ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಅಂದರು. ಕ್ಯಾನ್ ವಿ ಮೇಕ್ ಎ ಲಾ ಇನ್ ದ್ಯಾಟ್ ರಿಗಾರ್ಡ್? ಇಟ್ಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್. 2018ರಲ್ಲಿ ಲಾ ಮಾಡಿದ್ರು, 19ರಲ್ಲಿ ಮಾಡಿದ್ರು, ಡ್ರಾಫ್ಟ್ ಸುಮಾರು ಸರಿ ಅಮೆಂಡ್ ಆಗ್ತಾನೆ ಇದೆ. ಅದು ಯಾವ ಕಾಲಕ್ಕೆ ಫೈನಲೈಸ್ ಆಗ್ತದೆ ಗೊತ್ತಿಲ್ಲ. ನಾವು ಒಂಥರ ಟ್ರಾನ್ಸಿಷನ್ ಸ್ಟೇಜಲ್ಲಿ ಇದ್ದೀವಿ. ಮೇ ಬಿ ಕಾನ್ಫಿಡೆನ್ಷಿಯಲ್ ಕಮ್ಯುನಿಕೇಷನ್ ವಿತ್ ಲೀಗಲ್ ಅಡ್ವೈಸರ್ಸ್ ಅದನ್ನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಬಾರ್ದು ಅಂತ, ಪ್ರೊಫೆಷನಲ್ ಕಮ್ಯುನಿಕೇಷನನ್ನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಬಾರ್ದು ಅಂತಲೂ ಇದೆ. ಡಾಕ್ಟರ್ಸ್ ಆಗಿರಲಿ ಅಥವಾ ಲಾಯರ್ಸ್ ಆಸ್ ಸಚ್, ವಿ ಆರ್ ಬೌಂಡ್ ಬೈ ಸರ್ಟನ್ ಎಥಿಕ್ಸ್ ಆರ್ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಆರ್ ಲಾ ಆಸ್ ಸಚ್. ಮೇ ಬಿ question intended to insult, annoy or annoy. Maybe confession caused by inducement, threat or promise when irrelevant in criminal proceedings. Confession ಒಂಥರ ಈ ಪ್ಲೀ ಬಾರ್ಗೇನಿಂಗ್ ಅಥವಾ ಮತ್ತೊಂದು ಸಿಚುವೇಶನ್, ಈಸ್ ಆಲ್ಸೋ ಒನ್ ಆಫ್ ದಿ ಪಾರ್ಟಿ ಟು ಅಪ್ರೂವರ್, ಆಸ್ ಅಪ್ರೂವರ್ ಅಂತ ಆದರೆ ಒಂದು ರೀತಿಯಲ್ಲಿ ಕನ್ಫೆಷನ್ನೇ ಅಲ್ಲಿ, ಲೀಡಿಂಗ್ ಟು ದಿ ಡಿಸ್ಕವರಿ ಆರ್ ವೆರಿ ಈಸಿ ಫಾರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ಸೊ ಅದನ್ನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಬಾರ್ದು ಆಫೀಸರ್ ಇನ್ ಚಾರ್ಜ್ ಅಂತೇಳಿ ಇದೆ. ಸೊ ಈ ಥರದ್ದೆಲ್ಲ ನಮಗೆ ಲೀಗಲ್ ಪ್ರಾವಿಷನ್ಸು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದೆ. ಫೋನ್ ಟ್ಯಾಪಿಂಗ್ ಅಥವಾ ವೈರ್ ಟ್ಯಾಪಿಂಗ್ ಟೆಕ್ನಾಲಜಿ ಜೊತೆಗೇ ಸೆಕ್ಯೂರಿಟಿ ಆಫ್ ದ ಸ್ಟೇಟ್ ಬಗ್ಗೆನೂ ತುಂಬ ಪ್ರಶ್ನೆಗಳಿದೆ. ಇದು ಮಾಡ್ತಾ ಇರೋದು ಫಾರ್ ದ ಸೆಕ್ಯೂರಿಟಿ ಆಫ್ ದ ಸ್ಟೇಟ್ ಅಂತ. ಆ ಕಾಂಟೆಕ್ಸ್ಟಲ್ಲಿ ನೋಡಿ, ಯಾವಾಗ ಲಾನ ಎನ್ಯಾಕ್ಟ್ ಮಾಡೋಕ್ಕೆ ಹೋದಾಗ ಗೌರ್ಮೆಂಟಲ್ ಅಥವಾ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಲಾಬಿ ಹೇಗಿರುತ್ತೆ ಅಂದರೆ, ದೇ ವಾಂಟ್ ಟು ಹ್ಯಾವ್ ಸಮ್ ಮೋರ್ ಪ್ರೊಟೆಕ್ಷನ್. ದೇ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಟೋಟಲಿ ಗಿವ್ ಸಚ್ ಟೈಪ್ ಆಫ್ ಫ್ರೀ ಝೋನ್ ಫಾರ್ ದಿ ಕಾಮನ್ ಮ್ಯಾನ್ ಆರ್ ದ ಇಂಡಿವಿಜುವಲ್. In fact, Professor C.S. Patil was the person involved in drafting of human rights rules for Karnataka state. He has drafted such 48 sections there. And district session courts have been designated as human rights courts. Many district judges not aware of these rules. Right to be forgotten. That is what, maybe that 48 sections was trickled down to some 15 or 16 sections. Only police officers are considered to be violators of human rights now. Earlier he has covered many, but executive is not ready to come under the rubric or cobwebs of the law. That's why I mentioned bureaucracy always would like to be in secrecy. They want to carry out everything, not making known to the common man. So more transparency is required. participation of the people in the policy making is required, and for the wrongful exercise of the power or abuse of the power in disclosing the information of a common man, they must be made accountable. TAP is the norm nowadays: transparency, accountability and participation. So that we have to consider. Regarding this marital privacy, in fact, and the health, especially mental health as such, Justice Ramohan Reddy has come out with X versus Z, like that, privacy, that very donation of the blood offered by a person who brought that patient was found to be HIV positive, and information was leaked by the Apollo Hospital to the father of that girl, and finally betrothal ceremony was overcome by cancelling that very marriage. And he moved the court for leaking his information, whether the right to privacy to be maintained at the cost of the right to life of that girl who is supposed to marry that man. This is conflict between this health and the health information and the privacy of the person. So like that, even the DNA technology is there, either to find the paternity for giving maintenance to the wife who is in distress. See, there was an objection that going for DNA test will reveal information and it violates my privacy right, like that, but court said in some eminent circumstances there can be conducting of such tests as such. So these are some of the aspects that we must take note while considering this very privacy, and you might be aware of this very 377 partially read down in this very Navtej Singh versus Union of India in 2018, and some of the paragraphs that has been mentioned in Puttaswamy case has been taken into account for reading down that very section 377, because the remaining part may tackle a situation where this very carnal sex or unnatural sex may be considered as a business because there is a privacy. That's why to punish them, this remaining part of 377 continues to be constitutionally valid. This right to privacy may be possible to be misused to legalize prostitution. This is possible circumstances. So this is not it so far in the Indian context. So privacy consequences may lead to this. That's why 377 remaining part continues to be valid constitutionally, but this very prostitution may creep into this very business, and it may be legalized in the coming days. Nobody knows. So this very right to be forgotten as such. This is one more right we require. Now once the purpose is over, why unnecessary the information is to be, continues to be there? See, for example, after my death, after my demise, what is the fun in continuing the information or the data given by me? ನಾವು ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತೀವಿ ಎಲೆ ಮರೆಕಾಯಿ ರೀತಿಯಲ್ಲಿ ಇದ್ದು ಹೋಗೋಣ ಅಂತ, ಅನ್ನೋಟಿಸ್ಡ್. So ಆ ಸೆನ್ಸಲ್ಲಿ after my demise also or the person's demise also, if the data is continued to be there, see, when the dead body itself is not a property, we have to consider the jurisprudential aspect of the person. Here but data continues to be there in the such type of data maintaining corporate bodies. Now I should be forgotten. So I must have that right to be forgotten as such, and these aspects we must give due importance, and maybe some mandatory consent is required for divulgence of any personal information. ನಾನು ಅದೇ ಸರ್ ಹೇಳಿದ್ರು, ಏನು ರಾಮಮೋಹನ್ ರೆಡ್ಡಿ ಅವರು ಅಕ್ಸೆಪ್ಟ್ ಅಂತ ಮಾಡಬೇಕಾದ್ರೆ ದಯಮಾಡಿ ಒಂದು ಸರಿ ಅಲ್ಲಿ ಓದಬೇಕು. ನೋಡಿ, ಒಂದು ಉದಾಹರಣೆಗೆ ಒಂದು ಎಕ್ಸಾಂಪಲ್, ಈ BSNL ಅವ್ರದ್ದು ಫೋನ್ ಒಂದು 25 ವರ್ಷದ ಕೆಳಗೆ 3 ನಿಮಿಷ ಮಾತಾಡಿದರೆ 24 ರೂಪಾಯಿ ಚಾರ್ಜ್ ಮಾಡೋರು. ಬೆಳಿಗ್ಗೆ ಟ್ರಂಕಲ್ಲಿ ಬುಕ್ ಮಾಡಿದರೆ ಒಂದು ವಿಕೆಟ್ ಉರುಳೋಗಿದೆ ಅಂತ ಹೇಳಬೇಕು, ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆ ಕನೆಕ್ಷನ್ ಕೊಡೋರು. ಕಾಂಪಿಟೇಷನ್ ಬಂದ ಮೇಲೆ ಈಗ ಎಲ್ಲರ ಹತ್ರನೂ ಟೆಲಿಫೋನ್ ಎಕ್ಸ್ಚೇಂಜ್ ಥರ ಆಗಿಬಿಟ್ಟಿದೆ ಈಗ. ಇನ್ಕಮಿಂಗ್ ಕಾಲ್ ಅಂದರೆ ಅದಕ್ಕೂ ಚಾರ್ಜ್ ಆಗ್ತಾ ಇತ್ತು. ನಾನಿಲ್ಲಿ ಹೇಳಕ್ಕೆ ಹೊರಟಿರೋದು ಪೋಸ್ಟಲ್ ಲೈಫ್ ಇನ್ಶೂರೆನ್ಸ್ ಅಂತ ಒಂದಿದೆ. ಈ ಲೈಫ್ ಇನ್ಶೂರೆನ್ಸ್ ಅವ್ರು ಹೇಗೆ ಮಾಡ್ತಾರೆ, ಅಲ್ಲಿ ಯಾರು ಏಜೆಂಟ್ಸ್ ಇರಲ್ಲ. ಸುಮ್ಮನೆ ಅಲ್ಲಿ ಇನ್ಫಾರ್ಮೇಷನ್ ಎಂಟ್ರ್ ಆದರೆ ಅಲ್ಲೊಂದು ಕ್ಲಾಸ್ ಬರ್ಕೊಂಡಿದ್ದಾರೆ ಗೌರ್ಮೆಂಟ್ ಆಫ್ ಇಂಡಿಯಾದವರು. ನೀವು ಯಾರಾದರೂ ಒಂದು ರಿಟ್ ಫೈಲ್ ಮಾಡೋದಾದರೆ ಅಲ್ಲಿ ಒಂದು ಕ್ಲಾಸ್ ಏನು ಬರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂದರೆ 5 ವರ್ಷದೊಳಗೆ ನೀವು ಈ ಪಾಲಿಸಿಯನ್ನು ಲೈಫ್ ಎಂಡೋಮೆಂಟ್ ಪಾಲಿಸಿಯಾಗಿ ಕನ್ವರ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳದೇ ಇದ್ದರೆ ಇದು ಲೈಫ್ ಪಾಲಿಸಿಯಾಗಿ ಮುಂದುವರಿಯುತ್ತೆ. ಸೈನ್ ಆಗಬೇಕಾದ್ರೆ ನಾವು ಯಾರೂ ನೋಡಲ್ಲ. ಪಾಲಿಸಿ ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ನನ್ನ ಟೈಮಲ್ಲಿ ಒಂದು 20 ವರ್ಷಕ್ಕೆ ಎಂಡ್ ಆಗತ್ತಾ, ಹಾಗಾದರೆ ಅವಾಗ ದುಡ್ಡು ಬಂದರೆ ತಗೊಳ್ಳೋಣ ಅಂತ ನೀವು ಹೋದರೆ, ಸರ್ ನೋಡಿ ಟರ್ಮ್ಸ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟಲ್ಲಿ ನೀವು ಸೈನ್ ಹಾಕಿದ್ದೀರಾ, 5 ವರ್ಷದ ಒಳಗಡೆನೆ ನೀವು ಎಂಡೋಮೆಂಟ್ ಪಾಲಿಸಿಯಾಗಿ ಅದನ್ನು ಕನ್ವರ್ಟ್ ಮಾಡಿದರೆ ನಿಮ್ಮ ಮೆಚುರಿಟಿ ಟೈಮ್ ಆದ ತಕ್ಷಣ ದುಡ್ಡು ಕೊಡ್ತಾ ಇದ್ವಿ ಅಂತ. ಈಗ ನೀವು ಯಾವಾಗ ಎಂಡೋಮೆಂಟ್ ಪಾಲಿಸಿಯಾಗಿ ಕನ್ವರ್ಟ್ ಮಾಡಲಿಲ್ಲ, ಇದು ಲೈಫ್ ಪಾಲಿಸಿ ಆಗಿದೆ ಸರ್, ಇನ್ನು ನೀವು ದುಡ್ಡು ತಗೋಬೇಕು ಅಂದರೆ 40 ವರ್ಷ ಆದಮೇಲೆ ತಗೋಬೇಕು ಅಂತ. ಅದು ಮುಂಚೆ ಏನಾಗಿತ್ತು, ಆಫ್ಟರ್ ದಿ ಡಿಮೈಸ್ ಆಫ್ ದ ಪಾಲಿಸಿ ಹೋಲ್ಡರ್ ಅವರ ಡಿಪೆಂಡೆಂಟ್ಸಿಗೆ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸಿಗೆ ಕೊಡ್ತಾ ಇದ್ರು. ತುಂಬ ಪ್ರೆಸರ್ ಮಾಡಿದ ಮೇಲೆ ಅದನ್ನು 85 ಇಯರ್ಸಿಗೆ ಇಳಿಸಿದ್ದಾರೆ. ಅಂದರೆ ಗೌರ್ಮೆಂಟ್ ಇಸ್ ದ ಬಿಗ್ಗೆಸ್ಟ್ ಎಕ್ಸ್ಪ್ಲಾಯ್ಟರ್. ಗೌರ್ಮೆಂಟ್ ವುಡ್ ಲೈಕ್ ಟು ಬಿ ಇನ್ ಸೀಕ್ರೆಸಿ. ಅದೇ ಬ್ಯೂರೋಕ್ರಸಿ ಇನ್ ಸೀಕ್ರೆಸಿ ಅನ್ನಲ್ಲ, ನಮ್ಮ ಟೈಪ್ ಆಫ್ ಏನು ಸಿವಿಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಇದೆ ಅವರಿಗೆ ಫೇರ್ ಮೆಂಡಾಗಿ ಬರೀ ಎಫಿಷಿಯನ್ಸಿ ಬಗ್ಗೆ ಮಾತ್ರ ನಾವು ಹೇಳ್ತಾ ಇದ್ದೀವಿ, ಫೇರ್ನೆಸ್ ಅವ್ರ ಹತ್ರ ಇಲ್ಲ. ದಟ್ ಈಸ್ ಸೀಕ್ರೆಸಿ. ನಮ್ಮದೇ ಎಲ್ಲ ಡಾಟಾ, ನಮ್ಮದೇ ಎಲ್ಲ ದುಡ್ಡು, ಆದರೆ ಅವರು ಅದನ್ನು ಡಿಸ್ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ. ಎಲ್ಲಿಗೆ ಬರ್ತೀವಿ ನೋಡಿ ನಾವು. ಸೊ ದಿಸ್ ಈಸ್ ಹೌ our information, our money, our liberty, our life is exploited, and the biggest exploiter is government. Right to privacy ಅನ್ನೋದು ಏನಾದರೂ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಆದರೆ ನಾವು ಆಗ ಒಂದು ಅಡ್ವಾಂಟೇಜ್ ಏನು ಮಾಡ್ಬೋದು ಅಂದರೆ ಎಗೇನೆಸ್ಟ್ ದ ಸ್ಟೇಟ್ ಮೂವ್ ಆಗೋದಲ್ಲದೆ ಯಾರ್ಯಾರು ನಮ್ಮ ಜನದ ಡಾಟಾನ ಹೊಂದಿದ್ದಾರೆ ಅವರು ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ, ಅವ್ರ ಮೇಲೂ ನಾವು ಈಗ ICI ಕ್ರಿಕೆಟ್ ಬೋರ್ಡ್ ಆಫ್ ಇಂಡಿಯಾ BCCI is not a state, but still the court has issued the direction constituting a committee to look into the malpractices or corrupt practices. ಅದೇ ಥರ ಈಗ ನಾಳೆ ನಿಮ್ಗೆ ನೆನಪಿರಬೇಕು, ಈ ಮೆಟಾ ಆಗಲಿ ಅಥವಾ ಅದಾನಿ ಗ್ರೂಪ್ ಆಗಲಿ ಅಥವಾ ರಿಲಯನ್ಸ್ ಅವರಾಗಲಿ ಯಾರಾದರೂ ಈ ಡಾಟಾ ಬಗ್ಗೆ ಕಾರ್ಪೊರೇಟ್ ಸೆಕ್ಟರನ್ನು ಓಪನ್ ಮಾಡಿದರೆ ದಟ್ ಡಾಟಾ ಬಿಲಾಂಗ್ಸ್ ಟು ದ ಕಾಮನ್ ಮ್ಯಾನ್ ಆಫ್ ದಿಸ್ ಲ್ಯಾಂಡ್. Any invasion, any violation, any infringement of our data, any selling of data, you are entitled for as a beneficiary. ಆ ಥರ ಆಗಬೇಕು, that may infringe your data. ಹಾಗಾಗಿ you must have the latest knowledge and updating always with respect to, and you have to get equipped with the pace of the technological developments. Then only you can save yourself, maybe in the context of life, that is possible by enjoying this liberty that is always coupled with that power, coupled with duty is liberty. So you have that very power if right to privacy is given to you, and this this very data protection bill is in the pipeline. Try to just contribute in what way the bill can be made good for the protection of the information related to person, as we are having sufficient legal provisions to tackle the privacy, physical privacy or mental privacy of the common man. I think this would be sufficient, as Professor C.S. Patil will be dealing with the accountability I think for the disclosure of information and what steps can be taken in that regard. Thank you for your listening.
Thank you, sir, for your words of wisdom. I humbly seek the permission of the dignitaries to start the technical session too. Sir. Yes, sir. Thank you, sir. I'm extremely delighted to pronounce that in session 2, we have with us a doyen of knowledge, Professor Dr. C.S. Patil, Professor of Law, Head, Research Center, Research in Democracy and Constitutional Government, KSLU Hubballi. Sir will be addressing us on the topic Accountability Regime of Violation of Privacy. I request Ms. Vashika, student of 5th semester BBA LLB, to introduce your resource persons to the gathering.
Known to the globe. ನನಗೆ ಎವ್ರಿ ಮಂತು ರಿಪೋರ್ಟ್ ನನಗೆ ಮೇಲಲ್ಲಿ ಬಂದ್ಬಿಡುತ್ತೆ ಗೂಗಲ್ ಸರ್ ಹೇಳ್ದಂಗೆ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಬರೋದು ಎವ್ರಿ ಮಂತ್ ಎಲ್ಲೆಲ್ಲಿ ಹೋಗಿದ್ರಿ ನೀವು ಎಲ್ಲಿ ಹೋಗಿ ಬಂದ್ರಿ ಅಂತೇಳಿ ಅದನ್ನು ನನ್ನ ಹೆಂಡ್ತಿ ನೋಡಿದರೆ ಗೊತ್ತಾಗತ್ತೆ ಅಲ್ವಾ ರೈಟ್ ಟು ಬಿ ಲೆಟ್ ಅಲೋನ್ ಹೇಗೆ ಕಷ್ಟ ಅದ್ಯಾಕೆ ಹೋಗಿದ್ರಿ ಆರ್ ವಿ ಕಾಲೇಜ್ಗೆ ಪ್ರೈವೇಸಿ ಬಗ್ಗೆ ಮಾತಾಡೋಕ್ಕೆ ನಿಮ್ಮ ಪ್ರೈವೇಸಿ ನೋಡಿ ಇಲ್ಲಿ ಡಿಸ್ಕ್ಲೋಸ್ ಆಗಿದೆ ಅಂತ ಅಲ್ವಾ ನಮಗೆ ಅಂದರೆ ಈ ಮೆಟಾವರ್ಸ್ ಅನ್ನೋದು ಬಂದ ಮೇಲೆ ದಟ್ ಈಸ್ ಎನ್ ಎಂಡ್ ಆಫ್ ಪ್ರೈವೇಸಿ ಅಂತ ಸೊ ಹೌ ಟು ಪುಟ್ ಎ ಲೀಗಲ್ ಫ್ರೇಮ್ವರ್ಕ್ ಫಾರ್ ದೀಸ್ ಪೀಪಲ್ ಒನ್ ಹೂ ಈಸ್ ಡೂಯಿಂಗ್ ಪಬ್ಲಿಕ್ ಫಂಕ್ಷನ್ ನಮ್ಮ ಸಾಮಾನ್ಯ ಜನದ ಡಾಟಾ ಅವ್ರ ಹತ್ರ ಇದೆ ಅಂದರೆ for what purpose it was given, only for that purpose it has to be made use and nothing more than that. ನೀವು KYC ಅಂತ ಏನಿದೆ ಅದೂ ಅಷ್ಟೇ ನೋ ಯುವರ್ ಕಸ್ಟಮರ್ ಅನ್ನೋ ಹೆಸರಲ್ಲಿ ಸುಮ್ಮನೆ ವರ್ಷಕ್ಕೊಂದ್ಸರಿ ಬನ್ನಿ ಕೊಡಿ ಅಂತ ಇರ್ತಾರೆ ಅದನ್ನು ಮತ್ತಾರಿಗೋ ಮಾರ್ಕೊಳ್ತಾ ಇರ್ತಾರೆ ಅವನು ನನಗೆ ಫೋನ್ ಬರುತ್ತೆ ಸರ್ ನಾವೊಂದು ನಿಮಗೆ ಒಂದು 10 ಲಕ್ಷ ಲೋನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿದೆ ಸರ್ ತಗೊಳ್ಳಿ 10 ಲಕ್ಷ ಸಾಗಲ್ಲ ಒಂದು 10 ಕೋಟಿ ಕೊಡಿ ಅಂತೀನಿ ನಾನು ಆರ್ ವಿ ಕಾಲೇಜ್ ಥರ ನಾನೊಂದು ಲಾ ಕಾಲೇಜ್ ಕಟ್ಟಬೇಕು ಅಂತ 10 ಕೋಟಿನ ಸರ್ ಅದು ಮತ್ತು 10 ಲಕ್ಷ ತೊಗೊಂಡು ಏನು ಮಾಡ್ತೀರಾ ಸಿ ಅನ್ಲೆಸ್ ಈ ನ್ಯೂ ಅಬೌಟ್ ಮೈ ಸಿಬಿಲ್ ಸ್ಕೋರ್ ಈ ವಿಲ್ ನಾಟ್ ಮೇಕ್ ಎನ್ ಅಡ್ವಾನ್ಸ್ ಅಲ್ವಾ ಸಿಬಿಲ್ ಸ್ಕೋರ್ ಅನ್ನೋದು ಅವನಿಗೆ ಗೊತ್ತಿದೆ ಈ ಬ್ಯಾಂಕ್ ಅವರು ಅವನಿಗೆ ಮಾರ್ಕೊಂಡಿದ್ದಾರೆ ಈ ಸಾಲ ತಗೊಂಡಿದ್ದಾರಲ್ಲ ಈ ಮೇಷ್ಟ್ರು ಚೆನ್ನಾಗಿ ತೀರಿಸ್ತಾರೆ ಅವರು ಬೇರೆಯವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದರೆ ಇದು ಲಾಂಗ್ ಬ್ಯಾಕ್ ದಿ ಡಿಡ್ ಇನ್ ಯುನೈಟೆಡ್ ಸ್ಟೇಟ್ಸ್ ಬಿಸ್ನೆಸ್ ಏರಿಯಾದಲ್ಲಿ ಡಾಟಾ ಕಲೆಕ್ಟ್ ಮಾಡಿ ಕ್ರೆಡಿಟ್ ವರ್ತಿನೆಸ್ ಅನ್ನೋದನ್ನ ಒಬ್ಬರು ಅಸೆಸ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತಾರೆ ಅಲ್ಲಿ ಇವನಿಗೆ ಸಾಲ ಕೊಡ್ಬೋದು ಇವನಿಗೆ ಸಾಲ ಕೊಡ್ಬೋದು ಅವ್ನು ಸಾಲ ತೀರಿಸ್ತಾನೆ ಅದನ್ನು ಅವನು ಹಂಚ್ಕೊಳ್ಳೋಕೆ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾನೆ ನೋಡಿ ಇದೆಲ್ಲ ಬಿಸ್ನೆಸ್ ಅಂದರೆ ಇವತ್ತು ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ದಲ್ಲ ಅವತ್ತೇ ಈಗ ಒಬ್ಬನಿಗೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವನು ಯಾರೋ ಒಬ್ಬ ಹಳೇದು ಓದ್ಬಿಟ್ಟ ಇದ್ರಲ್ಲಿ ಮಾಡ್ಬೋದು ದುಡ್ಡು ಅಂತ ಸೊ ಯು ಮಸ್ಟ್ ಬಿ ವೆರಿ ಕೇರ್ಫುಲ್ ವೈಲ್ ಗಿವಿಂಗ್ ಇನ್ಫಾರ್ಮೇಷನ್ ಟು ಸಂಬಡಿ ನೋಡಿ ನಿಮ್ಗೆ ಗೊತ್ತಿರೋರೇ ನಿಮಗೆ ಬಗಲ್ ಮೇ ಆಯ್ ದುಶ್ಮನ್ ಅಂತ ಅಲ್ವಾ ನಮ್ಮ ಮಾಹಿತಿ ಬಗ್ಗೆ ನಮ್ಗೆ ಗೊತ್ತಿರೋರೇ ಮುಂದೆ ನಮ್ಮ ಶತ್ರುಗಳು ಮಾಹಿತಿಯನ್ನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಬೇಕಾದ್ರೆ ಇನ್ಫಾರ್ಮೇಷನಲ್ ಪ್ರೈವೇಸಿ ಅನ್ನೋದು ಒಂದು ಬಾಡಿಲಿ ಪ್ರೈವೇಸಿ ಅನ್ನೋದು ಮತ್ತೊಂದು ಫಿಸಿಕಲ್ ಪ್ರೈವೇಸಿ ಬೇರೆ ಇನ್ಫಾರ್ಮೇಷನಲ್ ಪ್ರೈವೇಸಿ ಬಗ್ಗೆ ಇನ್ಫಾರ್ಮೇಷನ್ ಪ್ರೈವೇಸಿ ಕೊಡಬೇಕಾದ್ರೆ ಯು ಮಸ್ಟ್ ಬಿ ಮೋರ್ ಕಾಶಿಯಸ್ ಬಟ್ ಬಾಡಿಲಿ ಪ್ರೈವೇಸಿ ಅನ್ನೋ ವಿಚಾರ ಬಂದಾಗ ಬೇರೆ ಬೇರೆ ಸಮಸ್ಯೆಗಳಿದ್ದಾವೆ ಅಲ್ಲಿ ಎಸ್ಪೆಷಲಿ ನಾವು ಇದನ್ನು 1983 ಆನ್ವರ್ಡ್ಸ್ ನಾನು ಸರ್ವೆಲೆನ್ಸ್ ಬಗ್ಗೆ ಒಂದು ಹೇಳಿದೆ ಗೋವಿಂದ್ ಕೇಸ್ ಅಷ್ಟೊತ್ತಲ್ಲಿ ರೈಟ್ ಟು ಲೈಫ್ ಅಂದರೆ ಏನು ಅನ್ನೋದನ್ನು ಸ್ವಲ್ಪ ಮಟ್ಟಿಗೆ ಟಚ್ ಮಾಡ್ತಾರೆ ಅಂತ ಬಟ್ 1983 ಅಷ್ಟೊತ್ತಿಗೆ ಈ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್ ಬಗ್ಗೆ ಒಂದು ಕೇಸ್ ಆಗತ್ತೆ ಸರಿತಾ ವರ್ಸಸ್ ವೆಂಕಟ್ ಸುಬ್ಬಯ್ಯ ಈ ಫೇಮಸ್ ಫಿಲಮ್ ಆ್ಯಕ್ಟ್ರೆಸ್ ಇದು ಪಾಪ ಅವಳು 8th or 9th ಓದ್ತಾ ಇದ್ಲು ಅವಳ ಗಂಡನ ಅಣ್ಣಂಗೆ ಮದುವೆ ಈ ಆಂಧ್ರ ಪ್ರದೇಶಲ್ಲಿ ಕರ್ನಾಟಕದ ರೂರಲ್ ಭಾಗಲ್ಲಿ ಒಂದು ಕಸ್ಟಮರಿ ಪ್ರಾಕ್ಟೀಸು ದೊಡ್ಡವನಿಗೆ ಮದುವೆ ಮಾಡ್ಬೇಕಾದ್ರೆ ಸಣ್ಣವನಿಗೂ ಮಾಡಿಬಿಡಿ ಯಾಕಂದರೆ ಮುಂದೆ ಇವರೆಲ್ಲ ಹೊರಗೆ ಹೋದರೆ ಅವ್ರನ್ನ ಕೇಳೋರು ಯಾರೂ ಇರಲ್ಲ ಈಗಲೇ ಮಾಡಿಬಿಡಿ ಅಂತ ಸರಿತಾ ಅಲ್ಲಿ ಹೈಸ್ಕೂಲ್ಗೆ ಹೋಗೋ ಹುಡುಗಿ ವೆಂಕಟ್ ಸುಬ್ಬಯ್ಯ ಕಂಟ್ರಿ ಮ್ಯಾನ್ ಅವ್ರಿಗೆ ಮದುವೆ ಮಾಡಿಬಿಟ್ರು ಅವನಲ್ಲ ಅವನ ಪಾಡಿಗೆ ಅವ್ರ ಊರಲ್ಲಿದ್ದಾನೆ ಇವನ ಪಾಡಿಗೆ ಇವಳು ಸ್ಕೂಲ್ಗೆ ಹೋಗ್ತಾ ಇದ್ದಾಳೆ ಒಂದು ದಿವಸ ಯಾರೋ ಅವಳು ಪೋಸ್ಟರ್ ನೋಡ್ಬಿಟ್ಟ, ಫೇಮಸ್ ಫಿಲಮ್ ಆ್ಯಕ್ಟ್ರೆಸ್ ಆಗಿ ಪೋಸ್ಟರ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಪಿಕ್ಚರಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ. ಅವ್ನು ಕೇಳ್ದ ವೆಂಕಟ ಸುಬ್ಬಯ್ಯಂಗ ಅವ್ನ ಫ್ರೆಂಡು, ನಿನ್ನ ಹೆಂಡ್ತಿ ಅಲ್ವಾ ಹೇಳು? ಹೌದೌದು. ಹಾಕಕ್ಕೆ ಸರ್ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್ ಆಯ್ತು, ಅವಳು ಬರಲಿ ನಿನ್ನ ಮನೆಗೆ ಅಂತ. ಅವಳಿಗೆ ಮರ್ತೇ ಹೋಗ್ಬಿಟ್ಟಿದ್ದೇವೆ ನಿಮ್ಮ ಮದುವೆ ಆಗಿದ್ದೀನಿ ಅಂತ. ಆಟ ಆಡ್ತಾ ಇದ್ರು, ಕರ್ಕೊಂಬಂತು, ಮದುವೆ ಮಾಡಿಬಿಟ್ರು. ಈಗ ನೋಡಿದರೆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇದೆ, ಹೋಗಮ್ಮ ವೆಂಕಟ ಸುಬ್ಬಯ್ಯನ ಜೊತೆಗೆ. ನೋ, ಅಟ್ ದ ಇನ್ಸ್ಟೆನ್ಸ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಡಿಕ್ರಿ ಶಿ ಹ್ಯಾಸ್ ಟು ಬಿಗೆಟ್ ಎ ಚೈಲ್ಡ್ ಫಾರ್ ಹಿಮ್ ಹೂ ಈಸ್ ಅನ್ನೋನ್ ಟು ಹಿಮ್. ಬರೀ ಒಂದು ಮಂಗಳಸೂತ್ರ ಕಟ್ಟಿದ, ಆಮೇಲೆ ಪತ್ತೆ ಇಲ್ಲ, ಅವನ ಜೊತೆಗೆ ಸಂಸಾರ. ವಾಟ್ ರೈಟ್ ದ ಕೋರ್ಟ್ ಈಸ್ ಹ್ಯಾವಿಂಗ್ ಇನ್ ಬಿಟ್ವೀನ್ ದ ಹಸ್ಬೆಂಡ್ ಆ್ಯಂಡ್ ವೈಫ್ ಅಲ್ವಾ? 122 ಅಲ್ಲಿ ಅವ್ರು ಏನು ಮಾತಾಡ್ತಾರೆ ಅದನ್ನು ನೀವು ಕಮ್ಯುನಿಕೇಷನ್ನ ಹೊರಗೆ ತೆಗಿಯಂಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಂಗ್ಲೆಂಡಲ್ಲಿ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್ ಡಿಕ್ರಿನ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಆದರೆ ದಟ್ ಲೇಡಿ ಈಸ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ದ ರೈಟ್ ಹಿಯರ್ ಬಿಕಾಸ್ ಆಫ್ ದ ಆರ್ಡರ್. ಅಟ್ ವಾಟ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಶಿ ಕ್ಯಾನ್ beget child for him, or she can lose her privacy right. And maybe even with respect to the marital rape being not considered as an offense even today, whether that amounts to invasion of privacy when she is not willing for that. ಈ ಥರದ್ದೆಲ್ಲ ಬಾಡಿಲಿ ಪ್ರೈವೇಸಿ ವಿಚಾರದಲ್ಲಿ ನಮ್ಮ ಮುಂದೆ ಬರ್ತಕ್ಕಂಥದ್ದು. ಇಂಡಿಯನ್ ಪೀನಲ್ ಕೋಡಲ್ಲೂ ಈ ಥರದ ಕೆಲವು ವಿಚಾರ ಇದೆ. ಸೆಕ್ಷನ್ 354 ಕ್ಲಾಸ್ 3ಅಲ್ಲಿ, ಎನಿ ಮ್ಯಾನ್ ಹೂ ವಾಚಸ್ ಆರ್ ಕ್ಯಾಪ್ಚರ್ಸ್ ದ ಇಮೇಜ್ ಆಫ್ ಎ ವುಮನ್ ಎಂಗೇಜಿಂಗ್ ಇನ್ ಪ್ರೈವೇಟ್ ಆ್ಯಕ್ಟ್, ದಟ್ ಈಸ್ ಅನ್ ಅಫೆನ್ಸ್. ಪ್ರೈವೇಸಿ, ವೈರಿಸಮ್, ಸ್ಟಾಕಿಂಗ್, ನಿರಂತರವಾಗಿ ಬೆನ್ನತ್ತೋದು ಮಾತಾಡ್ಸಕ್ಕೆ, that is also offense. Privacy ಬಿಡೋದಿಲ್ಲ. let to be alone ಅಂದ್ರೆ ಇಲ್ಲ. no you can't be alone ಅಲ್ವಾ? ತುಂಬ ಸಮಸ್ಯೆ. ವ್ಯಕ್ತಿಯಾಗಿ ಇರಲಿಕ್ಕೆ ನಾವು ಅವಕಾಶ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿದರೆ, ಪ್ರತಿ ಸ್ಟೇಜಲ್ಲೂ ಇನ್ವೇಷನ್ ಆಫ್ ಪ್ರೈವೇಸಿ ಅಂತೇಳಿ. ನೋ, ಐ ಆಮ್ ಸ್ಪೀಕಿಂಗ್ ಅಬೌಟ್ ಪಬ್ಲಿಕ್ ರಾಂಗ್, ನಾಟ್ ಪ್ರೈವೇಟ್ ರಾಂಗ್. ಸೊ ಇದೆಲ್ಲ ಇಂಡಿಯನ್ ಪೀನಲ್ ಕೋಡಲ್ಲಿ ನಾವು ಸೇರಿಸಿದ್ದೀವಿ ಅಂದರೆ ಅರ್ಥ ಅದೇನೆ. ಮೇ ಬಿ ಡಿಸ್ಕ್ಲೋಸರ್ ಆಫ್ ಐಡೆಂಟಿಟಿ ಆಫ್ ದ ವಿಕ್ಟಿಮ್ ಆಲ್ಸೋ. ದಿಸ್ ಇಸ್ ವಾಟ್ ಐ ಕ್ಯಾನ್ ಸೇ ದ ಲಿಮಿಟೇಷನ್ ಇಂಪೋಸ್ಡ್ ಅಪಾನ್ ದ ಪ್ರೆಸ್ ಪೀಪಲ್. ಅಷ್ಟೆಲ್ಲ ನಾವು ಲಾ ಮಾಡಿಕೊಂಡು 228A ಸೇರಿಸಿದ್ರು ಪ್ರೆಸ್ ಅವರು ಸಮ್ಮಾರ್ ದಿ ಅದರ್ ವೇ, ಅವ್ರ ಮನೆಗೆ ಹೋಗೋದು, ಅವ್ರ ಹೋಗೋದು, ನಿಮ್ಗೆ ಏನಾಯ್ತು ಅವ್ರ ಅಪ್ಪ ಅಮ್ಮಂಗೆ ಕೇಳೋದು, ವಿಕ್ಟಿಮ್ಗೆ ಹೇಳಲ್ಲ ನಾವು. ಲುಕ್ ಇಟ್ ದ ವೇ, ಅದರ್ ವೇ ಯು ಆರ್ ಡಿಸ್ಕ್ಲೋಸಿಂಗ್. ಈ ಥರದ್ದು ಇದ್ರೂ ವಯಲೇಟ್ ಮಾಡಿರೋ ಸಂದರ್ಭಗಳು ತುಂಬಾ ಇದೆ. ಈಗ ವಿಜುವಲ್ ಮೀಡಿಯಾ ಈಸ್ ಬ್ರಿಂಗಿಂಗ್ ಔಟ್ ಎವ್ರಿಥಿಂಗ್ ಆ್ಯಂಡ್ ವಿ ಆರ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ಎನಿ ಸಚ್ ಟೈಪ್ ಆಫ್ ಪ್ರೈವೇಸಿ ಇನ್ ದಿಸ್ ರಿಕಾರ್ಡ್. ಸೊ ಮೇ ಬಿ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿಸ್ ಅನ್ಯಾಚುರಲ್ ಅಫೆನ್ಸಸ್ ಆಲ್ಸೋ 377 that has been read down. It was not declared totally unconstitutional. Only the first part has been read down, and the remaining part, if there is any carnal sex or unnatural sex to that extent, that continued to be a punishable offense. So especially ನಮಗೆ 2013 ಆದಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಲಾ ಅಮೆಂಡ್ಮೆಂಟ್ ಆ್ಯಕ್ಟ್ ಪಾಸ್ ಆದಮೇಲೆ ತುಂಬ ಕಷ್ಟ ಮೆನ್ಗೆ. ನಿರ್ದಿಷ್ಟವಾಗಿ ಯಾವುದೋ ಮೊನ್ನೆ ನೋಡಿ, ಕಂಡಕ್ಟ್ರು ಯಾರೋ ಒಂದು ಗರ್ಲ್ಗೆ ಹಿಜಾಬ್ ಹಾಕೊಂಡು ಬಂದಿದ್ದಾಳೆ, ಅವಳಿಗೆ ನೀನೇ ಐಡೆಂಟಿಟಿ ಪಾಸಲ್ಲಿ ಇರೋದು, ಹೇಗೆ ನಾನು ಐಡೆಂಟಿಫೈ ಮಾಡೋದಮ್ಮ ಅಂತ ಕೇಳಿದ್ದಾರೆ. ನನ್ನ ಕಣ್ಣು ನೋಡಿದರೆ ಗೊತ್ತಾಗಲ್ವಾ ನಿಮಗೆ? ಲುಕ್ ಅಟ್ ದಿಸ್. ಆ ಕಂಡಕ್ಟ್ರು ಏನಾದ್ರು ನಿರ್ದಿಷ್ಟವಾಗಿ ಅವಳ ಕಣ್ಣನ್ನೇ ನೇರವಾಗಿ 30 ಸೆಕೆಂಡುಗಳ ಕಾಲ ನೋಡಿದಲ್ಲಿ ಅದು ಅಪರಾಧ. ನನ್ನನ್ನು ಈ ಕಂಡಕ್ಟ್ರು ನೇರವಾಗಿ ದೃಷ್ಟಿಸಿ ನನ್ನ ಕಣ್ಣನ್ನೇ ನೋಡಿದ ಅಂತ, ಹಾಗೆ ನೋಡೋದು ಅಪರಾಧ ಆಗ್ಬಿಡತ್ತೆ ಅಲ್ವಾ? ಈ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಇದೆ, ಪ್ರೈವೇಸಿ ರೈಟಲ್ಲಿ ಕಾನ್ಫ್ಲಿಕ್ಟ್ಗಳಿದೆ. ಅದನ್ನು ಹೇಗೆ ಬ್ಯಾಲೆನ್ಸ್ ಮಾಡೋದು ಅನ್ನೋದು ತುಂಬ ಸಮಸ್ಯೆ. ರೈಟ್ ಟು ನೋ ಇದೆ, ರೈಟ್ ಟು ಪ್ರೈವೇಸಿ ಇದೆ. ದೆರ್ ಈಸ್ ಎ ಕಾನ್ಫ್ಲಿಕ್ಟ್, ವಿ ಹ್ಯಾವ್ ಟು ಬ್ಯಾಲೆನ್ಸ್ ದಿಸ್. ತುಂಬ ಈಸಿಯಾಗಿ ಹೇಳ್ಬಿಡ್ತಾರೆ, ಡಿಸಿಷನ್ ಕೊಟ್ಬಿಟ್ರು, ಜಸ್ಟಿಸೇ ರಿಟೈರ್ಡ್ ಆದೋ ಜಸ್ಟಿಸ್ ಪುಟ್ಟಸ್ವಾಮಿ ಅವ್ರು ಬಂದುಬಿಟ್ಟಿದ್ದಾರೆ, ನಾವು ಅವ್ರಿಗೆ ನ್ಯಾಯ ಕೊಡದೇ ಇದ್ರೆ ಹೆಂಗೆ ಅಂತ. ರೈಟ್ ಟು ಪ್ರೈವೇಸಿ ಇಸ್ ಎ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಅಂದರು. Can we make a law in that regard? It's very difficult. 2018ರಲ್ಲಿ ಲಾ ಮಾಡಿದ್ರು, 19ರಲ್ಲಿ ಮಾಡಿದ್ರು, ಡ್ರಾಫ್ಟ್ ಸುಮಾರು ಸರಿ ಅಮೆಂಡ್ ಆಗ್ತಾನೆ ಇದೆ. ಅದು ಯಾವ ಕಾಲಕ್ಕೆ ಫೈನಲೈಸ್ ಆಗ್ತದೆ ಗೊತ್ತಿಲ್ಲ. ನಾವು ಒಂಥರ ಟ್ರಾನ್ಸಿಷನ್ ಸ್ಟೇಜಲ್ಲಿ ಇದ್ದೀವಿ. ಮೇ ಬಿ ಕಾನ್ಫಿಡೆನ್ಷಿಯಲ್ ಕಮ್ಯುನಿಕೇಷನ್ ವಿತ್ ಲೀಗಲ್ ಅಡ್ವೈಸರ್ಸ್ ಅದನ್ನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಬಾರ್ದು ಅಂತ, ಪ್ರೊಫೆಷನಲ್ ಕಮ್ಯುನಿಕೇಷನನ್ನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಬಾರ್ದು ಅಂತಲೂ ಇದೆ. ಡಾಕ್ಟರ್ಸ್ ಆಗಿರಲಿ ಅಥವಾ ಲಾಯರ್ಸ್ ಆಸ್ ಸಚ್, ವಿ ಆರ್ ಬೌಂಡ್ ಬೈ ಸರ್ಟನ್ ಎಥಿಕ್ಸ್ ಆರ್ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಆರ್ ಲಾ ಆಸ್ ಸಚ್. ಮೇ ಬಿ question intended to insult, annoy, maybe confession caused by inducement, threat or promise when irrelevant in criminal proceedings. Confession ಒಂಥರ ಈ ಪ್ಲೀ ಬಾರ್ಗೇನಿಂಗ್ ಅಥವಾ ಮತ್ತೊಂದು ಸಿಚುವೇಶನ್, ಈಸ್ ಆಲ್ಸೋ ಒನ್ ಆಫ್ ದಿ ಪಾರ್ಟಿ ಟು ಅಪ್ರೂವರ್ ಅಂತ ಆದರೆ ಒಂದು ರೀತಿಯಲ್ಲಿ ಕನ್ಫೆಷನ್ನೇ ಅಲ್ಲಿ, leading to the discovery or very easy for investigation. ಸೊ ಅದನ್ನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಬಾರ್ದು ಆಫೀಸರ್ ಇನ್ ಚಾರ್ಜ್ ಅಂತೇಳಿ ಇದೆ. ಸೊ ಈ ಥರದ್ದೆಲ್ಲ ನಮಗೆ ಲೀಗಲ್ ಪ್ರಾವಿಷನ್ಸು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದೆ. ಫೋನ್ ಟ್ಯಾಪಿಂಗ್ ಅಥವಾ ವೈರ್ ಟ್ಯಾಪಿಂಗ್ ಟೆಕ್ನಾಲಜಿ ಜೊತೆಗೇ ಸೆಕ್ಯೂರಿಟಿ ಆಫ್ ದ ಸ್ಟೇಟ್ ಬಗ್ಗೆನೂ ತುಂಬ ಪ್ರಶ್ನೆಗಳಿದೆ. ಇದು ಮಾಡ್ತಾ ಇರೋದು ಫಾರ್ ದ ಸೆಕ್ಯೂರಿಟಿ ಆಫ್ ದ ಸ್ಟೇಟ್ ಅಂತ. ಆ ಕಾಂಟೆಕ್ಸ್ಟಲ್ಲಿ ನೋಡಿ, ಯಾವಾಗ ಲಾನ ಎನ್ಯಾಕ್ಟ್ ಮಾಡೋಕ್ಕೆ ಹೋದಾಗ ಗೌರ್ಮೆಂಟಲ್ ಅಥವಾ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಲಾಬಿ ಹೇಗಿರುತ್ತೆ ಅಂದರೆ, ದೇ ವಾಂಟ್ ಟು ಹ್ಯಾವ್ ಸಮ್ ಮೋರ್ ಪ್ರೊಟೆಕ್ಷನ್. ದೇ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಟೋಟಲಿ ಗಿವ್ಸ್ ಅ ಸ್ಟೆಪ್ ಆಫ್ ಫ್ರೀ ಝೋನ್ ಫಾರ್ ದಿ ಕಾಮನ್ ಮ್ಯಾನ್ ಆರ್ ದ ಇಂಡಿವಿಜುವಲ್. ಇನ್ಫ್ಯಾಕ್ಟ್ ಪ್ರೊಫೆಸರ್ C.S. Patil was the person involved in drafting of human rights rules for Karnataka state. He has drafted such 48 sections there. And district session courts have been designated as human rights courts. Many district judges not aware of these rules. Right to be forgotten. That is what. Maybe that 48 sections was trickled down to some 15 or 16 sections. Only police officers are considered to be violators of human rights now. Earlier he has covered many, but executive is not ready to come under the rubric or cobwebs of the law. That's why I mentioned bureaucracy always would like to be in secrecy. They want to carry out everything, not making known to the common man. So more transparency is required, participation of the people in the policy making is required, and for the wrongful exercise of the power or abuse of the power in disclosing the information of a common man, they must be made accountable. TAP is the norm nowadays: transparency, accountability and participation. So that we have to consider. Regarding this marital privacy, in fact, and the health, especially mental health as such, Justice Ramohan Reddy has come out with X versus Z like that, privacy, that very donation of the blood offered by a person who brought that patient was found to be HIV positive, and information was leaked by the Apollo Hospital to the father of that girl, and finally betrothal ceremony was overcome by cancelling that very marriage, and he moved the court for leaking his information, whether the right to privacy to be maintained at the cost of the right to life of that girl who is supposed to marry that man. This is conflict between this health and the health information and the privacy of the person. So like that, even the DNA technology is there, either to find the paternity for giving maintenance to the wife who is in distress. See, there was an objection that going for DNA test will reveal information and it violates my privacy right like that, but court said in some eminent circumstances there can be conducting of such tests as such. So these are some of the aspects that we must take note while considering this very privacy, and you might be aware of this very 377 partially read down in this very Navtej Singh versus Union of India in 2018, and some of the paragraphs that has been mentioned in Puttaswamy case has been taken into account for reading down that very section 377, because the remaining part may tackle a situation where this very carnal sex or unnatural sex may be considered as a business because there is a privacy. That's why to punish them, this remaining part of 377 continues to be constitutionally valid. This right to privacy may be possible to be misused to legalize prostitution. This is possible circumstances. So this is not it so far in the Indian context. So privacy consequences may lead to this. That's why 377 remaining part continues to be valid constitutionally, but this very prostitution may creep into this very business, and it may be legalized in the coming days. Nobody knows. So this very right to be forgotten as such. This is one more right we require. Now once the purpose is over, why unnecessary the information is to be, continues to be there? See, for example, after my death, after my demise, what is the fun in continuing the information or the data given by me? ನಾವು ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತೀವಿ ಎಲೆ ಮರೆಕಾಯಿ ರೀತಿಯಲ್ಲಿ ಇದ್ದು ಹೋಗೋಣ ಅಂತ, unnoticed. So ಆ ಸೆನ್ಸಲ್ಲಿ after my demise also or the person's demise also, if the data is continued to be there, see, when the dead body itself is not a property, we have to consider the jurisprudential aspect of the person. Here but data continues to be there in the such type of data maintaining corporate bodies. Now I should be forgotten. So I must have that right to be forgotten as such, and these aspects we must give due importance, and maybe some mandatory consent is required for divulgence of any personal information. ನಾನು ಅದೇ ಸರ್ ಹೇಳಿದ್ರು, ಏನು ರಾಮಮೋಹನ್ ರೆಡ್ಡಿ ಅವರು ಅಗ್ರಿ ಅಕ್ಸೆಪ್ಟ್ ಅಂತ ಮಾಡಬೇಕಾದ್ರೆ ದಯಮಾಡಿ ಒಂದು ಸರಿ ಅಲ್ಲಿ ಓದಬೇಕು. ನೋಡಿ, ಒಂದು ಉದಾಹರಣೆಗೆ ಒಂದು ಎಕ್ಸಾಂಪಲ್, ಈ BSNL ಅವ್ರದ್ದು ಫೋನ್ ಒಂದು 25 ವರ್ಷದ ಕೆಳಗೆ 3 ನಿಮಿಷ ಮಾತಾಡಿದರೆ 24 ರೂಪಾಯಿ ಚಾರ್ಜ್ ಮಾಡೋರು. ಬೆಳಿಗ್ಗೆ ಟ್ರಂಕ್ ಕಾಲ್ ಬುಕ್ ಮಾಡಿದರೆ ಒಂದು ವಿಕೆಟ್ ಉರುಳೋಗಿದೆ ಅಂತ ಹೇಳಬೇಕು, ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆ ಕನೆಕ್ಷನ್ ಕೊಡೋರು. ಕಾಂಪಿಟೇಷನ್ ಬಂದ ಮೇಲೆ ಈಗ ಎಲ್ಲರ ಹತ್ರನೂ ಟೆಲಿಫೋನ್ ಎಕ್ಸ್ಚೇಂಜ್ ಥರ ಆಗಿಬಿಟ್ಟಿದೆ. ಈಗ ಇನ್ಕಮಿಂಗ್ ಕಾಲ್ ಅಂದರೆ ಅದಕ್ಕೂ ಚಾರ್ಜ್ ಆಗ್ತಾ ಇತ್ತು. ನಾನಿಲ್ಲಿ ಹೇಳಕ್ಕೆ ಹೊರಟಿರೋದು ಪೋಸ್ಟಲ್ ಲೈಫ್ ಇನ್ಶೂರೆನ್ಸ್ ಅಂತ ಒಂದಿದೆ. ಈ ಲೈಫ್ ಇನ್ಶೂರೆನ್ಸ್ ಅವ್ರು ಹೇಗೆ ಮಾಡ್ತಾರೆ, ಅಲ್ಲಿ ಯಾರು ಏಜೆಂಟ್ಸ್ ಇರಲ್ಲ, ಸುಮ್ಮನೆ ಅಲ್ಲಿ ಇನ್ಫಾರ್ಮೇಷನ್ ಎಂಟ್ರ್ ಆದರೆ ಅಲ್ಲೊಂದು ಕ್ಲಾಸ್ ಬರ್ಕೊಂಡಿದ್ದಾರೆ ಗೌರ್ಮೆಂಟ್ ಆಫ್ ಇಂಡಿಯಾದವರು. ನೀವು ಯಾರಾದರೂ ಒಂದು ರಿಟ್ ಫೈಲ್ ಮಾಡೋದಾದರೆ ಅಲ್ಲಿ ಒಂದು ಕ್ಲಾಸ್ ಏನು ಬರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂದರೆ, 5 ವರ್ಷದೊಳಗೆ ನೀವು ಈ ಪಾಲಿಸಿಯನ್ನು ಎಂಡೋಮೆಂಟ್ ಲೈಫ್ ಎಂಡೋಮೆಂಟ್ ಪಾಲಿಸಿಯಾಗಿ ಕನ್ವರ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ದೇ ಇದ್ದರೆ ಇದು ಲೈಫ್ ಪಾಲಿಸಿಯಾಗಿ ಮುಂದುವರಿಯತ್ತೆ. ಸೈನ್ ಆಗಬೇಕಾದ್ರೆ ನಾವು ಯಾರೂ ನೋಡಲ್ಲ. ಪಾಲಿಸಿ ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ನನ್ನ ಟೈಮಲ್ಲಿ ಒಂದು 20 ವರ್ಷಕ್ಕೆ ಎಂಡ್ ಆಗತ್ತಾ, ಹಾಗಾದರೆ ಅವಾಗ ದುಡ್ಡು ಬಂದರೆ ತಗೊಳ್ಳೋಣ ಅಂತ ನೀವು ಹೋದರೆ, ಸರ್ ನೋಡಿ ಟರ್ಮ್ಸ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟಲ್ಲಿ ನೀವು ಸೈನ್ ಹಾಕಿದ್ದೀರಾ, 5 ವರ್ಷದ ಒಳಗಡೆನೆ ನೀವು ಎಂಡೋಮೆಂಟ್ ಪಾಲಿಸಿಯಾಗಿ ಅದನ್ನು ಕನ್ವರ್ಟ್ ಮಾಡಿದರೆ ನಿಮ್ಮ ಮೆಚುರಿಟಿ ಟೈಮ್ ಆದ ತಕ್ಷಣ ದುಡ್ಡು ಕೊಡ್ತಾ ಇದ್ವಿ ಅಂತ. ಈಗ ನೀವು ಯಾವಾಗ ಎಂಡೋಮೆಂಟ್ ಪಾಲಿಸಿಯಾಗಿ ಕನ್ವರ್ಟ್ ಮಾಡಲಿಲ್ಲ, ಇದು ಲೈಫ್ ಪಾಲಿಸಿ ಆಗಿದೆ ಸರ್, ಇನ್ನು ನೀವು ದುಡ್ಡು ತಗೋಬೇಕು ಅಂದರೆ 40 ವರ್ಷ ಆದಮೇಲೆ ತಗೋಬೇಕು ಅಂತ. ಅದು ಮುಂಚೆ ಏನಾಗಿತ್ತು, ಆಫ್ಟರ್ ದಿ ಡಿಮೈಸ್ ಆಫ್ ದ ಪಾಲಿಸಿ ಹೋಲ್ಡರ್ ಅವರ ಡಿಪೆಂಡೆಂಟ್ಸಿಗೆ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸಿಗೆ ಕೊಡ್ತಾ ಇದ್ರು. ತುಂಬ ಪ್ರೆಸರ್ ಮಾಡಿದ ಮೇಲೆ ಅದನ್ನು 85 ಇಯರ್ಸಿಗೆ ಇಳಿಸಿದ್ದಾರೆ. ಅಂದರೆ ಗೌರ್ಮೆಂಟ್ ಇಸ್ ದ ಬಿಗ್ಗೆಸ್ಟ್ ಎಕ್ಸ್ಪ್ಲಾಯ್ಟರ್. ಗೌರ್ಮೆಂಟ್ ವುಡ್ ಲೈಕ್ ಟು ಬಿ ಇನ್ ಸೀಕ್ರೆಸಿ. ಅದೇ ಬ್ಯೂರೋಕ್ರಸಿ ಇನ್ ಸೀಕ್ರೆಸಿ ಅನ್ನಲ್ಲ, ನಮ್ಮ ಟೈಪ್ ಆಫ್ ಏನು ಸಿವಿಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಇದೆ ಅವರಿಗೆ ಫೇರ್ ಮೆಂಡಾಗಿ ಬರೀ ಎಫಿಷಿಯನ್ಸಿ ಬಗ್ಗೆ ಮಾತ್ರ ನಾವು ಹೇಳ್ತಾ ಇದ್ದೀವಿ, ಫೇರ್ನೆಸ್ ಅವ್ರ ಹತ್ರ ಇಲ್ಲ. ದಟ್ ಈಸ್ ಸೀಕ್ರೆಸಿ. ನಮ್ಮದೇ ಎಲ್ಲ ಡಾಟಾ, ನಮ್ಮದೇ ಎಲ್ಲ ದುಡ್ಡು, ಆದರೆ ಅವರು ಅದನ್ನು ಡಿಸ್ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ. ಎಲ್ಲಿಗೆ ಬರ್ತೀವಿ ನೋಡಿ ನಾವು. ಸೊ ದಿಸ್ ಈಸ್ ಹೌ our information, our money, our liberty, our life is exploited, and the biggest exploiter is government. Right to privacy ಅನ್ನೋದೇನಾದರೂ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಆದರೆ ನಾವು ಆಗ ಒಂದು ಅಡ್ವಾಂಟೇಜ್ ಏನು ಮಾಡ್ಬೋದು ಅಂದರೆ ಎಗೇನೆಸ್ಟ್ ದ ಸ್ಟೇಟ್ ಮೂವ್ ಆಗೋದಲ್ಲದೆ ಯಾರ್ಯಾರು ನಮ್ಮ ಜನದ ಡಾಟಾನ ಹೊಂದಿದ್ದಾರೆ ಅವರು ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ, ಅವ್ರ ಮೇಲೂ ನಾವು ಈಗ ICI ಕ್ರಿಕೆಟ್ ಬೋರ್ಡ್ ಆಫ್ ಇಂಡಿಯಾ BCCI is not a state, but still the court has issued the direction constituting a committee to look into the malpractices or corrupt practices. ಅದೇ ಥರ ಈಗ ನಾಳೆ ನಿಮ್ಗೆ ನೆನಪಿರಬೇಕು, ಈ ಮೆಟಾ ಆಗಲಿ ಅಥವಾ ಅದಾನಿ ಗ್ರೂಪ್ ಆಗಲಿ ಅಥವಾ ರಿಲಯನ್ಸ್ ಅವರಾಗಲಿ ಯಾರಾದರೂ ಈ ಡಾಟಾ ಬಗ್ಗೆ ಕಾರ್ಪೊರೇಟ್ ಸೆಕ್ಟರನ್ನು ಓಪನ್ ಮಾಡಿದರೆ that data belongs to the common man of this land. Any invasion, any violation, any infringement of our data, any selling of data, you are entitled for as a beneficiary. ಆ ಥರ ಆಗಬೇಕು. that may infringe your data. ಹಾಗಾಗಿ you must have the latest knowledge and updating always with respect to, and you have to get equipped with the pace of the technological developments. Then only you can save yourself, maybe in the in the context of life, that is possible by enjoying this liberty that is always coupled with that power, coupled with duty is liberty. So you have that very power if right to privacy is given to you. And this this very data protection bill is in the pipeline. Try to just contribute in what way the bill can be made good for the protection of the information related to person, as we are having sufficient legal provisions to tackle the privacy, physical privacy or mental privacy of the common man. I think this would be sufficient, as Professor C.S. Patil will be dealing with the accountability, I think, for the disclosure of information and what steps can be taken in that regard. Thank you for your listening.
Thank you, sir, for your words of wisdom. I humbly seek the permission of the dignitaries to start the technical session too. Sir. Yes, sir. Thank you, sir. I'm extremely delighted to pronounce that in session 2, we have with us a doyen of knowledge, Professor Dr. C.S. Patil, Professor of Law, Head, Research Center, Research in Democracy and Constitutional Government, KSLU Hubballi. Sir will be addressing us on the topic Accountability Regime of Violation of Privacy. I request Ms. Vashika, student of 5th semester BBA LLB, to introduce our resource person to the gathering.
Good afternoon to one and all. It gives me immense pleasure to introduce to you all our resource person for the day, Professor Dr. Chidananda Reddy S. Patil. I indeed consider it my privilege to introduce Sir on this special occasion. Professor Dr. Chidananda Reddy S. Patil, who is popularly known to us as Professor C.S. Patil, graduated from the University of Mysore in the year 1983. Following which, Sir completed his legal studies at the University College of Law, Karnataka University in 1986. Sir then obtained a master's degree in law from the University of Mysore in the year 1988, where he specialized in constitutional law. During his LLM, Sir secured the first class and first rank, for which he was awarded 2 gold medals by the University of Mysore and Sir was also awarded by the Government of Karnataka for his achievement. Sir holds a doctorate in law from the Karnataka University, Dharwad. Professor C.S. Patil has taught law in various colleges, including the JSS Law College, Mysore, HA Law College, Dharwad, KLE Society's Law College, Bangalore, and the University College of Law in Dharwad. Sir has discharged responsibilities as the Dean and member of the Syndicate and Academic Council of Karnataka State Law University. Sir was also the director of KSLU's Law School for a period of 7 years. Sir is one of the experts to submit a research paper to the Committee on Reforms of Criminal Justice System, of which Honorable Dr. Justice V.S. Malimat was the chairman. Sir was also a member of the expert committee for the establishment of Karnataka Rural Development and Panchayat Raj University. Sir has drafted many legislations for the government of Karnataka, including the Karnataka State Human Rights Courts Rules of 2006. Sir also received a commendation for his work in the field of human rights in the year 2010. Professor C.S. Patil's expertise in arbitration law is yet another feather in his cap. Sir has, in his credit, authored 1 book, edited 2, and has had more than 85 of his articles published in various law journals. Presently, Sir is a professor at the Karnataka State Law University in Hubballi, where he is also discharging responsibilities as the head of the Research Center for Democracy and Constitutional Government. Sir has got such an illustrious profile that mere words would not do justice to his innumerable achievements. We are very much elated by your presence, sir. Thank you for being here today.
Thank you, Varshika. I request Professor Patil to take over the session. Thank you, sir.
Good afternoon. If you want to be a ranker, gold medalist, you should have a friend like Jagdish, who will be in your class, who will bother about the well-being of the first ranker, concerned about his health, concerned about his comforts, and wake up early in the morning. You fellow, you are a first ranker, come and start study. Okay. And all my classmates put together, they said, you take first rank. We are not in race with you. That was a very difficult situation. Okay. Nobody is competing and you are going for first rank. So nice it is to be a first ranker with friends like this, Professor Jagdish, and my dear friend Anjana Reddy, and the colleague in Kilfar right from 2005. Revaya Vadiyar is associated with Kilfar right from day 1. And when he speaks, he will say that I was associated with it right from day 1. We together, with the help of the then Law Minister Sri H.K. Patil and then the Law Secretary, Parliamentary Secretary, all these things have come into existence, and it is so nice to be part of this program always. George Bernard Shaw has said, what is the character? Character is what you are when you are not observed by anyone. C.S. Patil standing here, this is artificial. You don't know who is this character. What is this character? When I am totally isolated, I am not observed by anybody, all of us, our true color is exhibited when we are not observed by anyone. Go and sit in the family court sometimes. You will learn lot of technology. And you will have lot of entertainment also. Lot of tragedy also, depends upon the way you perceive things. Couple tracking. What is this couple tracking? Take her mobile, download some software, hide it, put a password, give it back to her. All calls that come to her will come to me. All messages she receives will be delivered to me also. All mails she gets, I will get. Whatever that happens on that cell phone will be notified to me. This is a software. Surrounding recordings for children who go to schools. Download that software, keep it in bag and send that way. Night vision cameras. Husbands and wives. There was an act, Husbands and Wives Act in England. There was a wonderful provision there. If a wife commits theft in the presence of husband, husband will be responsible. Okay, the implication is she is doing it under his direction. Now it is a turntable situation. Whenever husband is going out, he puts a 360-degree camera. See, so there is a 360-degree camera in the house, concealed somewhere, and it has night vision also, and it will run whenever there is some movement. It is not always recording. When you open the door, it will start recording. And it is so smart, memory card will not be exhausted, it will keep on uploading everything to the cloud. These things have come into our life, whether we like or not. I get perplexed. I always wonder at things. We are speaking of privacy, and the parliament is grappling with the data protection. Right? What are you doing? Are we talking about privacy or are we talking about data protection? One draft, second draft, select committee, and improved version of that. What is that we are doing? Are we straight on the point of privacy, or are we going through a circuitous route in order to ensure privacy? Privacy of what? Some data. And this data is also very important, very significant. This person is a concentric circle of information. This person, each person is a concentric circle of information. All of us are bundle of informations. Okay? Bhavana is not my friend. Arpita is not my friend. Why? Then what we are? We are known to each other. Jagdish is my fast friend. Anjana Reddy is my friend. It all depends upon to what extent these circles have overlapped, circles of information. So when we come in touch with each other, the outer circle touches. As we share information, circle starts overlapping. And depending upon how much information you share, always when we look at lovers, we always wonder what these people talk 4 hours, 3 hours, always, and what is that? Unless you exchange so much of data, love will not happen. Okay? Affection is information, love is information, respect is information, friendship is, I am quoting from the definition of Charles Fried, wrote long back. All human relations are information. You want to develop some relation? Start informing. Share information, relation will develop. You want to avoid some relation from some relation coming into existence, don't share information, relation will not happen. See, this is the beauty. All creativity because of privacy. All relation because of information, and we have, whether we like it or not, we have come here through all those definitions, right from Thomas Cooley through Warren and Brandis, who later became Justice Brandis. Read that book. 3 of us have read that book, Privacy 3.0 by Rahul Mathan, and maybe some of you have read that book. Otherwise, read it. Highly readable book, wonderfully written. And because he is from Bangalore, we have to read that. Our own Bangalorean has written a book, we have to. Okay. There are various dimensions which the earlier speakers have already mentioned. 4 factors to be considered are: how was the information acquired? Whether it was acquired properly or innocently or wrongful means. This is very important. How that fellow gathers that information. Whether it is properly acquired, innocently acquired, or through wrongful means. Second, was there any consent to disclose? Or whether any consent can be implied. Okay. Whether the exposure was innocent or disreputable, wantedly whether it was disclosed or it happened like that, fizzled out. Was there any damage caused, or was there any annoyance which is just annoyance? C.S. Patil is a professor of law in Karnataka State Law University. Bombard, I carry a vote because it causes no annoyance to me. And somebody may be so sensitive that he feels embarrassed whenever somebody calls him a professor. How dare you call me a professor? You are a professor, you are. These factors are to be taken into consideration. There is intersection between right to information, privacy, defamation, public life, private life, all these things. Technology is the darkest enemy of privacy. Technology is very, very dangerous to privacy. And all of us are victims of that. Crazy it is. I have gone to a shopping mall. Some lady has come to that shopping mall. Somewhere it is recorded, C.S. Patil is Miss so and so in this Mantri Mahal. Crazy things. One of my friends, he has a Facebook account. Lady said, I also will go on to Facebook, went. And she wrote, married to Mr. X. So that gets linked to Mr. X. Mr. X is 55 years. Then people started congratulating him. Because he got married, no? Congratulations, congratulations. In that string, somebody said, very sorry, sir. Then somebody else would, no, don't say like that, it may happen to anyone. Each fellow started sending their messages because this lady got tagged. Then this lady went to husband, so what is happening? So, it is your creation. You declared that we are married. Maybe my first wife has died. I got married second time. Some people think like that. Some people say it is a delayed marriage. Crazy. Technology is very, very dangerous. Camera was very dangerous those days. That is written in that book. When camera came, people got scared. And now we have all these gadgets, very dangerous. So starting from early data processing exercise that was taken, see, it is very simple. Earlier, minus technology, data was in different silos. So in this box, Jagdish is in this box, C.S. Patil in this box, Anjana Reddy in this box. In that there are small boxes, family life in one box, professional life in one. So it was in different compartments. In files, physical files. Now it has become digital. When you layer data, it gives a different picture which earlier nobody would have conceived of. This is the problem. Combination of data creates lot of problem. And how we have to deal with this. And this is going to be coupled with, somebody was speaking about big data. And to add to that, another thing came into existence, that is artificial intelligence. If you have seen that movie of Rajinikanth, Chitti goes pagal. ಅಲ್ಲಿ ಒಬ್ಬ ಚಿಟ್ಟಿ ಇರ್ತದೆ, artificial intelligence, it becomes crazy. See, that is algorithm. Chitti is algorithm. Human behaviors, we have experience of regulating human behavior of centuries. We know how to handle a human being. But when it comes to the point of algorithm, we do not have experience. And we do not have time also, because these algorithms have started acting. When he gets that mail, what he has done in 1 month, where all he traveled, that is algorithm. After 1 year, I get a story on my Facebook saying that C.S. Patil did this, some song is there and photographs are there, it comes. And that fellow says, we have created a story of you because you are our valued customer. No, he is playing with me. You do anything, the way you swipe your mobile, you are leaving your footprint. And the way you handle your gadgets, you can be traced and you can be tracked. There are distinct advantages and disadvantages. In Bangalore, in the field of law, there is what is known as a smart draft. Okay, in the ADRs, we have a lot of softwares that have come into existence for the past more than 15 years. ROS, R-O-S-S, ROS is the artificial lawyer practicing in America. You have artificial doctors also, and their success is very fascinating. I tell you, if you do not want to be replaced by artificial intelligence, there is only one way out. Don't specialize. Be a generalist. A generalist cannot be replaced by artificial intelligence. If you focus and go for micro specialization, maybe you will be taken over by that machine that will be performing better than you. Byron Reed's Fourth Age, a fascinating book you can read if you want, about artificial intelligence. Okay, this is the thing, we do not have technology to regulate this. And see, why Aadhaar was brought here? Targeted delivery. The benefits of the governance should reach the deserving people. There is advantage with the technology. But privacy is to be compromised. We cannot take a chance of not being benefited by technological revolution that is taking place. We cannot be out of tune with the technology. And if you are not putting your robust system in place, laws in place, nobody will come to your country to invest. Okay? And India has a very clean route in this area. There is no jurisprudence because we were governed by Britishers, and all this privacy thing started, and we do not have any track to follow. We can chart our track afresh. This advantage is there as far as India is concerned. Consent. Okay? All the drafts are speaking about consent. Informed consent. Consent for this, consent for use, consent for the right to be forgotten, all that is there. And the Honorable Judge mentioned about the consent. Professor Jagdish mentioned about the consent. There is one word used in Justice Sri Krishna Committee report. Consent fatigue. Okay, what is this consent fatigue? I am tired of that. It will not move further unless I agree. Okay, and in the draft as finalized now, there is a clause. If I do not agree, then also I should be in a position to proceed. That clause they have introduced. See, there are 3 people here. data principal, data processor, and data fiduciary. Obligations are cast upon all these things. Data fiduciary is directed to bring it to the notice of Data Protection Authority all cases of violation of protection of data. What is this? It expects me to file a complaint against myself, because I will come to know where I have violated. I am supposed to report it to the Data Protection Authority, and then authority will investigate it and they will impose penalty on that. And there should be consent managers. One simple class. It should be as easy to retract consent as it is easy to give consent. I agree. So if I do not want, I should be in a position to disagree so expeditiously as I have done earlier. And there is a consent manager. What we have agreed, I tell you, when you read this, all these industries which are in field, they have the best of the brains in their portal. Lawyers are there. They have drafted these consent forms. And the veritable ways in which the data can be used, we cannot understand. That's how the consent forms are. So consent-based model, we doubt whether consent-based model can provide adequate security for privacy. In this situation, I am of the strong conviction that we should go for accountability model. Okay? You are holding data, whether you call yourself a data processor or data, fiduciary. I have trusted you, I have entrusted my data with you. And you should be responsible for anything that goes wrong with that data. Otherwise, forget me. Right to be forgotten. To give you a very mundane example, when I have ordered something online, I have given my mobile number and my address because that parcel is to be delivered. Once delivered, it should be deleted. I should be forgotten. That company should forget me. They should not follow me about whatever I am doing, sending. I tell you, this is a crazy world in which we are there. Or at least there should be a combination of accountability model, consent model, and what National Law School has evolved as a rights-based model. Different things are happening, and you are all youngsters and you should be very actively participating in this, because for us it is very difficult. First we have to understand the language. We are not familiar with this language. We started with a floppy in pocket, which you have not seen floppy. Anyone has seen this floppy? Okay, good. You have some expertise in archaeology. Okay, so we started. Maximum you could put a photograph in that. One photograph, black and white, floppy is full. Then this CD came. We got fascinated, CD. And when the CD is spoiled, we will put a hole on that and dangle it in the car. Okay, that was a sort of ornament also. Then we got the DVD. Then you will not believe, I made it a program to buy a pen drive when I come to Bangalore. When I came to Bangalore, my first pen drive of 1 GB I bought paying 1,000 rupees. 1 GB data, it was such a huge thing. When I bought my first laptop, the person who gave me that laptop, that vendor said, "Sir, this is 80 GB. What you will do with 80 GB? Now I felt 80 GB is a world. It should be a lot of space for me. Then started GB. After that, TB came. Then, what is that? petabyte, zettabyte, hexabyte, dogbyte. We went mad. And I stay in Dharwad, I run into a lot of problems. What is the size of a petabyte? What is the size of a zettabyte? Who knows? Then I got hold of some engineer friend, he said, 1 zettabyte is half of the size of your mobile. What it can contain? He says, all the communication that has taken place on this earth, all photographs, all videographs, everything of 1 year you can put in 1 zettabyte, something like that. So what is the information is shrinking, and whole transaction that now crazy thing, government is very seriously thinking whether they will ban all the mobile in educational institutions, because everybody records anything and it becomes viral. Meetings are recorded, programs are recorded, anything to anything. So somewhere we are running into terrible problem with this data and also this aspect of privacy. How we will go about penalty, whether it is an answer, we do not know. Somebody has come into your house, as it happens in movie, he has put a camera and gone. Whom to trust? If somebody plants a camera in my chamber, I will not come to know. Anybody can put anything anywhere and go. Earlier, ಟೇಪ್ ರೆಕಾರ್ಡಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಬಟನ್ ಹಾಕಿದರೆ ಶಬ್ದ ಆಗ್ತಿತ್ತು, ಯಾರಿಗಾದ್ರೂ ಗೊತ್ತಾಗ್ತಿತ್ತು. ಇದನ್ನ ಏನು ಮಾಡೋದು, ಅದಕ್ಕೆ ಮತ್ತೆ ಗೂಗಲ್ ಮಾಡೋದು. ಈಸ್ ದೇರ್ ಎ ನೈಟ್ ವಿಷನ್ ಕ್ಯಾಮರಾ ಇನ್ ಮೈ ಬೆಡ್ರೂಮ್, ಹೌ ಟು ಡಿಟೆಕ್ಟ್ ಇಟ್, ದೆನ್ 1 2 3 4 Cora, what is that? Question answers. That fellow says, switch off all the lights, switch on your camera and go round. If you see any ultra red light, there is a camera. Crazy, no? If that suspicious character comes into my house and goes, I should switch off lights and search for camera. Am I a law professor or am I a detective? With great difficulty we try to catch up, try to understand what is the law. And when the law is being framed, I tell you, the problem here is we cannot forego the advantage of this digital revolution. We cannot forego this, and we cannot sacrifice our privacy because of that. There are extreme advantages with the data, but there are some risks also. How to balance this is a challenge, as you are all eagerly looking for. 555 pages select committee report. Who on earth has to read this? Should they not write a small report of 10 pages? Everything is becoming data. So you are all young, familiar with the technology, follow it up. As Professor Jagdish said, make your contribution in the law making. That way the trouble taken by Kilpar and Reddy should be of great help. It's very simple. We get confused. Sharing some personal information, taking the chance of violating privacy of Jagdish. Jagdish wanted to leave his mobile and come to Bangalore, and he forgot his purse and came to Bangalore with the mobile. So if Jagdish has forgotten his purse at home, he has no tension because he has mobile in his pocket. Okay? So he has all his money, he has all his address, he has all his information, everything is there. So advantageous the technology is. But you cannot complain that you are recorded also, because you do not have your purse. This is the paradox we have when it comes to the point of information. Thank you very much.
Thank you, sir. Words are never enough to express our gratitude to the knowledge givers. I am privileged to express my gratitude to our resource person, Professor Dr. G.R. Jagadish, Principal, National College of Law, Shivamogga, for enlightening us on constitutional dimension of right to privacy. Sir, on behalf of Kilpar and RVILS, I extend my heartfelt gratitude to you. I request Shri K. Dwarakanath sir, Shri Revaya sir, and our beloved principal Anjana Reddy sir to felicitate our resource person. Thank you, sir. I am honored to express my gratitude to our distinguished resource person, Professor Dr. C.S. Patil, Professor of Law, Head Research Center, Research in Democracy and Constitutional Government, KSLU Hubballi, for sharing his words of wisdom on accountability regime on violation of privacy. Thank you, sir. Yes, sir. Thank you, sir. I take this opportunity to thank Shri K. Dwarakanath Babu, Director, Kilpar, for gracing the technical session, and a heartiest thank to Dr. Revaya Odeyar, Research Head, Kilpar, for gracing the technical session. I thank our beloved principal, Professor Dr. Anjana Reddy KR, for being the pillar of support. Last but not the least, I thank the faculty members and participants from various institutes, teaching and non-teaching staff, and the students of RVILS for their presence and participation in the technical session. Thank you.
Good afternoon, ladies and gentlemen. Welcome back. Myself, Maitra, Assistant Professor at RV Institute of Legal Studies. We have gathered here for the paper presentations on the topic Right to Privacy, Its Dimensions and Limits. We have Dr. N. Satish Gowda, Associate Professor of Law at Bangalore University, as the chairperson for this session. I welcome you, sir. And we also have Revaya Odeyar, sir, Research Head, Kilpar. I welcome you, sir. And we have Dr. Anjana Reddy KR, Principal, RV Institute of Legal Studies. I welcome you, sir. I now request Ms. Atmaja, student of third year BBA LLB, to introduce our chairperson.
Good afternoon to one and all. It indeed is a great honor to introduce to you all Dr. Satish Gowda and Sir. Sir currently is the Associate Professor in the Department of Studies in Law and University Law College, Bangalore University. He has put in 15 years of teaching experience at both UG and PG levels and has an LLM with first class in constitutional law and business and trade law, and also has obtained his PhD in the area of constitutional law in the year 2012. Sir has secured third rank with distinction in LLB and fifth rank in BAL and holds MPhil in judicial science with distinction. He has also done MA, PG DHRM and PG DMCJ with first class. Sir has published more than 50 articles in different law journals and a few articles in leading newspapers, and has also successfully guided 5 PhD research scholars. Sir has visited and delivered lectures in School of Law, Xiamen University, China, United Nations Organization, New York, the USA, Georgetown University Law Center, Washington, D.C., Harvard Law School in Cambridge, Massachusetts, USA, International Court of Justice, Hague, Netherlands, Maastricht Center for Human Rights, Maastricht University, Netherlands, Technische Universiteit Hamburg, Germany, Chair for Public International Law, European Law, University of Cologne, Germany, University of Sri Jayawardena held at Villa on View, Vadua, Sri Lanka, Regent International College, Bangkok, Thailand, DU, Dhaka, Bangladesh Conference in Association, Ankara University, Turkey, held at New Gombo, Sri Lanka. Sir has received the Young Scientist Social Science Award for the Best Paper Presentation at the first International Congress Conference held at Regent International College, Bangkok, Thailand. He is presented in the national and international level conferences and has also been the coordinator for a refresher course, international and national seminars and workshops, and also for the national moot court competitions. Sir is a member of the Faculty of Law, Board of Studies and Board of Examinations in many universities across the country and served as chairman, BOE and custodian of law examination. He has served as NSS coordinator, nodal officer for youth, Red Cross and COVID-19 cell of Bangalore University. Sir, it's a great privilege to have you here, sir. You're welcome. Thank you.
Thank you, Atmaja. To update you all with the rules of the presentation, the warning bell will be given at the 4th minute and the final bell will be given at the 5th minute. So the presenters will have 5 minutes to present their paper. So with your permission, we now begin with the presentations. I now call upon KM Anita to come over.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. Good afternoon, everyone. Good afternoon, everyone. Dignitaries in dais and faculties and my dear good friends. I'm Anita. I'm from Patel Law College, Bangalore. I'm studying 3 years LLB first semester, and I'm here to present the paper titled The Paradox of Our Rights to Information and Privacy. India has witnessed similar consecutions between the right of information and the right to privacy. Ironing has been identified between these two rights. That is, both the rights are important from human rights prosecuted in the present society. Has both rights existed in the regimen of the government as well as within the individuals. These are of such a nature that they overlap each other and thereby creating a conflict. The conflict in the sense that whenever there is demand for access to the right of information, the privacy right gets affected, as the information which an individual is getting access to be indirectly entering the premises of another individual's privacy. The state needs to involve a proper platform for detecting the key issues so that there is a minimization of the dispute and thereby maintaining stability between the two rights. The two rights might aim to is assigning a fundamental right. The right to information is for the individuals to get access to the information which is withheld by the government, and the right to information is provided to the individuals has fundamental rights to control their information access, use and their collections which has been kept hidden by the government bodies or private bodies. Both rights are consideration as the two hands of the same persons, and thereby hiding the individual rights to hide the answerability to the government. Now it has become the most talked subject of discussion in the present world, and the debate goes on not only in India but also around various other countries where they have made similar legislations. The challenge is to protect privacy as similar new technologies have emerged. These new technologies have instated sharing their personal information in various peoples. The personal information includes biometric as well as DNA. This data is collected and is used routinely. Some of the public records and revealed all over the internet platform. This has increased the difficulty level of protecting the privacy of the individuals. The right to information has also received equal recognition. The RTI laws are nowadays becoming common, as almost 90 countries have adopted the related religions. Access to this information has been open for public use, and any individuals can get access through various websites, technologies. Thereby, neither of the rights can override each other, as it will be affected and reduce individuals' human rights. Therefore, there is a need for specific laws to control the importance of both the rights and maintaining a balance between them. The paper would focus on the various conflicts between the rights of information and the right of privacy, and includes an important aspect of the issues of whether both the rights can go hand in hand in the same platform. Before landing upon the legal issues, we'll discuss in brief both the concepts. So, India have witnessed several trends which have led to the recognition of the right of information by several countries worldwide. Thereby, the right information is recognized as fundamental right under the Universal Declaration of Human Rights. If there is an increase in the access of the information by citizens, the government bodies would be more transparent, and thereby citizens can exercise their rights. Consider the access of information by the citizens of India played an important role. There is no free flow of information that has restricted certain information access. Example, under the Official Secrets Act of 1923, where certain restrictive practices are involved, the culture of secrecy exists, within which restrictions the access of information to the common people, and the low rate of literacy as well as awareness existence among the people of India. Therefore, certain fundamental rights has certain awareness among the people and formed pressure in the group on the other associations. In India, into the concept right of information under the Constitution of India. In India, it's... Thank you everyone, such a giving great opportunity to me. Thank you.
Thank you, Anita. Now we move on to the next presenter. I call upon Dhanya Kesari Rao on the stage.
A very good afternoon to everyone present. I, Dhanya, a third-year law student of Avi Institute of Legal Studies, will be presenting a paper titled Internet of Things, Infringement of Right to Privacy. Communication and connectivity are the foundation of modern society. In this digital era, apart from human communication, we are compelled to connect even with digital devices. This is facilitated by Internet of Things, or IoT. IoT is a digital network connecting physical devices through sensors and software. Who over here does not have a smartphone with them right now? A raise of hands, please. Look around you. This smartphone, this device, is the most large-scale sensor used to obtain information. This is because of the convenience it adds into our lives. But this convenience comes at a cost. The cost is the violation of a basic human and fundamental right, the right to privacy. Every sensor of IoT devices collect and analyze enormous amounts of data from the user. Knowledge is power. This phrase remains relevant irrespective of the era. Therefore, knowledge in the form of data is the most critical asset for any company. Data acquisition. These can happen through health devices and sensors, such as this Fitbit that I am wearing right now, is gaining information about my location, health information, and personal information that I am providing to the app. Automobile sensors, which are inbuilt in devices of any automobile. Home and electricity sensors, such as Alexa, which integrate with other devices of any house. And smartphone sensors. No substantial mechanism to sufficiently safeguard the accumulated data is available with us. Interested persons can examine and collect such data. This leads to breaches. The breaches are of personal information, financial information, health information, technology, security, data related information. Personal information related breaches are done by apps such as DigiLocker. DigiLocker contains details about your PAN card, about your driver's license, as well as your passports. Google Pay, it is a UPI-based app which is available on all our mobile phones. Fitbit is an app which takes all your healthcare information data. To create an environment that is conducive to Internet of Things growth while still guaranteeing users' right to privacy, all the stakeholders, individual users, companies, and the government must cooperate. Company obligations. Security must be considered at the outset by design and not as a consequence of any breach. Choice and control must be provided to consumers when collecting their information. Data minimization must occur, wherein only data which is very relevant at that point of time must be collected. Self-assessment of security threats must be done by companies. Government obligations. In India, privacy laws are scattered over several different legislations, such as the Information Technology Act and Indian Contracts Act. There is a need for a robust framework of laws dealing with infringement of privacy, keeping in mind the obligations of all those involved. Users must be made aware of the shortcomings and be equipped with adequate legal remedies when their rights are breached. Privacy is a principle that empowers us to retain our individuality. Privacy is not only a personal right, but a collective good, a cornerstone of democracy. When we recognize a fundamental right, we must strive to uphold it. Thank you.
Thank you, Dhanya. I now call upon Shivaranjani to take over.
Good afternoon, everybody. So today I'm going to talk on the topic called Right to Privacy as a Fundamental Right in India. And my name is S. Sivaranjani, third year LLB from Panchami College of Law. So first, we should know that every human being has some confidential and superstitious part of their life and which cannot be digested at public domain, and it cannot be told in the public. Because the right to privacy, as we know, as we have been listening, that it consists of several emotions. And right to privacy is a right to be let alone. The right of a person to be free from unwarranted publicity. Everything should not be told outside. So right to privacy is inherent in nature, and we do not act now to safeguard our privacy now. We could all become victims of identity theft. So Article 21 says that no person shall be deprived of his life or personal liberty except according to procedure established by law. Thus it includes all the aspects of the life which makes a man's life more meaningful and complete and worth living. And right to privacy is one such right. So we should understand that right to life, that is Article 21 of Indian Constitution, is a fundamental right, and right to privacy is inherent in right to privacy, right to life and personal liberty. So let us discuss that how this has become a fundamental right from case law, right from the beginning. The first case law is like MP Sharma versus Satish Chandra. So in this, the Dalmir Group's company, which was making malpractices and making fraud balance sheets, so the FIR was lodged in that for search and seizure warrant. And in that, it was all the private documents, all the documents were investigated. So because of that, the Dalmir company challenged for investigating this private document. The court clearly said that there is no concept called right to privacy in Indian Constitution. So this was the first thing which was very narrow way of thinking. And then the Karak Singh case, wherein it was regarding the dacoity, and there was no substantial evidence for that. So what happened was investigation and supervision on all domiciliary visits and all their expenses, everything has been checked over it. And because of this, right to privacy, again, it got lost. Justice Subbarao statement, he said, anybody can enjoy freedom of movement anywhere for personal purpose. If the movement is being tracked, then how free it is. So if we are living in a free country of freedom, independence, and if we feel that someone is tracking and it's been monitored, then how we are free? We are free. We have the freedom, and how we feel that, how we can feel that we are in the independent country. And the UP police regulation was challenged and so on. But it was said that right to privacy is not guaranteed. Similarly, in PUCL, that is People's Unions of Civil Liberties versus Union of India, again the thing was told about that only at unavoidable circumstances this phone tapping and other things can be done. And the next case was about Menaka Gandhi versus Union of India. In that, it was like we all know about this case, and it's again here it's talking about the fundamental right. Individual, if it satisfies the triple test, then only the state can interfere into the fundamental rights of an individual. It is the first one is the legality and the need and proportionality. So the main case, the last case, which is the Justice Puttaswamy versus Union of India, here again the same three-test policy has come. That is, the law should be in existence and there shouldn't be any interference, and it should be for a legitimate purpose, and there should be a proportionality. Only when there is a last resort, then only the state can interfere. That means here the fundamental right of this right to privacy is a fundamental right, but it is not an absolute. Right, it is subjected to restrictions, and such restrictions, say for example, national security. In case of emergency or for a public order disorder, in that case this can be violated and it can be compromised. So everything is not completely free, but it is with an absolute, it is not absolute, but with subjected to restrictions. And as we know about the spyware, Pegasus and our phones everywhere, so the right to privacy has to be is an important concept, but we are just letting it go, but we should not allow it, but it is our choice that whether we should agree it or not. So it left to us, but the technology is also grabbing our privacy, and there should be a proper solution in order to create a better solution to future coming India. Thank you. Thank you everyone for your time. Thank you everyone.
Thank you, Shivaranjani. Now we move on to the next presenter. I call upon Risha Ray to take over.
Good afternoon to one and all. I am Risha PK, 7th semester student. Okay, so my topic is right to privacy in relation with freedom of press. The space between one's right to privacy and freedom of press is very thin. Article 21 of the Constitution gives one the right to liberty, under which they talk about right to privacy, and Article 19, Clause 1, Subclause A of the Constitution gives a person freedom of press, under freedom of speech and expression. Both the rights have their own importance, but many times freedom of press contravenes with the right to privacy, and there are times the press had interfered in investigations and where it resulted in tampering and destroying of evidence. Here, I'll be critically analyzing the relation between freedom of press and right to privacy. So when we talk about right to privacy is something that has emerged through judgments. Like, it's a negative right as it comes into presence when it's violated. It only comes into the presence when it gets breached, and so it is called a negative right. In the Indian law context, the concept of privacy isn't well defined. It is more about protecting someone's private matters, such as family issues and individuality, and every citizen of this country can avail this right except in procedural of law. In case of Govind and state of Madhya Pradesh, in 1975, the Honorable Supreme Court recognized the concept of right to let alone and acknowledged the fact of lack of precise mention of right to privacy in Indian Constitution. Now let's look into freedom of the press. the freedom of press is considered the press is considered the fourth organ of a government, along with the judiciary, executive and legislature. And the current situation is very much different than how it was previous. Before, the freedom of press was expressed through newspapers and articles. But in the current situation, in today's generation, there are more resources like TV, news channels, radio channels, social media, etc. And the change in mode of the press is both an advantage and disadvantage of the freedom of press. It is an advantage as the information can be shared fast without any delay, and anyone and everyone can express their opinion and views in certain issues, which comes under the freedom of speech and expression, which we can say is both an advantage and disadvantage, because sometimes all the opinions won't be really accurate or really related to the whatever issues that's happening. And the press plays a prominent role in the public welfare, but it shall act responsibly. So here, by critically analyzing, I would like to say how the press should act responsibly. And when we talk about the press, in the present scenario, as I said, it's mostly in the mode of media. And amid the over-competitiveness and the run for ratings and views, someone's right to privacy isn't a concern anymore. And it had come to the extent of tearing down someone's identity, and many times it had interrupted many case proceedings and investigation in which high-profile people were included. The same was observed by the Andhra Pradesh High Court in the case of Liberation Front and State of Andhra Pradesh. The court stated, gross misuse of technological advancement and the unhealthy competition in the field of journalism resulted in the obliteration of...
See, this program has organized to inculcate something about the right to privacy in different dimensions. My sincere appeal, please respect to her freedom of speech and expression. If you are in her position, how you would have been reacted? It's my sincere appeal to everyone. Please listen, okay? Yes.
Okay, so as I was saying, the same view was observed by the Andhra Pradesh High Court in the case Liberation Front and State of Andhra Pradesh. The court stated, gross misuse of technological advancement and the unhealthy competition in the field of journalism resulted in the obliteration of norms of communication or communication to the noble profession. The freedom of speech and expression, which is bedrock of journalism, is subjected to gross misuse. It must not be forgotten that only those who maintain restraint can exercise rights and freedom effectively. And one of the example where we can see the freedom of press interfering with the right to privacy is the recent case, Sushant Singh Rajput case, where he was a high-profile person, he was an actor. So the involvement of media was too much that many public interest litigation bill was filed in the court to keep the media in control. The actions on the media were very seriously violating one's right to privacy, as the media was exposing the late actor's personal life as well as the accused persons. And I would like to give one more example that the incident, in the grasp of the incident where an Indian Air Force official were captured by the Pakistan. Mr. Aravind Vartaman was captured by the Pakistan, and in that case he was a national hero. He was defending our country in our enemy's country, and but the time the media here was running behind his family. They were forcing the family who don't know if they'll get their family member back or not. The media was forcing them to be on spotlight and give interviews. So this is, we can say, is one such case scenario where the freedom of press is interfering with the right to privacy. And yeah, okay, thank you.
Thank you, Risha. I now call upon Ms. Darshana Suresh to take over.
A very good afternoon to one and all gathered here. I'm Darshana Suresh, student of 7th semester BBA LLB, and I'm here to present speak on the paper that I will be presenting, which is on the topic of right to privacy under Article 21. I will be dealing with the concept of right to privacy and how it has evolved over time, and what are the main loopholes which is still present in the legal system on the concept of right to privacy. So when you speak about right to privacy, you need to understand that it was derived from a Latin word which is privatus, and it essentially means isolated, or it means restricted. So it is a personal space of a person when we speak about privacy. So even in Blacklaw's dictionary, it is clearly quoted that privacy means right to be let alone. It means that the right of the person to be free from unwarranted publicity, unwarranted interference by people on matters where it does not involve any public interest. So when we speak about right to privacy, it is a very common thing where we mention about freedom of speech and expression, which is dealt under Article 19 of the Constitution. So when we speak about Article 19, we also know that there are certain reasonable restrictions which are present on that particular law, and that is when the term privacy comes into picture when you speak about the reasonable restrictions. So the right to privacy also, when we look at the international obligations, the UDHR 1948 in Article 12 and also the ICCPR in Article 17 gives protection to the concept of privacy. But back then, privacy it was not given any separate constitutional status in India, even though India was a part of many of the conventions and also the UN organizations. So now, in the case of Nihal Chand versus Bhagwan De, this was a very old case which happened during the colonial period, and even back then, the High Court, though in a minority view, the High Court had recognized the independent existence of privacy when it comes in from privacy from the customs and traditions which were practiced in India. But privacy was recognized in India in the case of Karak Singh, which was also mentioned by a lot of dignitaries who spoke here about the case of Karak Singh, where seizures by police officers just on the basis of suspicion was considered to be unconstitutional, and the court held that this is a violation of right to privacy of a person. And even in the case of Sharda Dharampal, the Supreme Court held that privacy is the state of being free from intrusion or disturbance in one's private life or affairs. So when we speak about privacy, it is always included in Article 21 of the Constitution, which speaks about right to life and personal liberty. So now coming to the Indian view, the courts have protected this right to privacy to some extent through their judgments, and it is done that under the Article 21 of the Constitution and under reasonable restrictions which are imposed in Article 19. So now when we speak about privacy under Article 21, as I said, Article 21 clearly gives protection to life and personal liberty, and though in different factual base, the Supreme Court had also recognized the right to privacy, and this was evidently found in the case of Karak Singh versus State of UP. And in this particular case, Justice Subbarao had held that the Article 21's concept of liberty also includes privacy. So now the courts have implicitly acknowledged the right to privacy through its various judgments it has delivered, as in the case of R. Rajgopal versus State of Tamil Nadu, where the court regarded privacy in two aspects. That is, firstly, as a tortious liability, which gives an action for damages for invasion of privacy, which is basically defamation. You are affecting the reputation of a person. And secondly, a right to be left alone, implicitly read into the right, the right of life and privacy under Article 21. Now, the most recent judgment, which is Justice K.S. Puttaswamy who had filed a petition regarding the Aadhaar card issue, where he said that it violated the right to privacy. This was the landmark recent judgment which has happened, where the Supreme Court unanimously ruled that the right of privacy is a fundamental right of a citizen of this country, which would be read with the right to life and personal liberty. If the judges may permit, I would request 1 minute to conclude my presentation. So, yeah, so privacy, as I said, it is not being recognized effectively and effectively in the legal system so far, and there are, you know, the resolutions which is being passed, it's all in the early stages. When you take the data protection regime and all, it is all in very early stages. So there is a need for the government to bring about very stringent and effective rules, laws, which will, you know, prevent and curb such violation against a citizen's right to privacy in the country. And at the same time, the government has also has to make sure that, you know, while making such law, they maintain the harmony between the citizens of the country and also maintain the interests of the public. With that, I conclude, and thank you very much. Thank you, sir.
Thank you, Darshana. I now call upon Ms. Srinidhi Joshi to take over.
Good afternoon to one and all present here. Good afternoon, judges. I am Srinidhi Joshi, studying 3rd semester BBA LLB in RV Institute of Legal Studies. Today I am here to present on a research paper that I have been working on, is that the reasonable restrictions on right to privacy, is it a shield for government tyranny? So, I would like to start by telling that the word privacy, or the phrase that we are using today, the right to privacy, is nowhere found in our constitution or any other statute or any other delegated legislation so far. Then how did right to privacy come into existence? Like, you've already heard so many presenters presenting on so many case laws, so I wouldn't be getting into the case laws right now, but I would like to mention the recent landmark judgment of Justice Case Puttaswamy versus Union of India that was passed in 2018. So it was a judgment by the 9-judge bench which stated that right to privacy falls under the criterion of Article 21, that is right to life. So a right to privacy can be considered as a fundamental right. This judgment clearly included right to privacy in our fundamental rights. But does that mean that any person who has right to privacy can do anything with their personal issue and the state cannot involve in it? Well, let us consider a few circumstances wherein first one is the beef consumption. So beef consumption is a personal choice. It falls under the criterion of privacy of having a personal choice. But how come beef consumption is banned or cow slaughter is banned? Similarly, section 377 that was taken out right before 2018 judgment, well, it was considered a criminal offense. How can it be considered a criminal offense if it is a matter of privacy or a personal choice? Similarly, triple talaq issue also, it is something related to a personal issue of a religion. Then how can the state intrude in it? Well, the answer for all the above questions is a no. Like every other fundamental right, the government has the power to impose restrictions which are reasonable in nature. Therefore, right to privacy is also a fundamental right, and hence it also has the limitation of having reasonable restrictions. Like one of the presenter already said, that there are 3 basic requirements of the reasonableness test to be approved for it being a reasonable restriction on the right to privacy. The first is that there should be an essential legislation for it, and the second is that it should fall under the criterion of Article 14, that it shouldn't violate any other kind of fundamental right, and the third is that it should be proportional, like it should be ongoing with the basic structure of the constitution. So there shouldn't be any damage to that. So these 3 requirements are important for a reasonable for a restriction restriction to be considered as reasonable. Well, but does that mean that government can impose any restrictions that can literally fall under the phrase called reasonable? Well, there has been no legislation or a statute regarding what reasonable can mean. There has been only case laws. One major issue I'm going to concentrate on where this reasonable restriction is being used as a shelter or as a shield by the government is the Arogya Setu app issue, that is the ongoing issue. So basically, most of you might know what Arogya Setu app is. The Indian government developed the Arogya Setu app for COVID-19 pandemic to track where the infected persons are. So the government made the main purpose of this was to prevent the spread of the virus. So the app traced one's location continuously and used Bluetooth technology for contact tracing. So it was so that if a person, if the Arogya Setu app gets to know that a person is infected, then his contact history of 30 days is directly given to the government authorities. Well, but these government authorities does not only include government authorities. The CEO of Digital India himself has told that this app was made in partnership with a private entity. Well, then what does that mean? Then all our data, all our information, all our demographic information is being transferred not only to the government but also to a private entity. Okay. So the basic motive they tell is that this app was made for COVID prevention or to stop the spread of COVID. There was ICMR database that was collecting all the patient information, including the location. So the app could have been made only for issuing the certificate or the vaccine registration. But why was it made like this? And also, if the judge permits, I will just take 1 minute.
It is up to you, but I will minus marks. Okay.
I would just like to conclude, sir. Yeah. So there has also been an instance wherein the court, while granting bail to a prisoner or the accused, what we tell, told him to install Arogya Setu app. So that is clear that government is taking our information from Arogya Setu app, wherein our personal details and demographic details are attached together. So they will exactly know where a person is. Almost similar to Aadhaar, but because Arogya Setu is not a very big consideration, it has not been made a very big case because it does not include maybe KYC or something. But yet Arogya Setu is a very big big motive of the government to, have a very big motive to, have control of whatever is happening in somebody's life. So they're taking away all the data. So yeah, it is true that during health emergency, the priority of the government should be public welfare under Article 47 of a constitution. But does that mean that Article 47 gives government the right to curb the privacy of a person? So no justification is given on that. Thank you.
Thank you, Srinidhi. I now call upon Mankala Surya Teja to take over. The next presenter, please be ready. It's Miss Navya.
Thank you, sir. Sabha Saraswati, Namaskara. From the morning being heard of the right to privacy till now, it made me reminded of the Lord Tennyson lines, a land of settled government, a land of just and old renown, where the freedom slowly broadened down from president to president. So, as Justice has spoken about in the morning, the right to privacy involves a lot of emotional matters, private space of an individual person, and so based on that, today my topic is right to privacy in the notion of intimacy. So, as speaking of the privacy cannot be defined, as we all know that, but the thing is, privacy changes from person to person, time to time, country to country, and also along with that, privacy is it's not a static, it's a dynamic law. Along with that, I would like to say that privacy has widened its jurisprudential scope all over individual, where it covered the 360 degrees of an individual person's life. It involves each and every aspect where it covers every matter what an individual does. So speaking of my topic is the intimacy. Imagine this room of a hologram wherein every matter of privacy has been let with one or the other topic. So let's take the part of the sacred presence of the bedroom. So taking the matters of the bedroom. For suppose, if a wife checking on the husband's personal belongings, will that amount to the infringement of the right to privacy? Yes. It held in the Zuleta versus a courts of appeal, where it has been clearly stated that the wife checking the personal belongings of the husband without his permission, although having an intention to check whether he is committing any offense, that still amounts to the infringement of the right to privacy. In that case, my question is, we have this old proverb saying that savare sulle heli vandu madve madodu. So in translates that you can tell 100 or 1,000 lies to make one to let one marriage happen. So don't you think the disclosure of the personal details with like the impotency or the sexual transmitted diseases or even the skin diseases like a psoriasis or the lichen planus or even the venereal diseases or something like that, if you disclose that matter with your spouse before the marriage, don't you think that leading to the cheating or the person is taking the defense of the right to privacy? My question is that you cannot take the person who is not explicitly expressing that disclosure to that person, that is amount to the infringement of the right to privacy, because he cannot take the defense of the right to privacy because it is risking other person's right to life, don't you think? Because marriage is not a small thing. It involves a lot of matters. It involves a person's people coming into the place and involving a lot of energy, money, investment, and a lot of things happen. So if such matter, just because you have taken your right to privacy that you don't want a disclosure, it is leading to a lot of chaos in the issues. So addressing of the statistics, till now there are 2,105 cases got the judgment over the impotency divorce cases in India till today from the time we got independence. Don't you think it is time during the pandemic, the statistics has been stated that 25 to 30% of the Indian divorce cases has been increased only on the specification of sexual insatisfaction or the any decision matter that was not disclosed by the spouse to the other person. So here my addressing is that the person has to disclose it. Yeah, bro, we know that we are supposed to give the details disclosure before the law, before marriage. We are supposed to tell to the other person. We already know it is already there. But the problem is with the implementation, because of our possessive jurisprudence of our country, with the insecurities of the society, with the false prestige of a family, we are taking that matter, we are not disclosing that matter to the other person, making that disclosure is not happening, leading to the right to privacy infringement. The person cannot take the defense of such right. And also, closing with my topic, I would like to tell this one thing, that is Welte versus Welte case in the Boston Law Review in the page number 1725, where it has clearly stated that right to privacy while having an impotency grounds for a divorce case, you cannot take such defense, although the evidence under 122 has been, like in law, it has been mentioned that you cannot take such defense. And at the time of the closing, my statement is, it's not the law that usually brings the change. It is an interpretation of law and also implementation of such law in our lives that brings a change. Thank you.
Thank you, Mankala. Now I call Navya on the stage. The next presenter would be Shreya Gupta. Please be ready.
Good afternoon, everyone present here. Navya. I'm going to talk about right to privacy under Article 21 and with that related conflicts. So in some countries, the right to privacy emerges by extension of the common law of breach of confidence, the right to liberty, freedom of expression or due process. In other countries, the right to privacy emerges as a religious value. The right to privacy is therefore not only a fundamental human right, but also a human right that supports other human rights and forms the basis of any democratic society. The Privacy Act of 1974 guarantees the right of individuals to be protected against an unwanted invasion of their privacy from the collection, maintenance, use and disclosure of personal information. It is intended to protect the individuals from an invasion of personal privacy through federal agency misuse.
Article 21 of the Constitution states that no person shall be deprived of his life or personal liberty except according to procedure established by law. After reading the Article 21, it has been interpreted that the term life includes all those aspects of life which go to make a man's life meaningful, complete and worth living. The right to life enshrined in Article 21 has been liberally interpreted so as to mean something more than mere survival and mere existence or animal existence. So right to privacy is also one such right. So is right to privacy an absolute right? No, it is not. Once an individual has been formally investigated or screened by a security agency, personal information is shared among security agencies for reasons of countering terrorism, and the right to privacy is almost automatically affected. The right to privacy may also come in conflict with several aspects of police investigations. Necroanalysis, brain mapping tests and polygraph tests lead to unjustified intrusion into one person's right to privacy. Necroanalysis constitutes a mental torture and thus violates the right to life under Article 21 as it deals with right to privacy. The Supreme Court has acknowledged the right to privacy by branding these tests to be unconstitutional and inhumane. The police are not supposed to stop you with a reason, and they cannot go looking through your pockets, bags, car, or anything elsewhere or of an individual has a reasonable expectation of privacy. Unfortunately, the police do not always follow these rules, often at the expense of a citizen's constitutional rights. However, if the police has violated your rights through an unlawful arrest, then they should not be able to benefit from breaking the law. In most cases, if the police did not go through the process of getting a valid search or warrant or arrest you, arrest a person with a probable cause, then the evidence gathered illegally cannot be used against you in the court. Police officers and law enforcement may also be tracking your phone, not through requesting a warrant to search your phone records, but from mimicking the phone cell towers. The first time this topic was ever raised was in the case of Kharak Singh versus State of UP, where the Supreme Court held that Regulations 236 of UP Police Regulations was unconstitutional as it clashed with Article 21 of the Constitution. Under Regulation 236 of the Police Regulation, the officials are authorized to put surveillance on the suspect through any of the below mentioned measures, that is, secretly picketing the house of the suspected accused or paying domiciliary visits to house at night. So it was held at the court that the right to privacy is a part of right to protection of life and personal liberty, and here the court had equated privacy to personal liberty. An individual suspected of wrongdoing may have no idea that they are being investigated. In fact, many individuals who are under investigation are completely innocent of any crime. Law enforcement or government investigation may go on for years before any arrest is made or charges are filed. During this time, officers and agents may be gathering information from surveillance, wiretaps, search warrants, or other evidence gathering methods to an unsuspecting innocent citizen. The problem with many privacy right violations is that an individual may be completely unaware that they are being watched, recorded, or followed. It may only come to light when someone is placed under arrest. The right to privacy on one hand and power of the state of search and seizure on the other hand has been subject matter of judgment not only in India but also in other countries as well. The Supreme Court referred to American case laws under the 4th Amendment to the US Constitution. The Supreme Court has also referred to Universal Declaration of Human Rights, European Conventions of Human Rights, other treaties and constitutional provisions, and held that the state cannot have unreal right of search and seizure. So in the absence of clear guidelines, the police must be wary of human rights violations while carrying out investigations. Regardless of whether the police is under great pressure to carry out effective investigations, violation of right to privacy could cause them a much need of conviction. That's my time. Thank you very much.
Thank you, Navya. I now call upon Shreya Gupta. The next presenter would be Ms. Nidhi. Please be ready.
Good afternoon, respected sirs, madams, and my dear friends. I, Shreya, from 3rd year BBLLB, is here to talk about right to privacy under Article 21 and related conflicts. Right to privacy, it is an essential life ingredient and an emotion that a human being unconsciously possesses. A very fascinating development in the Indian constitutional jurisprudence is the extended dimension given to the Article 21 by Supreme Court of India. Today, I'll be focusing mainly on 3 topics, which is very relatable in our day-to-day life where we expect privacy should be provided. The legal genesis of this word was first coined in Kharak Singh case, which has been elaborately discussed by my friends. Since last decade, there has been significant development in the field of law under the pretext of right to privacy. Recently, a swirling wave came back in 2017 in K.S. Puttaswamy case, where the center's move was challenged, that was to make Aadhaar mandatory for availing the benefits of various social welfare schemes. The Supreme Court ruled that right to privacy is an intrinsic part of right to life and personal liberty under Article 21, and the center cannot make such compulsions and hence struck down the center's proposition. Right to privacy comes into picture only in places where we want privacy and it is not there. I shall be giving you few daily life examples. In shopping places, whenever we purchase something, we are asked to provide the phone numbers to issue bills, which is an infringement of our privacy. What if I don't feel okay with sharing my numbers to a third person? They deem it compulsory, saying that they won't issue bills if we don't give our phone numbers to them, leaving no choice for us to deny. In such intricate situations, we often focus on our purchased goods and neglect our right to privacy, and it becomes oblivious of what they are doing with one phone numbers once we leave that place. Often, the phone numbers are utilized by different businesses like government, medical services, retails, schooling and accounting. Our numbers are forwarded further without our knowledge. As Sir mentioned, we should apply right to be forgotten principle here, which says as soon as a work is accomplished or the purpose is fulfilled for the data provided, it should be deleted or removed from there. In the recent time, there is a lot of talk in the judicial arena about criminalizing marital rape. The contents of marriage is a matter of great privacy. Now, if this proposition is criminalized, we as a civilized society will fail immensely in striking an equilibrium between right to privacy and rights of a married woman. The only distinction between an act of rape and a consensual sex is of consent. Now, between married couples, the determination of consent happens inside four walls. If that matter is brought to the cognizance of the police alleging rape, it will be harboring right to privacy. Next area where there is a gross aberration of privacy is happening is on social media. Unfortunately, social media happens to be an inevitable aspect in our daily lives. The amount of digitalization we have brought in our lives from past a decade, it becomes important to set limits to it. With the extension of the web and virtual web, protection has become hallucination. With incredible opportunity comes extraordinary duty. The interest in incessantly tracking over browsing history, which is snatching our privacy away. Often web portals like YouTube, Instagram or Facebook suggest us to follow, like or share certain posts based on our previous watched videos. Social media has become a menace in our life. It has brought in complexities. The urge to post our daily activities is leaving us disastrous end and ultimately infringing our privacy. Right to privacy, once incorporated as a fundamental right, is wide enough to encroach into any sphere of activity. The conferment of such a right has become extremely difficult with the advancement of technology and the social networking sites. I would like to conclude by saying to what extent our private data can be used for public purposes. Can it be regulated? Are there exceptions? If so, under what circumstances? Are the legalities and the interpretations of constitutions known to the common people for their sake to protect their privacy? Thank you.
Thank you, Shreya. I now call upon Ms. Nidhi. The next presenter would be Krishna Kashyap. Please be ready.
So good afternoon, everyone. I'm Nidhi, first year LLB from BMS Law College. So today I'm going to talk about freedom of press and right to privacy. So how many of you are aware that today there is a movie getting released, that is Radhe Shyam? Can you raise your hands? Oh, great. And how many of you are aware that there is also one more movie that has gone released today, that is Kashmir Files? Can you raise your hand? Fine, good. Because I had a talk with one of my classmates, many of my classmates, not one. So many of them were not aware of this Kashmir files, okay. Why? Because the media didn't cover it, okay. That is what is happening nowadays. So to tell you, the freedom of media is unlimited there is no body which is governing the medias, but there is only one, that is the new broadcasting authority that is actually controlling the medias. But as far as we are seeing, the media has not got no limits. They can speak whatever they want, they can interrupt into anybody's life, anybody's privacy, and they can, make news according to their will and wish. But our liberty depends on the freedom of the press, and that cannot be limited without being, lost. That is what it is always said, according to some great scholar. And media is also known as one of the fourth pillar of the Constitution of India. And Article 19, Subclass 1, Subclass A states that freedom of speech and expression. And media always takes this section as a cover for them, as a shield for them. But also, to look at the positive side, it has the media work is a crucial work, and they always do the work of a watchdog. And don't you people think that media interfere too much in the cases where they give a different turn? So there is one such example of Arushi and Hemraj murder case, if you are aware of it. So unnecessarily, until and unless there was things proven, the media themselves stated that there were many names which came in the list of murder list, so they might be the accused, and they also stated that Arushi, she had an affair with the household worker. All these issues came before the judiciary actually gave the judgment. This actually was a defamation. If she was alive, in spite of her dismissal, that was also a defamation, because there was nothing such happened between that Arushi and a worker. That is also like infringement of a image that she is having affair or something like that. And after that, we also have the Sushant Singh Rajput case, as one of the speaker told, that there was too much of media involvement, and there were many actress name which was taken, that he was blackmailed by them, he committed suicide because of them like that. But that was not the case. And you obviously know the Puneet Rajkumar sir, who passed away. And there was also issue that the people were ready to file case against the doctor, the family doctor of Puneet Rajkumar, who initially treated. This all happened because of media. They should limit themselves before they give the facts to the public, because that is always said that the Supreme Court in one of the judgment has stated that no doubt it would be the mischievous of the newspaper to systematically conduct the independent investigation. They can conduct it, but they shouldn't give any decision before the Honorable Supreme Court or the Honorable Courts of the India give any decisions. And even in D.K. Ravi's case, we saw that the media themselves declared that because of their personal issues, because of some work pressure, he committed suicide. Till the CBI, they couldn't stop themselves. And obviously for the youngsters like us, it will might be, yes. So the media should actually give some importance for the right to privacy of an individual, and they have to be controlled in a broader sense. But this new broadcasting authority only wants such newspapers or the press people, and they are fined for only 1 lakh. That is the only thing that is happening. So that's all what I wanted to convey. And we being youngsters, being law students, have to go through the facts of the case or some issues, not just believing the facts that the press or the media states as they want. Thank you.
Thank you, Nidhi. I call upon Krishna Kashyap to take over. The last presenter would be Megha Jain. Please be ready.
Very good afternoon to the distinguished judges, faculty of RVILS, and all my fellow audience present here. I'm going to be talking a brief summary about analysis on data protection and privacy. So the topics that I'm going to be covering is how your data is being violated, how your privacy is being violated, and how it's being misused. 1. 2, about the remedies, what are available to us, and 3, about the current laws that we have across the world and particularly in India too. So we have come to a modern age where in the past 3 decades we have seen a lot of technological advancements. So in the past 30 years we have seen maybe from a normal phone, a cordless phone, to a cell phone device or a smartwatch that we all have. So every single movement that we walk across is being tracked. It's being tracked, it's being monitored, your data is being enumerated, and it's being interpreted and used for different things. So I'm sure everybody, how many of you have watched The Office? Yes, thank you. So identity theft is not a joke, Jim, says Dwight, but then he tries to impersonate everybody over there. So, and also, Dwight also takes in a lot of phone calls. So he makes phone calls on behalf of others, and then he tries to, impersonate them. So I'm pretty sure every single one of us present here have an Android phone or an Apple phone. So at least in Apple, in the Apple ecosystem, you get to choose where you give your consent. Not completely. May I remind you that once you, on any phone for that matter, when you're trying to download a software, you want a software upgrade your phone. So let's say there's iOS 16 that's going to come. You're going to have to press the I agree. We all agree to it. So we are giving our consent, so there's no option of I disagree. So you're being so vulnerable here that it leaves no choice if you don't agree to it, right? So you don't want a phone of 70,000 or 80,000 that you've paid to become a brick. Nobody wants that. So there's that, and there's also this case that I was recently going through from the U.S. Courts, which said the husband found out that the wife was having an affair, that she was being adulterous through her Fitbit app. So he was legally entitled to check her records on the shared phone. So he did not violate her privacy, but there was also a thing where he could see that at 2 a.m., particularly, she wakes up, goes for a run to somebody's house, and then drains about 300 calories, which is odd at 2 a.m., right? So there's that. Yeah. Nobody burns 300 calories at 2 a.m. Right. And we also have this Snapchat streaks that we keep on doing. Like, I saw so many of us at lunch break today. Not only at lunch break, throughout my student career. Thankfully, I do not have a Snapchat account. But I see a lot of my friends going on streak. Let you not end the streak. So you're completely doing the streak. So there, you're letting yourself to be vulnerable. You're letting every single person. Companies like Cambridge Analytica can influence politics. There are so many companies that are breaching the right of privacy over here. So is your mom. She can see what you're doing, but she doesn't have any eyes. She doesn't have cameras, but she knows what you're doing. So your privacy is being breached everywhere, may it be your home, may it be on your phone, may it be on your school, may it be on your laptop. Every single place, our privacy is being breached. So what are the remedies? What can we do? We are at a very vulnerable state right now because it's a very new concept to us. It's developed very recently that because of this technological advancement, we are not at that level, but I'm sure that we can incorporate a lot of laws that focuses on consent and the trusted sources, and the onus is on the person, the company that's collecting your data. The onus is on them to collect and protect your data. So I'd like to conclude with that. Thank you so much for your time. Krishna here.
Thank you, Krishna. I would now like to call upon Megha Jain.
Hi, good afternoon everyone. I'm Megha from BMS College of Law. I'm a first semester student pursuing 3 years LLB. A very good afternoon to the audience, to the honorable judges and all the teachers and faculty members of RV College present here. Mine being the last presentation, I'm sure by now you guys have gone continuously hearing the words privacy, data protection, Constitution, Article 21. But guys, no, my presentation is not about that. I will not talk about the Constitution. I will not give you case laws. But I would like to give you a worldwide view. Okay, so let me start off by asking, how many of you all here know what is the present state of the Data Protection Bill in India? Do you know what's happening around that? Has the bill been passed? Has it become an act? Or has it been enacted? Anybody, anything? Not yet. Okay, why? It is still under consideration. Yes, it is still under consideration, but what consideration is going on? The initial bill, the bill when it started, it took 1 year. They did, consultations with all the stakeholders across the country for 1 year, and then the draft was proposed. So why do you think it's gone back for consideration? I will tell you that. So my topic is analysis of the trends global trends in data protection, which is happening right now. So before that, I will be just giving you a brief about my presentation. I will first briefly touch upon the concept of data privacy in India, and then we will discuss what is happening in the global arena. And then lastly, due to paucity of time, I will briefly touch upon five countries which have recently, overhauled their data protection laws, or they've brought in a new data protection law. Firstly, talking about India, as some of you already told, the bill has not been enacted. All right, so the bill did not enact because the government wanted, more consideration, more consultations to happen. And also, India wanted its protection bill largely to be in line with the General Data Protection Regulation, that is popularly known as the GDPR. I will discuss what the GDPR is in a couple of minutes from here. But before that, let me tell you, did you know that the India as a nation, we as its people, we are not alien to the concept of privacy. Okay, here a lot of my co-speakers told about, the privacy between a husband and wife within the four walls of house. I don't know how many of you all know here, but the concept of privacy finds its roots back in the ancient text of Hitopadesha. Hitopadesha is a very famous ancient text wherein they talk explicitly about privacy. They say that there are certain matters pertaining to, your rights, whom you worship, the religion that you want to follow, and also the physical relationship of a man and woman that should be private. So, privacy as a concept has been prevalent in India from times immemorial, even before we knew it. All right. Now, moving on to the data privacy trends across the globe. Now, we know that, especially in the last 2 years, thanks to, the COVID pandemic, the buzzword has been data protection, data privacy. It could as well, go on to become the word of the year, barring, of course, COVID and pandemic. And there's a reason to it, because we were all confined to the four walls of our house. What did we have? We did not have anything. We did not have the freedom to, move around. We were confined to four walls of our homes, our laptops, our mobiles and other electronic gadgets, and our family members only. So anything and everything we consumed was from the internet, and there were agencies like Cambridge Analytica who were right there to, take all the data. We kept feeding in our data, whether, it was in the form of putting in our health data in the Arogya Setu app, or, downloading new social media apps. We kept on feeding data to those companies, and then they kept taking data from us. Now, talking about the data trends across the globe, one is the increasing influence of GDPR in the globe. Okay, now GDPR, it is the General Data Protection Regulation, which was commissioned in the year 2012, and finally it came into enactment on 2018. Now, the crux of that GDPR is that they give the people, the end user, a complete free consent policy. If today you want my data, and if I do not consent to the data, you cannot take it. If you take it, you put yourself on the risk of, paying heavy penalties, and these penalties run into millions of dollars, million of euros. Then the second most prominent trend is disinformation. We know that there is so much disinformation happening around it, and to curb these disinformation, again, stringent laws and regulations have been put in check. Then the third most important aspect, employee relationship or employee monitoring. Because, we were all working, there was an environment of work from home. Employers became, very insecure, whether, people are working or not, or, are they being 100% productive. And also, if they are actually working, or they've just put a picture and then they are resting behind. We know that. We've seen so many videos around that. It was true. So companies started monitoring more people, and they came up with weird policies. So here also, again, data protection laws of many companies, many countries, they put in stringent checks. They said that if you go ahead doing this, we will impose heavy penalties. Then a new area of work came in. Two new professional areas of work came in. One is, people started having a chief privacy officer in companies. A lot of companies, a lot of tech giants in the West, they have a new role. It is called the chief data privacy officer, wherein you have a grievance, you go to him and you tell, listen, I feel, the company is invading my privacy. I do not want that. So literally, you have a grievance cell which only takes care of your privacy concerns, wherein if your privacy is being infringed by the company. Then second, the most important professional area where, data privacy is coming into picture is your data protection as a service. Now we've heard of software as a service, we've heard of a lot of things as a service, but data protection. And let me tell you one fact, there was a market research conducted by, with regard to data protection as a service, which said that, this market is expected to grow by $18.96 billion by 2026. That means in 4 years, we will see a new area of market which will be as big as $18.96 billion. Can you imagine how much is it in Indian rupees? I would want someone to do the math and let me know. And now I will just conclude. It's okay, sir. That's all right. I'm still there. Okay. I know my time is up, but then there are certain interesting laws around the world. I would just pick two and tell you. One is, the recent Protection of Personal Information Act passed by the South African government. It is popularly called as the POPIA Act. Now, this law is so strict that other laws around the world, all the laws around the world, in fact, they only give a penalty in the form of, a compensation. You just have to compensate. If there's a data breach happening, you just compensate and get away with it. But then the South African law is so strict that, they are charging the person, they're pressing criminal charges on the person or the company who violates your data privacy, who violates your data protection. Then even a country like China, an ironclad economy like China, even they are taking active steps in data protection, and they are also following the GDPR guidelines. And they've made it so stringent that if anyone is found invading the privacy, whether in China or outside China, the penalty is so strict that they may have to spend 50 lakh Chinese yen, which is equal to about 6 million euros, or the company will have to give up 5% of its gross annual turnover. So you can imagine it's not even 5% of the profits, but it is 5% of the annual turnover. Thank you.
You have to maintain the time. Okay. No arguments, no further arguments. You have to move.
Thank you, Megha. I thank all the presenters for your active participation. Now I request Dr. N. Satish Gowda sir to give his inputs on right to privacy. Sir, please.
Good afternoon to one and all. Respected teacher, professor, my mentor, Professor C.S. Patil sir, and Professor Jagdish sir, and Revanna Vadaya sir from Kilpar, and particularly the principal of this esteemed institution, Dr. Anjan Reddy sir, and all teaching faculty members and students from different institutions. It gives me an immense pleasure to be part in this a very meaningful seminar organized by RV Institute of Legal Studies in association with Kilpar. Of course, after listening the inaugural session and technical sessions and paper presentation sessions, I was thinking I think if this is the case, judiciary may evolve one more important unenumerated right called right not to be listened. So I think, again, I don't want to violate your right to patience. In fact, already Professor C.S. Patil sir is an authority, and even Honorable Mr. Justice Ramohan Reddy sir also spoken well. In fact, through somebody I heard. Then Jagdish sir also delivered a wonderful presentation on right to privacy. But I have few remarks and observation about the presentation what you have made. In fact, we have heard almost 12 presentations. It was a really learning process for me. See, getting award is here effective participation. Participating in the conference itself is a great moment for all of us. Winning and losing is immaterial. The material part is here to say our own views with some confidence and through having traits of providing detailed information through your effective communication skills. What I have observed, of course, all have presented well. That too, some of the students who are from first year, they have made a very good presentations. Of course, in fact, they have not come to even to study some law subjects. Nevertheless, they have made a wonderful attempt. But my message to all the paper presenters, before you come here, please be specific about your topic. Some of you have not mentioned your title also, number one. Number two, try to ensure discipline within given time. You should think what need to be presented, what need not to be presented, to be and not to be presented. That is the art, that is the skill. Within 5-6 minutes, of course, some of you already you have prepared the MP Sharma's case, then Karak Singh's case, then Govinda's case, then Rajgopal case, and finally all they are coming to discuss about the Puttaswamy's case. In fact, yesterday when we met with Professor C.S. Patil sir, I think Puttaswamy passed away because nobody has read detailed judgment of because all we speak about right to privacy was evolved in the case of Puttaswamy. What is the contents? One must read how judges have given their own analysis and observation. That too, 9 judge benches, constitution benches, unanimously they said right to privacy is an implied fundamental right. Of course, no fundamental right, especially under Indian constitution, in the absolute nature. They are considered as a qualified rights. Comparatively, American Constitution and Indian Constitution, if you go there, in fact, there were no Bill of Rights in the original Constitution. They were incorporated after commencement of the Constitution 1791, somehow 4th Amendment recognized, where they recognize all rights without mentioning any reasonable restrictions. But in India, we have a reasonable restrictions. Of course, some of you were addressing a very good topic like right to privacy and freedom of press, right to privacy under 21, and reasonable restrictions. When it comes to reasonable restrictions, I just gone through some of the issues relating to right to privacy through some important source, where I came to know there are 2 types of privacy. One is physical and digital privacy. Physical privacy and digital privacy. Of course, we do not have any comprehensive legislation to because why some of last speaker she was telling it is under consideration. In fact, in 2017, Sri B.K. Honorable Justice B.K. Sri Krishna under his, they appointed Sri Krishna committee to look into all these things and all, and they submitted a report. As a result, they started preparing this bill. Still it is under consideration. But we need a specific and comprehensive legislation to deal all digital and physical privacy related issues. And when it comes to reasonable restrictions concern, of course, before that I want to tell one thing. Right to privacy is a costly in the sense it is for, I say, elite people. Somewhere, wherever I go, I argue fundamental rights except reservation, they are not available to the vulnerable sections. They are available only to elite classes. The rights are available to the vulnerables, are there in the direct principle of state policy. Unfortunately, they are not enforced before the court of law. Even we do not make any attempt to pressurize the state government to, state or central government to implement direct principle of state policy. I always make fun. Before contesting election for MP or MLA, we have to ask them, do you know the direct principle of state policy? Similarly, for media, when it comes to right to privacy, we have to teach them what actually right to privacy and what are the reasonable restrictions. Because I didn't see Supreme Court, Constitutional Court, suo moto, they have taken so many cognizance and evolved so many employed unenumerated fundamental right, where it is pertinent to remember one of the important quote made by the Justice P.N. Bhagavati. He says, judge infuses life and blood into the dry skeleton provided by the legislature and create living organism appropriate and adequate to meet the needs of the society. Judiciary has been playing a wonderful role, but when it comes to the preparing a regulation in the form of guidelines to the media, of course I didn't see even the central government or state government, no government have not come forward to impose at least reasonable restriction. They must even it is not an express right, right? Freedom of press is not an express right. It is an implied right. Nevertheless, they are not following the 19 clause 2 in the sense, it is very unfortunate. In this regard, judiciary also have not shown any interest to issue direction in the form of guidelines to the press, what need to be telecasted, what need not to be seen. In fact, Solisara, still I just watched in YouTube where there was a discussion with a fellow from the Times now, I think. He was telling, who hell you are, who hell you are. Are you a competent court of law? Are you a competent court? How do you telecast? Don't you know about limitation? Forget about limitation. What about right to privacy? They will die after watching your news. So there are so many issues involved. It is digital, of course, especially even right to privacy. I was just remembering, husbands should have dareness to hand over his mobile to his wife, especially without. Of course, I don't put it in. I don't have anyone can access. So in the sense, I'm free because many I have gone through some advertise also. He never, of course, he tries to put his finger or toe something just to know what contents are there in the mobile also. That also come under the purview of right to privacy. Of course, there are many issues when it comes to other. Putswami's case, of course, 9 judges benches, they have decided. Of course, when it comes to comparative analysis, if you go to European Union or in even US perspective also, they use other details and all only for the government schemes. Government schemes, that they are very much required. But here they say you have to enter your Aadhaar card to all bank account, IT, and wherever we go, even for admission. I don't know for what purpose. Again, that has to be addressed properly because I can't trust state whether they are going to protect my data and all. So again, it is an issue. That's why it is under consideration. It is under consideration in the sense how long it will be under consideration, we don't know. But whatever it may be, it is a need of our to pass a specific comprehensive legislation on private issues related subject matter concern. And one more message for the speakers: whenever you want to present on any issues, please be specific and your communication should be very effective. One of the paper presenters, he was just presenting well, but he was slow. He was so slow in the sense he should know the timings. Of course, the contents was very good, but it should be finished within given time. Time matters, communication matters, application of mind matters, and very important, substance and contents in your presentation matters. And finally, to make you all comfortable, artistic approach matters. Sometimes you should make fun, because otherwise, right not to be listened. Concept should be evolved. So, of course, leaving all participation in a national level, like a conference like this, it's an opportunity. In fact, it was a learning process for us. Of course, we have read something about right to privacy under Article 21. But I was, with curiosity, I was just listening what any paper presenter may say something which is unknown to me. So, one should listen, one should learn. There is a famous saying by Sarvagna, he says, Sarvagna nembavanu garvadindadavane sarvarulu beretu ondondu nudi kalitu vidya meru parvatada Sarvagna. So, one should always be humble, and you should be, that's what I was telling you people. It is very easy to comment, and it is very easy to just chat and converse. But if you come and stand here, then you will come to know the responsibility. So, in fact, it was a wonderful opportunity for me to learn different aspects relating to right to privacy through your paper presentation. And once again, I thank the organizer for giving me an opportunity to chair this wonderful session. Thank you one and all. Thank you.
Sir will talk. Thank you, sir, for sharing such remarkable thoughts. Yes. I request Professor Dr. C.S. Patil sir and Dr. Jagdish sir to come on the dais, and even Dr. Anjana Reddy sir to come over the dais.
ಇಲ್ಲ
Participation stands to be important part irrespective of winning. The most awaited time is here. Do you all want to know who has won the prizes? Yes. The third prize is shared between two participants. It goes to Megha Jain and Nidhi from BMS College of Law. I request Nidhi and Megha to come over the dais.
Come, both of you come. Certificates. Yeah. Cash prize also you cut. Don't discuss 500 rupees note. Change it. Come. Come, Megha. You can take. Yeah. Come.
To Ms. Darshana Suresh. I request Jagdish sir to give away the prize. I request Dr. C.S. Patil sir to give away the prize. Thank you. Congratulations to all the winners and participants. I now call upon Ms. Bhavna C., Assistant Professor of Law, RV Institute of Legal Studies, to propose the vote of thanks.
A very good afternoon. Honorable dignitaries, distinguished guests, respected Principal Sir and dear participants. On behalf of Karnataka Institute for Law and Parliamentary Reforms and RV Institute of Legal Studies, its entire fraternity and organizing committee, I feel immense pleasure to take this opportunity to propose the vote of thanks to our chairperson, Dr. Satish Gowda, sir, Associate Professor of University Law College, Bangalore University, for chairing the session in spite of his busy schedule and sharing his insights about the concept of privacy. I would request Dr. Revaya Odia, sir, to honor the guests. Thank you, sir. I would further extend a hearty thanks to Mr. Dwarkanath Babu, sir, for selecting RVILS as a destination for conducting this workshop. He's not here, but a very gratitude. Seriously, it's a privilege that he chose our institution for conducting this workshop. Thank you, sir. I extend my gratitude to Dr. Revaya Odiyar for his coordination in organizing this workshop. So I request our principal, sir, to do the honors. Thank you, sir. I also thank Professor Dr. C.S. Patil, sir, and Professor G.S. Jagdish, sir, for gracing this session. I would specially thank our management for their constant support in organizing such activities. I also thank our respected beloved principal, Dr. Anjana Reddy Kehar, for his unfaltering support. I congratulate all the winners of this paper presentation, and as well as a congratulations for all the presenters from other institutions as well as from RVLS. My deep sense of appreciation and thanks to all our participants who chose to be with us and attended the session with great enthusiasm and made it a successful event. My sincere gratitude also goes to the organizing committee for taking this topic that really matters in today's age and time. I also thank the media friends. But last but not the least, I thank all my fellow faculties, administrative staff, student coordinators, volunteers, and all my dear students for the contribution in making this event a success. Thank you. Have a good day.
Thank you. Thank you, all of you. And please collect your certificates and more. Thank you.
A small announcement. I request everyone to kindly fill in the feedback form and then collect your participation certificates. Yeah. I request the audience to raise for the national anthem.
Janmana Adhinayaka Jaya He Bharata Bhagya Vidata Punjab Sindh Gujarat Maratha Dravida Utkala Vanga Vindhya Himachala Yamuna Ganga Uchchala Jaladi Taranga Tava Shubha Name Jage Tava Shubha Ashish Mage Gahe Tava Jaya Gatha Janagana Mangaladayaka Jaya He Bharata Bhagya Vidata Jaya He Jaya He Jaya He Jaya 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 He